Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazier, people represented by Mr. Darden and Ms. Clark. Jury is not present. The record should reflect that this morning I had a chambers conference with counsel to discuss a questionnaire that will go to the jurors this afternoon, inquiring of them if they are desirous of extending the hours of deliberation into a later session during the evening hours, and whether or not they are desirous or willing to deliberate on Saturdays, with the understanding that any deliberations must be conducted here at the courthouse and in the jury deliberation room. We also discussed, counsel had no objection to the questionnaire proposed by the court. Also, the record should reflect that the court has directed counsel to be available on a 1 hour's call for the purposes of responding to questions by the jury and also requests for readback. And the court has indicated also that a longer time period to be available for the purposes of rendering a verdict will probably be in place, but we'll discuss that when the time comes. All right, anything else we need to discuss put on the record before we conclude with Mr. Darden's argument? Sure. All right, Deputy Trier. Yes, Mr. Scheck, good morning.
Good morning. I just wanted to register for the record certain objections. One in particular to Ms. Clark's argument, and get some determination from the court on this issue. At one point in her argument, she began making references to the defendants not performing tests on evidence, and started making comments about experts for the defense who never appeared in court or testified, and what they did or didn't do. In particular, the comment that concerned me the most was in reference to EDTA testing. It's one thing to say that Dr. Reeders didn't perform a test using the MSMS machine, because that certainly came out and was an impeachment in the testimony. But what concerned me was a reference, well, the defense had other experts and they didn't come in and give you test results or anything to that effect. And that seems to me improper because, first of all, it's commenting on a privileged area. I think that's 913. And secondly, I think we've already had some litigation on this issue where the court actually made a finding that the conduct of the prosecution in terms of trying to find out what, if anything, defense experts were doing in this area was, in the court's words, reprehensible. So it seems to me that comment on what other experts could have done with respect to their testing or did do or anything like that would be improper, although I have no objection to her making comments about Dr. Reeders. I thought that, and I'd like some kind of guidance from the court on that issue.
Ms. Clark?
I don't know what to say, Judge. I pointed out to the jury what's in the record. I pointed out the truth. And I think I was very specific about the people they called and they didn't call. What I pointed out, to the best of my recollection, is that they called Dr. Reeders to testify about someone else's tests. He performed none. He could have. I talked about Dr. Gerdes, and I talked about Dr. Lee, and I talked about Dr. Blake. This is all in the record. I don't recall. I did not refer to other experts that were unnamed or that did not come into the record. I talked about the ones that were in the record, and that's why they didn't perform any tests. So I don't know what the complaint is.
All right, Mr. Scheck, do you want to, are there any case citations? Because primarily during the course of argument, prosecution counsel are entitled to comment upon the state of the evidence and the failure to call logical and material witnesses. And that's People versus Miller, 50 Cal 3rd at 9:54. The court's comments at 9:96.
No, it sounds like from her comments, I heard something different, and if Ms. Clark doesn't believe she said that, or certainly isn't going to make that argument on a rebuttal, then I guess we don't have a quarrel.
Okay.
It seems to me, though, that just to make my point very, very clear, it's one thing to comment on Dr. Reeder's and what tests he did or did not perform under the circumstances. I distinctly heard her say the defense has other experts that could have done that test. And that, I think, is beyond the Miller case and beyond proper comment on the record, and it appears that Ms. Clark agrees.
Has to
So
be based on
perhaps
something based in the record, correct?
right. So it appears as though there's no disagreement here. But I'm very concerned because of.
Let's do this. Let's have our computer maven, Mr. Blazier, see if he can find the appropriate comment, and at the next recess, we'll take it up if you feel it's something that's appropriate.
Your Honor, I'll tell you what.
No, we just settled it.
Well, no, because in case, I don't know, we can't all remember what we say over the period of hours, but I will say this. Any reference to other experts would have been they could have brought someone in, not they had someone available. But assuming, what if that's the case? Don't do it? Wait. Okay,
Discussion's over.
all right.
All right, thank you. Deputy Trier, let's have the jurors, please. Ladies and gentlemen, please be seated. And let the record reflect that we've now been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. And Mr. Darden, are you prepared to continue on with your argument, sir?
Yes, I am, Your Honor. Thank you.
Right.
Good morning, sir. Good morning, ladies and gentlemen. I hope everybody,
Would you just briefly show that to counsel?
if you can, I hope everybody had a
Thank
good
you.
sleep last night. It was a long day yesterday. And I thank you. Let me thank you in advance for hearing me again this morning. I don't expect to take up the entire morning. In fact, with any luck, I won't take up more than half of it. But we'll have to see. Well, you recall where we left off yesterday. I was telling you about this defendant's relationship, this man's relationship with Nicole Brown. And I told you that it was a simmering relationship. You know, it was a slow burn. It was a slow burn. And I described for you and discussed with you some of the testimony that you heard in this case, testimony you heard from witnesses about their relationship. And we talked about the 1985 incident involving the baseball bat and the Mercedes-Benz. We talked about the 1989 incident and the fact that the police have been there 8 times before. Both the defendant here and Nicole Brown both admitted that, so I guess it's true, right? We talked about the incident at the Red Onion when the defendant grabbed Nicole by the crotch and in front of a bar full of strangers and humiliated her. We talked about that. We talked about his admission to Ship, about his jealousy after the 1989 incident. We never talked about the testimony we heard from Denise Brown. Do you remember the testimony from Denise Brown when she talked about some of the really, really nasty things he would say to Nicole? As you may recall, Denise Brown, Nicole's sister, testified that during the time that she was pregnant, the defendant would call her names. Do you recall that testimony? He'd call her a fat pig. And he would call her a fat pig in front of other people. Now, I don't know what you should extract from that. I mean, have you ever heard of such a thing? I don't know. I would suggest, however, that is some indication of how he really felt about her. You know, sometimes you get in a relationship, people get in a relationship, you know, and you have one half of the relationship who's dominant, and you have another half who's somewhat passive, and the dominant half dominates the other half. And what effect do you suppose this would have on Nicole? That is, being called a fat pig by her husband while she's pregnant. What effect would that have on her self-esteem? Because you're probably wondering, well, hey, if he did all of these things to her, if he said all of these things to her, why did she stay? Well, there's this old song, and the words used to go I think it was the Dramatics. I can't really recall. But there was a couple of lines in the song where they said, the strong give up and move on, and the weak give up and stay. You know, if you badger a person long enough, if you beat them down long enough, if you wear them down long enough, pretty soon you strip them of their dignity, their self-esteem, and they are weak, and they are submissive, and they can't go. They can't stay. And you know how that is. Everybody knows how that is. We've all been in bad relationships before. You have friends. You see them in these bad relationships. Why? Why do they stay? Why do they stay? Usually they feel they don't have a choice. They don't know that they have a choice. They forgot that they had a choice. In their minds, they have no choice. She's a fat pig. But we talked about that yesterday, and we talked about justice, and we talked about what the real issue in this case was about, and I pointed the defendant out to you, and I told you he killed her, and you've heard the evidence in this case. He killed Ron Goldman. O.J. Simpson's a murderer. That's what the evidence indicates. That is what the evidence indicates. That is what the evidence shows. It shows that he's not just a murderer, but he's a double murderer. And that's unfortunate. It's unfortunate that I have to stand here and tell you this, because I'd rather be somewhere else. I'm sure you'd rather be somewhere else. Who wants to really have to confront and deal with these issues? But we have to, because we have a duty. Marcia and I have a duty, and you have a duty as well. Your duty is to look at all the evidence, to be fair, be conscientious, be objective. And your duty is to look at all the evidence, the totality of circumstances, everything. We don't want you to just look at one piece. Don't just look at the prosecution's case. Look at the entire case. Look at everything. Because when you do, hey, what can you say? Except he did it. And we've proven it. And we've proven it beyond a reasonable doubt. And we talked about the safe deposit box yesterday, and we talked about the fact that Nicole knew that she was going to die, and we know that she knew that because she told the police that in 1989. And we know that she knew that because of what she saved for us, the roadmap she left for you in that safe deposit box. The letters, the photographs, the will. You recall that testimony. And as we went through the progression here, through the history of his abuse of Nicole, and by the way, not every incident here on this chart is an incident necessarily of abuse. But we wanted to lay out the history of their relationship as well. And so that's why you see things like divorce, and et cetera. So we're not trying to mislead you. But we thought it was important that you know how the relationship developed over the years. And this is an unusual relationship. You have to agree. There's something wrong here. Henry Lee said there was something wrong. There's something very wrong here. This is a slow-burning, simmering relationship, and it's just like I told you yesterday, the fuse is burning. The fuse is burning, folks, and it's getting shorter, and it's getting shorter, and it's just getting shorter. But this morning, I want to take things a step further, if I may, if you'll allow me to. Let's just cut right to the chase. Imagine a defendant in his Bronco. He is full of anger and he is full of rage, and it's nighttime. And he's driving that Bronco, and he is full of jealousy. And the fuse continues to burn. And the focus of his anger is Nicole. For some reason, in his mind, she has done something that he can't ignore, something that has set him off. He's jealous, he's raging, he's out of control, and he's in that Bronco, and he is driving as fast as he can toward Nicole's house. And it's about 10 o'clock. He is out of control, folks. He is completely out of control, and when he gets to Nicole's place, he quickly parks the Bronco and he gets out. It's 10 o'clock. He's in his Bronco. He's at Nicole's house. It's nighttime. But we're not even talking about June 12. We're not talking about June 12, 1994. We're talking about October 25, 1993. All along, I've asked you to be open-minded about this man and who he is. And we have suggested to you, and I think we've proven to you, that he is not the person that you see on those TV commercials and at halftime in those football games. That is his public persona. We all have one. We all have one. We behave a certain way when we're in public, and we behave another way when we're at home. You know what they say, nobody knows what goes on behind closed doors. And the fact that we may see you and you may see us doesn't really mean that you know us, or that you know me, or you know Miss Clark or Mr. Cochran. You see us here in public. But what are we? What are we really? What are we really inside? What are we really at home? Well, we have a very, very, very nice example. Well, nice is a bad choice of words. We have a very, very poor example of who this man is, of who he is at home, of who he is in his private life. It's the private side, the other side of him. And I want you to listen to a tape of an emergency call. And you recall that I played that tape for you a long time ago, months ago, and you probably forgot about it up until yesterday, I hope. But I'm going to ask you to listen to that tape in just a moment. Now, some people say, well, how could O.J. Simpson actually kill this woman and Ron Goldman when her kids are in the house? You know what I mean? They say, well, who would do something like that? Well, he would. Keep this in mind, if you will, if you think it's important. In 1989, when he beat her, you'll recall that when the police came and wanted to take her to Parker Center to have photographs of her injuries taken, you'll remember that she said, I don't want to go, I just want my kids, just take me back home to my kids are at home, I want to be with my kids. The night he beat her, his kids were in the house. And when you listen to this tape from October 25, 1993, after the first couple of minutes, you'll hear the defendant in the background yelling and screaming and raging. You'll hear that rage. And you'll hear Nicole on the telephone say, the kids are upstairs. The fact that the kids are in the house means nothing to this man, Mr. Fairlow, Mr. Wooden.
Which exhibit is this, Mr. Darty?
Which exhibit is this, Mr. Fairlow? 20?
Thank you.
911 emergency. Can you get someone over here now to 325 Gretna Green? He's back. Please. Okay, what does he look like? He's O.J. Simpson. I think you know his record. Can you just send somebody over here? Okay, what is he doing there? He just drove up here. Somebody over? Wait a minute, what kind of car is he in? He's in a white Bronco, but first of all, he broke the back door down to get in. Okay, wait a minute, what's your name? Nicole Simpson. Okay, is he the sportscaster or whatever? Yeah. Okay, wait a minute, we're in the police. What is he doing? Is he threatening you? He's freaking going nuts. Okay, has he threatened you in any way, or is he just harassing you? You're going to hear him in a minute. He's about to go. Okay, just stay on the line. I don't want to stay on the line. Just stay on the line so we can know what's going on until the police get there, okay? Okay, Nicole? Just a moment. Does he have any weapons? I don't know. Okay. He went home and hurried back. Okay, so upstairs sleeping, and I don't want anything to happen. Okay, just a moment. Is he on drugs or anything? No. Okay. Just stay on the line, just in case he comes in. I need to hear what's going on, all right? Did you hear him outside? Is he yelling? Yeah. Okay. Has he been drinking? No. Okay. Orenthal unit, additional domestic violence, 325 South Brentwood Greenway. The suspect has returned in a white Bronco. Monitor comment, incident 4221. Okay, Nicole? Is he still outdoors? He's in the backyard. He's in the backyard? Screaming at my roommate without me and at me. Here. Okay. Okay, what is he saying? Oh, something about some guy I know and hookers and keys and not your guys. Where was that? I started this shit before and it's all my fault. And now what am I going to do? Get the police get on this? The whole thing. Also, it's all my fault. I started this before. Brother. I only get this close. Okay. Has he hit you today or no? No. Okay, you don't need any paramedics or anything? Okay. You just want him to leave? My door. He broke the whole back door in. And then he left and he came back? And he came and he practically knocked my upstairs door down, so he pounded it, and then he screamed and hollered, and I tried to get him out of the bedroom because the kids were sleeping in there. Okay. And then he wanted somebody's phone number, and I gave him my phone book, or I gave Cliff my phone book down to write down the phone number that he wanted, and then he took my phone book with all my stuff in it. Okay, so basically you guys have just been arguing? Is he inside right now? Okay, just a moment. Is he talking to you? Yeah. Are you locked in a room or something? No, he can come right in. I'm not going where the kids are because the kids are... You think he's going to hit you? I don't know. Okay. Stay on the line. Don't hang it up, okay? What is he saying? What is he saying?
If you want to give me a chat before this talk with EPA on
yelling at you? Just stay on the line, okay? 8078, 325 South Gretna Greenway, 325 South Gretna Greenway, 807881, close your line, clear 4221, are you 825? Is this was something that you did? A long time ago, it always comes back. Is your roommate talking to you? No, I could talk. Listen to him. I know. So do you have any weapons or anything with him right now? Okay. Where is he standing? In the back doorway. In the house. Okay. Could you just please, OJ, could you please, Is he leaving? No. Does he know you're on the phone with the police? No. Okay. Where are the kids at right now? Up in my room. Can they hear him yelling? I don't know. Quiet. Is there someone up there with the kids? No.
I think we've heard enough of that. You'll have this tape in the jury room. I'm just a messenger. And I think you get the message. And you get the message straight out of his mouth. I mean, you hear this man in the background raging. He is raging about a picture of a man he saw at Nicole's house. A picture of a man she had apparently dated how many months before? How many months did Nicole say? About 18 months or something like that. It's on the tape. And Nicole said on that tape as well that it always comes up. This man, that issue always comes up. Apparently, this man and that issue is of great concern to the defendant, of so much concern that he apparently just can't get it out of his system. He can't put it behind him. He can't forget it. He can't forget it. And you hear him back there yelling and screaming at Nicole, and you hear the language, and you hear the things that he's saying about her, and you hear him in the background say, I don't give a shit anymore. That's what he said. An old relationship, a past boyfriend, a boyfriend she apparently had at a time after she moved away from his home and after she filed for divorce. A year and a half. And he still hadn't gotten over it. And it's October 25 in 1993. And Nicole doesn't know it at the time. She knows he's going to kill her at some point, but she doesn't know at the time that she only has 8 months to live. Now, we offer this tape to you, as I said before, so that you would know who you're dealing with. And because you have a right to see him, the private side of him. When you listen to the 911 call, as you take it back into the jury room, listen to the part where she tries to calm him, where she's on the phone and it sounds as if he's getting closer to her because you can hear his voice more clearly and his voice is raised even higher than before. And she tries to calm him. And as she's trying to calm him, she tries to calm him by using a calm voice of her own. You get what I'm saying? I mean, she says, oh, OJ, OJ. Now, 3 minutes before, she was in tears on the phone calling the 911 operator, but when he comes near, he's enraged. She is trying to calm him down with a calm voice. What does that mean? I mean, is that helpful to you at all? Let me suggest to you that what that means is that she's been there before. She apparently feels as if she has a way, some tactic or some approach that might help calm him down. It's Nicole's approach to her problem when the defendant becomes enraged. A calm voice. And she is scared. And you know she's scared. You can hear the fear. You can hear the terror in her voice when she calls the 911 operator. But when he gets close and when she gets to the point where she has to calm him down, she's the calm one. She's the one who is in jeopardy. But she's the one with the calm voice. 1993 was the same year that the defendant talked to Cato Kalin. Remember, Cato Kalin was living at Gretna Green with Nicole. He was living in the back in the guest house. And he talked to Cato just before Nicole moved to Bundy. You remember that conversation? You recall that testimony? This is an example of this man's control, of the control he had over Nicole, the control he exercised over her. Cato was living with her. Cato's going to be paying rent to her, to Nicole. This is money. This is income. Okay? She's divorced from this man. She is not his wife. She is not his wife. She has not been his wife since 1992. Okay? Cato lives there. She has no relationship, no intimate relationship with Cato. She has a right to have him live there in the guest house if she wants. And as she moves to Bundy, if she wants Cato to rent a room, she has that right. I mean, this is 1993. He has no right to interfere with that, but he wants to exercise control over her. He's about control. This is all about control, ladies and gentlemen. It's all about control. The beating, the humiliation, all of that. That's how you control people. You beat them down. They lose their self-esteem. You humiliate them, and pretty soon, they're like puppies. He talked to Cato, and he said to Cato that it wouldn't be a good idea if he moved to Bundy. It wouldn't be right. Remember? Well, you know, you meet people and you get involved in relationships, and he continued his relationship with Nicole, and you have to take people at face value and take them how they, take it how it comes to you. You know what I'm saying? If he wanted to be with Nicole, then he should be with Nicole, the way she is. And if the way she is that she needs a tenant to pay rent, to make it or whatever, that's her thing. He should just accept that, but he doesn't. He talks to Cato, and what does he do? He bribes him. He bribes him away from her. Cato was going to be paying $450 to $500 rent at Bundy. He bribes Cato away, and what does he do? How does he do it? Cato, come live with me over at Rockingham. We got the jacuzzi, the pool, your stage, the tennis court. You got your own room. And what's it going to cost you? What's it going to cost Cato? Nothing. Zero. Zilch. Scratch. It's free. He's bribed Cato away from her, and she is upset about it. You heard the testimony. Nicole talked to Cato, and she begged him not to do as the defendant asked. She told Cato that he was being manipulated. This is control. But Cato told you from the witness stand that the deal was too sweet. It was a freebie, free stuff, free rent and board, free room and board. How could he turn it down? He turned his back on Nicole, and Nicole was angry about that. Nicole named her dog Cato. Think about that. Nicole named her dog Cato. I'm not suggesting to you that this man was angry and depressed and consumed with jealousy each and every moment of the day or each day that he was with Nicole. I'm not saying that. I'm sure that there were periods of calm. I'm sure that there were periods when they had a good time. I'm sure there were times and periods when things worked out great for both of them. But always beneath the surface looms this jealousy and this anger and this passion and that rage, the rage you just heard on that tape. And you know, if you're in Nicole's position and you know all about this, and you know that, hey, you know, there are certain things that can set him off, that can set that fuse to burning, that can make that fuse shorter and shorter, then you're going to tread lightly, right? You're going to try and do everything you can not to upset him. And that's control. They went back and forth in their relationship. They'd make up, then they'd break up. They'd try to get together. They had kids. That sounds natural, right? I mean, you know, there's nothing wrong with that per se. And as I understand the testimonies, I recall that they were together again in the spring of 1994. Despite all of that, despite everything that had happened up until this point, in 1994, she moves in January to Bundy, and in the spring she begins dating the defendant again. And Cato Kalin told you from the witness stand that they had some kind of commitment, either to each other or she to him. I'm not sure of all the details, but you heard the testimony. And if my memory fails me, then, you know, rely on the testimony in case I'm incorrect. But they had some kind of agreement or commitment that she would date only him or wouldn't date anybody else before he left to go to New York for football season. She was supposed to date only him until August. And Cato said that that was a commitment, that they had that commitment. Well, somebody broke the commitment apparently. And May 19, as I recall, was Nicole's birthday. And for her birthday, he gave her an expensive bracelet. And on her birthday as well, as I recall, she was sick with pneumonia. Was that the testimony? That she was sick? And I think someone said, and it may have been Miss Arnell Simpson, that the defendant had brought her soup, taken soup over to her on her birthday because she was sick, or maybe the day after her birthday, but sometime around that time period. But for some reason, Nicole broke off their relationship. She broke off the relationship. For some reason, on May 22nd or thereabouts, Nicole got the courage, the strength to break this relationship. Now, you have to assume that when someone moves out of your house, that that's an attempt to break off a relationship. And you would think that he would get the point. When she filed for divorce, you would think that he would get the point. Then when the divorce is final, you would think that he would get the point. But they go back and forth for whatever reason. I'm not saying it's all his fault. I'm sure to some extent it's Nicole's fault also, if we can fault anybody for this. But she returns that bracelet on or about May 22, 1994. She couldn't be bought. She couldn't be controlled anymore. She had had enough. And when you look at the things that transpire after May 22, 1994, you get the sense, don't you, that he finally got the message? It's over. It's over. She can't be bought. You can give me this expensive gift if you want to. That's fine. But I'm not staying in this relationship. take it back. And she gave it back to him. And the defense would like you to think that this wasn't, that there was no big deal to this breakup, that nobody was upset, that he wasn't upset about it. But was he? Christian Reichard testified from the witness stand for the defense, and he told you that the defendant had been depressed during the weeks leading up to the murder. He had been depressed because of his failing relationship with Nicole. He was depressed because she couldn't make up her mind as to whether or not she wanted to stay in the relationship. You recall that testimony? He was depressed about that. But it seems to me that perhaps this depression turned to anger. Do you have the IRS letter? In the days that followed, and we don't know everything that happened between them in the days that followed, but we know that at some point there was a letter that he wrote to her. We assume that he wrote it because his signature is on the bottom, and this letter has been marked as evidence that Mr. Fairlow will get the exhibit number. The actual letter has been marked as evidence. And the letter was dated June 6th. And it's signed O.J. Simpson. And in the letter, now remember, there are no hard feelings here if you believe the defense case. And this letter begins, on the advice of legal counsel and because of the change in our circumstances, I'm compelled to put you on written notice that you do not have my permission to use my address at Rockingham as your residence or mailing address for any purpose, including but not limited to information and tax returns filed with any taxing entity. Well, what is this? What does this letter mean? How is this letter helpful to you? How many times do we break up with someone and then send them a letter a few days later or 2 weeks later in legalese? And what are the changes in their circumstances that he's referring to? The change in their circumstances is that she has decided that she does not want to be with him anymore. And now he's out to hurt her. He's going to hurt her. This letter is People's 25, Your Honor. Did Nicole have some kind of tax problem? Looks like it. In the last paragraph, he says, I cannot take part in any course of action by you that might be misleading to the IRS or the Franchise Tax Board. What is he suggesting to her? How should she receive this letter? And look at the carbon copy. Mr. Cochran asked someone on the witness stand if they knew that Marvin Goodfriend was his accountant, as I recall. We've heard that Leroy Taft is his lawyer. A carbon copy to his lawyer and his accountant. What's going on here? This is supposed to be an amiable breakup? No hard feelings? This is control. This is a subtle threat. If you disagree with me, fine. If the defense disagrees with me, that's fine as well. But let me tell you something. When the defense began the defense case, well, not the defense case, but when Mr. Cochran did his opening statement, he told you about a witness he intended to call. And this witness seemed to be a pretty important witness, and would seem to be, given the evidence that you've heard in this case. He told you about a woman named Dr. Lenore Walker. And he said to you at page 11783 that there's an expert in the U.S. whose name is Dr. Lenore Walker, and that she is, by all accounts, the #1 expert in America on the field of domestic violence. And he said that she has been called by some the mother of the battered women syndrome. He went on to tell you that she was a psychologist. And she interviewed and tested the defendant. The things that I am saying to you and discussing with you today, the testimony that you heard from the witness stand about the domestic violence, the beating, the abuse, the intimidation, the threats, the stalking. Did they call one witness to rebut any of that testimony? They called 58 witnesses. How many came to address the 1989 incident, or the October 23, 1993 incident that you heard on the tape? Or why didn't they call Dr. Walker? who could have put this all in perspective for you if what the witnesses said in this case aren't true. I mean, it wasn't true. Dr. Walker could have interpreted this letter for you. But they didn't call Dr. Walker. They wouldn't call Dr. Walker. They better not have called Dr. Walker. And Dr. Walker never stepped foot into this courtroom while you were here in the jury box. They are a group of very, very fine lawyers. They called some of the most expensive experts money could buy. But we didn't see Dr. Walker. We didn't see her explain to you why this letter is insignificant, if that's the defense position, or why this cycle of violence that led up to Nicole's murder doesn't help to establish motive from a practical sense. And there was something that he said to you on page 11793, and I want to take a moment and show it to Mr. Cochran before I read it, if I can. Something Mr. Cochran told you he would present to you in this case. And at page 11793, he said to you, I'm going to tell you about the facts. And he says, so you will hear from Dr. Walker, and you will hear about the battery of tests, and I think you will find that she will say that in looking at O.J. Simpson, she testified, that in looking at O.J. Simpson and interviewing him and looking at him, at this point she finds no evidence of antisocial personality disorder, and I think you will find that becomes very important in this case. So where is Dr. Walker to come here to testify, to take the witness stand, to sit in a blue chair and tell you that none of this is important, that everything I've told you for the last 3 hours is insignificant and unimportant? Where is she to tell you that he does not suffer from some antisocial personality disorder? She ain't here. And had she come here and expressed an opinion that this was unimportant, we could have cross-examined her. But they can't touch this. They can't touch this. This is important evidence. You have to consider it when you consider motive, when you consider the issue of identity, the identity of this man as the killer of these two people. You have to consider this on the issue of premeditation. This is important evidence. As the days proceeded on, we know that he hired an interior decorator. As I recall the testimony, Paula Barbieri, his new girlfriend, the one that he was so happy with. It's odd, but on the one hand, they say he was happy with Paula Barbieri. On the other hand, Cato said that he told him, the defendant told Cato, that he, the defendant, didn't know if Paula was the one. I don't know. But let me tell you something about this letter, just to go back, and this whole interior decorator situation. The fuse is burning, and it is getting short. Okay, it's getting short. He is trying to erase her presence, for instance, from his home. Okay, this is how short the fuse is getting. He's trying to erase her presence from his home. He has hired an interior decorator to redecorate the bedroom, the master bedroom, was it? And the bathroom, they're going to rip out the plumbing. The places she had been, they are going to change. They are going to erase her presence from the house. He is going to erase her presence from the house, or at least he's going to try. He is angry and he is upset. He has been rejected and he doesn't like that rejection. And he's trying to get over her. He's trying to get beyond this. And so what does he do? And what does he do? And what does he do? They do work awfully hard, so I can't get upset at them. Page 19.
I believe it is. Mr. Fairley, what evidence exhibit is this? Let me know. Mr. Darden.
Oh, thank you. Thank you, gentlemen. So what does he do? He gets rid of her wedding photo, their wedding picture, puts it underneath the bed. He is trying to get beyond this, but he can't get beyond this because the fuse is burning, because he is upset and angry that the relationship was terminated by her. I mean, you look at that picture, you look at them. After you're divorced and after you break up with someone, you don't usually keep the pictures out, right? I mean, you don't. But do you throw them underneath the bed? You put them in a box, or you get rid of them altogether? That's what you do. But in this case, in his case, he is trying to get over her, but he can't. He can't get over her. He can't get beyond this. On the one hand, he throws his picture underneath the bed. And on the one hand, she is out of sight, and he hopes out of mind. But on the other hand, she's just beneath the bed, where he has access to it, where he can grab it, and where he can look at it. He is beginning to obsess with her. He is becoming obsessive with her, and he is trying to replace her at the same time with Paula. His relationship with Paula supposedly blooms again all of a sudden at about this time, right after she breaks up with him. If she broke up with him on May 22nd, and by June the 6th or whatever, he and Paula are back together, and now they're ripping the plumbing out of the house. You know, people need space. You need time when you're in a relationship, especially one that lasted 17 years. He is trying to replace Nicole with Paula, and he is trying to find some sense of control. But the fuse is burning. And I just wish Dr. Walker had been here to help explain this to you. I'm sure she could have done a better job of it than I have so far. And so we move on. The days pass, and that photo was People's 536, the wedding photo. And the days pass, and we begin to approach June 12th, the day of the recital. You recall that the defendant had conversations with Cato Kalin that day, and he talked about Nicole. He talked about her dress. He talked about how short it was. He talked about the relationship being over. It didn't appear, and you tell me, maybe you disagree, that he and Cato Kalin had that kind of relationship, the kind of relationship where he would vent his frustrations regarding Nicole to Cato. I don't know. You saw Cato, and I don't know why anybody wanted to discuss the personal problems with Cato Kalin, but he did. And he talked about Nicole a couple of times that day to Cato Kalin. and Marcia cross-examined Cato Kalin and directly examined Cato Kalin, and they talked about those conversations. And as Marcia mentioned yesterday, Cato had a bias, and he was biased in favor of the defendant. He minimized things. That's not to say that he just outright lied about things, but he minimized things. I think he minimized the tone of the defendant's voice when he talked about Nicole. I think he minimized just how upset the defendant was when he talked about Nicole. But hey, whatever. The defendant supposedly seen Paula. It's the day of the recital. And what happened that day? Well, the fuse got shorter. I'll tell you why. Paula, his new girlfriend, wanted to go to the recital. The recital where Sydney was going to be performing over at the school. And they had an argument about that, for lack of a better term. They had a disagreement about that. She wanted to go. He didn't want her to go. He wanted to go alone. He told Cato that they had a disagreement about that, and she was upset. Well, why is that important? It's important because she left. It's important because Paula left. She left Rockingham. She left Los Angeles. But apparently he didn't know that. Apparently they had their disagreement about the recital. Paula got mad. Paula left town. It's pretty apparent that he didn't know that. I can't tell you how bad that disagreement was, or if there were raised voices or whatever. We don't have any of that in the testimony or in the evidence in this case. But we do know that Paula left and that he didn't know where Paula had gone. And the fuse is getting shorter, because what happened that day is this. Paula, as a woman, I guess she's asserting her womanhood. She's supposed to be his woman now. She wants to go to the recital. Why not? He won't let her. Why won't he let her? Because he still has hope for Nicole. He still has some hope. He still has some hope. He doesn't want Paula to go to the recital. He won't let Paula go to the recital. And Paula realizes why. And she packs up and she leaves. That afternoon, the defendant called Nicole. We'll get the right photo board. That afternoon, he called Nicole's house. So he's still got hope. He's got hope that, she's always come back, right? Each and every time that they've gone back and forth many, many times. They've always gotten back together. She's always come back. But she isn't coming back this time. But he still has hope. He's put in a catch-22 situation of sorts that day when he and Paula talk about her going to the recital. He has to make a choice that day. He's either going to go to the recital where Nicole is, alone, hope in hand, or he's going to choose Paula. It's either Nicole or Paula. If he takes Paula to the recital, take her out in public, take her around Nicole, take her around the Brown family. He's made a choice now, okay? It's public. Everybody knows he has made a choice. He is now with Paula. But he couldn't make that choice because he still had hope, and he still had hope for Nicole. And so he called Nicole on June 12th. He called her and talked to her at 2:18 in the afternoon. It was a 4-minute phone call. And something happened during that phone call. But let me tell you what else. That after he finished that 4-minute phone call with Nicole, he tried to call Paula. As soon as he hung up with Nicole, he tried to call Paula in the 305 area code, Florida, right here. The phone call it began at 2:18, it lasted 4 minutes. At 2:22, he's calling Florida. Something happened. I don't know what happened. Something happened. Whatever happened, during that phone call, he had a need to talk to Paula thereafter or immediately thereafter. But he's calling Florida looking for Paula. But we know from the testimony and the evidence in this case already that Paula's in Las Vegas in a hotel room being paid for by Michael Bolton. He doesn't know where she is. Sounds like she got upset and stormed off and went about her business. But he can't find Paula. He's having a problem with Nicole. He's about to lose all the women, both the women in his life. And the fuse is getting shorter, folks. It's getting shorter. And the frustration is building. Okay? And the anger is building. And something has triggered his anger, because in all of this, this is a tension. This entire relationship over a 10-year period is filled with tension because of the doors being kicked in and the punches and the slaps and the intimidation and the control and all of that. I mean, this is a very, very tense relationship, and things are about to explode because he has that conversation with her. He tries to call Paula. He can't find Paula, and by the time he gets to that recital that afternoon, around 5 o'clock, he is fit to be tied. He is angry. You heard the testimony of Candace Garvey, Steve Garvey's wife. She was also at the recital. She knows the defendant. She'd known him for a long time. He came into the recital. She and Steve spoke to him. They said, hello. How are you? How are you doing? And what was her testimony? What was his response? There was no response immediately. You recall her testimony. He had a blank stare on his face. He was distracted. She told you that it was as if he looked right through her, as if he didn't recognize that she was there. And she told you that his demeanor that afternoon in the recital frightened her. And she told you that he was angry. And Denise Brown testified as well about that recital. And they told you that he was angry and he didn't look to be or act like the O.J. Simpson they had come to know. Candace Garvey said that he was distant, that his anger was simmering, that he had this look of simmering anger. He was in a slow burn and the fuse was getting shorter. Something set him off, and perhaps what set him off was this 4-minute phone call at 2 in the afternoon. Perhaps his inability to find Paula that afternoon set him off. Okay, now the fuse is really burning. Now the fuse is getting shorter. And there's going to be an explosion, folks. There's going to be an explosion. He arrives at the recital. He sees Candace Garvey, literally ignores her. He's angry. He takes a seat in the auditorium. He sees the Brown family seated in the auditorium. Okay. Judith Brown and Lou Brown, Nicole's parents, and her sisters. Nicole is seated with them or near them. He goes over to the Brown family and he greets everybody in the family, every one of them. He greets everybody but Nicole. He doesn't address Nicole. This is a family event, right? His daughter, Nicole's daughter, at the recital dancing, but he doesn't address her because he is angry. He is consumed with anger, and the fuse is getting shorter. He doesn't appear like the O.J. that they knew, the man that they knew. Candace Garvey is frightened by his demeanor. And what does he do? He takes a seat behind the Brown family. And there are no seats near the Brown family, so nothing wrong with that. Nothing wrong with the fact that he takes a seat behind the Brown family. But as Denise Brown told you on the witness stand, after a few minutes, he just abruptly got up and moved. He got up, took a chair, and in the dark, in this dark auditorium, because the program was going on, he takes that chair and he moves it into the corner and he sits in the corner of the auditorium. Denise Brown told you that she could not understand. She did not understand why he did that. She told you on the witness stand that she didn't say anything to offend him. Nobody said anything to offend him. Why is he so angry? Who is he angry at? Well, common sense would tell us that he's angry at Nicole. Why? Because he didn't address her. But for another reason as well. as he sits there in the corner in the dark, he isn't watching the program on the stage. He's watching Nicole. Candace Garvey told you this, Denise Brown told you this as well, that whenever they looked over at the defendant, that he was not looking at the stage or the program on the stage or the kids dancing up on the stage. They told you that every time they looked over in that dark corner at the defendant, he was staring at Nicole. He was staring at Nicole, and that simmering anger that he had, folks, he was about to lose control. The fuse is getting shorter, and there's about to be an explosion. He is about to lose control. And he's about to lose control like he did on those earlier occasions. And sure, he didn't kill her in those earlier occasions, in October of '93 or in 1989. But that was then, and back then the fuse was a lot longer. But now, the fuse is way short. It's awfully short. And when the program was over, clearly he knew that the relationship was over. In the past, he had done things to Nicole, and she had come back. But not only that, the Brown family. He still had the Brown family. But when you consider the evidence in this case, you see that after the recital, Nicole and the kids and the Brown family went to the Mezzaluna for dinner. They didn't invite him to go. He has been rejected, completely rejected. He has been rejected in public, and this is how these things work. You may sit here and think, oh, well, this isn't such a big deal. Well, sure. Perhaps in your lives and in your relationship, this wouldn't be such a big deal. But you have to put it in the context of the relationship that they've had. This is a big deal. It is a big deal to him. And he is rejected in public. They go off to dinner. He's left to go off to dinner with Cato Kalin. He isn't used to rejection, by the way. He's a celebrity. We talked about that earlier. Celebrities get, you get the best tables. You always get everything you want. You get what you want. There are no rules for celebrities. But on June 12th, he isn't getting what he wants. And so he goes home. And the fuse is getting shorter. And it's getting shorter. And he talks to Cato Kalin, and he complains about the dress she wore. And the fuse is getting shorter. Christian Reichardt was called by the defense, and he testified that he spoke to the defendant at 9 o'clock that night. And then when he spoke to the defendant, that the defendant was jovial, happier than he'd been in weeks. He went from simmering anger at the recital to jovial at 9 p.m. that night. Well, what happened? Why is that? It's because the defendant has developed a plan. He has come up with a plan to rid himself of the problem that has plagued him for 17 years. And he talks to Reichardt. He called Reichardt, as a matter of fact, if you believe that testimony. So many weird things going on that evening. He wants $5 for the sky cap. Cato gives him a 20. He's driving the Bentley to McDonald's. He's calling Christian Reichardt at 9 o'clock, and he tells Reichardt that he's packing right then. 9 o'clock, he's packing to go to the airport. That was the testimony from Reichardt. But then you have these other witnesses come in, Miss Orenthal Simpson and Gigi, the maid. They come in and they tell you that he always packs at the very, very last minute. He rushes around the house, and how everybody knows that he does that. What is going on here? Why is he packing now? Why is he doing these things with Cato Kalin? Why is he jovial all of a sudden, if you believe Christian Reichardt? It's because he has a plan and he knows what he is going to do. He has had enough. The public rejection that day is enough. Folks, let me tell you, the fuse is so short at this point that he is about to explode. The next thing we know, he's in that Bronco. He is in the Bronco at 10 o'clock. or earlier. We don't know when exactly he got into that Bronco, but we know that at 10 o'clock he's into that Bronco, and he is driving in that Bronco. And why wouldn't he be? How do we know that? We know that, as Ms. Clark said, because he keeps the phone in the Bronco, and he is panicked, and he is out of control, and he needs someone or something to help calm him. And so what does he do? He calls Paula. But he calls Paula in two places. He calls Paula at a 310 area code in LA. And she isn't there. Then he turns around and he calls Paula at a 305 area code. And she ain't there either. Paula Barbieri probably could have stopped this whole thing that night if she had been there to receive his phone call. But now Paula's gone. Nicole is gone, and whose fault is all of this? It isn't his fault. It isn't the defendant's fault. It's Nicole's fault. It's Nicole's fault, and that's. Even in 1989, when he beat her, when he came out of the house, he blamed her. Remember when he spoke to Edwards? He didn't want her in the house anymore. He had two other women. And then we come to find out that she found out that he had been with two women, and she was upset about that and wouldn't sleep with him. But he took it out on her. When you listen to the October 25, 1993 911 tape, he's blaming her because she had a relationship with a man a year and a half before, after she had moved out, after she had filed for divorce, when she was literally a single woman out there on her own. He always blamed her. Everything was her fault. And his breakup, his problems with Paula, the fact that he lost Paula was her fault. It was her fault because she went back and forth in terms of their relationship, and the fuse was short, and the fuse is about to explode. You're going to take a 10:30 break, Your Honor?
Yes.
And the bomb will explode when we come back.
All right, ladies and gentlemen, we're going to take our mid-morning break at this time. Remember all my admonitions to you. We'll stand in recess for 15 minutes. Matter, all parties are again present. All right, Deputy Trier, let's have the jurors, please. And let the record reflect that we've now been rejoined by all the members of our jury panel. And Mr. Darden, you may continue with your argument.
Thank you, Your Honor. We're getting there. I've talked much longer than I'd ever expected. And I don't apologize for that because I think it's necessary that we have this discussion.
Keep your voice up just a little so I can hear, because you're
Okay.
far away. Thank you.
So I apologize in a sense, I guess, but I have a duty and you have a duty, and I'm not going to have much of an opportunity later, I think, to talk to you. And so I wanted to share these things with you because I think they're important and because I think they may help guide you in your deliberations. But when we left off, we were talking about the fuse, how short the fuse was getting, and how the defendant was on his way to Bundy in that white Bronco. The same Bronco he drove that night in October of 1993. And so he's on his way, and he is panicked, and he is out of control, and he's calling Paula. And he can't find Paula. He calls her in L.A., he calls her in Florida. She's nowhere to be found. He can't find her. He has lost her. And he has lost Nicole. And whose fault is this? It's Nicole's fault. He made a choice that day. He chose Nicole over Paula. And he lost them both. And so he arrives at Bundy. And Ms. Clark discussed with you yesterday the details of the murder, of both murders. And I don't want to, repeat all that she said. But one of the things that she said that I just want to elaborate on a little bit is his choice, his weapon choice, the use of a knife. This is a rage killing. And it is upfront and it is personal. And that is why you see all the brutality that you see. Common sense tells us that. I mean, we know that just from life experience and from living in L.A. We know what kind of killing this is. This is a rage killing. And he's using a knife because he is there to settle a personal score, a personal vendetta that he has. He stabs this woman in the neck. And he's right there. I mean, it's one-on-one. And the rage that he has, the anger, the hate that he has for her that night, at that time, it's like it flows out of him and into the knife, and from the knife into her. Into her. And he kills Goldman, and he kills her in this rage. And let me make it clear to you. He's enraged, but he has made a conscious decision, a premeditated decision, a deliberate decision to go there and do what he is about to do to this woman. Otherwise, why would he take a big knife with him, right? He killed her that way because he wanted to make a statement. He wanted to teach her a lesson. He wanted to let her know. He wanted her to be there face to face to know just who it was who was doing this to her. With each thrust of that knife into her body and into Ron's body, there is a release, a small release. It's like a tiny time capsule, like contact. There is a release, a gradual release of that anger and that rage. And he stabs and he cuts and he slices until that rage is gone and until these people are dead. And after that rage is gone, he's better. One of the most remarkable things about this case is that after this man, after he did this to these two people, he didn't run away. He didn't jog away. Apparently, he didn't limp away. You heard Agent Boziak's testimony. He just walked away. He had released all of that rage and that anger. during this homicidal fit he was having as he killed these two people. And I'm just a messenger. And I hate to be the one to stand here and tell you about these things, but this is a murder case. And this is what he did. All these things we talked about, these are the things that he did. This is how he lived. This is his life. Okay. And so I think we've come full circle at this point. We've shown you that he had the opportunity to kill. We've shown you that he had the motive, that he had a motive to kill. We've shown you in this trial that he was physically capable of killing. We've shown you that he had a reason to kill. We've shown you that he would have killed, could have killed, and did kill these two people. He's a murderer. He was also one hell of a great football player. But he's still a murderer. And so we've come full circle. There was Ron, and there was Nicole. And, Ron, he was just at the wrong place at the wrong time. Nicole, she was in the wrong place for a long time. And there's this common factor, this common element between the two of them. The one thing they had in common was this man, this defendant. And so we began with them, two very much alive, vibrant human beings. We went through 1989 and 1985, through the beating he inflicted on her. And we went from that in 85 into 1989. And we came to this point on June 12 at Bundy. And so we've come full circle. And the only common element in all of this, and the only direction in which all the evidence points, is to O.J. Simpson. And I told you when this began that I had the hardest job. Nobody wants to do anything to this man. We don't. There's nothing personal about this. But the law is the law. And it applies to us. It applies to you. It has to apply to him. He made a promise a long time ago. He promised to love and to cherish and to keep her. He married her, and he made those promises to her. He promised to be her husband, and he was. And let me say to you that every wife killer or ex-wife killer starts off as a loving husband. And in every household where there's a marriage between a man and a woman, there's a picture just like that picture right there. There's a picture just like that on every mantle, in every home where the husband killed the wife. What he did that night on June 12th, the night of June 12th, to these two people, this brutality, is a violation of every law, high and low, that we can possibly think of. And I suppose there's some people that say, hey, we should cut him some slack. And, if this were a case of, a theft or embezzlement or something like that, you can always make restitution. But this is a very, very serious charge. Two people are dead. And let me say that what you do in this case is entirely up to you. I mean, you're the jury. When I sit down, I sit down. I'm done. I've completed my duty. I've done what the law requires me to do. I have lived up to the oath, my oath, as a member of the district attorney's office. And we hope we presented the best evidence we could. And if we didn't present the best evidence we could, don't hold that against us. I just want you to, when the time comes to go into the jury room, I just want you to, somebody just say, let's calm down, let's elect a foreperson, let's read the law, let's take a minute and let's just look at the evidence. And I'd just like you to use your common sense when you do. When you do that, you use your common sense when you try to be objective, when you remove all the emotion out of this case, when you remove all of the sympathy and passion, and when you just look at the facts, the evidence as best you can, you'll come up with the right decision. The world's watching. Everybody wants to know what you're going to do. Marshall Clark and I know you're going to do the right thing under the law. And whatever you do, the decision is yours. And I'm glad that it's not mine. Let me turn my attention and hopefully yours to the defense case, if I can talk about that a little while. They put on a defense. They called 58 witnesses. And they called 58 witnesses in this case, presumably to help raise a reasonable doubt in your mind as to the guilt of this man. And you heard from some real muckety-mucks, some real big shots in the field of science and forensic science and DNA, and you heard from Henry Lee. A real impressive group of experts, I suppose. But when you consider our case, you have to consider their case as well. You have to assess the credibility of their witnesses just like you have to assess the credibility of our witnesses. And when it comes to assessing the credibility of witnesses, you apply the same standard regardless of whether it's a defense witness or a prosecution witness. You have to decide whether or not that expert testimony is worth anything or what it's worth. I hope that when you do that, I hope you keep in mind that, people made a lot of money testifying in this case. And you should consider that on the issue or question of whether or not those witnesses are biased. But study the defense case carefully. I insist that you do, as painful as some of it might be for you. But consider this. The defense that they put on in this case, it wasn't really an affirmative defense. It wasn't the kind of defense where they show you that he wasn't there, okay, at the time of the murder. They never did that. They never showed you that. What they did was they attacked all of our evidence. Well, not all of it. They didn't attack the domestic violence. There are lots of things that they attacked initially. Only to find out, of course, only for you to find out that, well, they didn't have a chance with it. But what you really wanted to know in that defense case, and I can't talk to you directly, but I'm going to assume you're reasonable people, you have common sense, good common sense, you're all successful at life. What you really wanted to know, correct? Maybe I'm wrong, but what you really wanted to know was where was he at the time of the murders, right? Where was that Bronco? Had they proven to you that that Bronco was not at Bundy or could not have been at Bundy, that would have been very helpful to you. Would that not have been impressive to you? Isn't that the kind of evidence you want to hear, that you want to see, credible, reliable evidence on that issue? That's the kind of evidence that raises a reasonable doubt. They didn't do that. They didn't put on that kind of evidence because they couldn't put on that kind of evidence. They don't have that kind of evidence. We all know where the Bronco was at 10:15. It was at Bundy. You would have liked to have known that some other person was with Nicole Brown or Ron Goldman, right? I mean, wouldn't you not have liked to have seen some evidence from some witness that the person that killed these two people was someone other than the defendant? When Mr. Cochran spoke to you during his opening statement, he talked to you about witnesses that he intended to call on. He gave you the names of those witnesses, and he told you what they were going to say. You know, and we did the same thing. I did the same thing. You know, on domestic violence, I told you I was going to call a few other people. I didn't. I think you got the point. You know, and I can't keep you here forever. Apparently, this sequestration thing is a real drag, right? And you'd like to end this experience, and I can understand that. But he promised to present to you the testimony of some witnesses who had they testified, could have perhaps raised a reasonable doubt in this case. So where are those people? Who are those people? Well, one of those people he mentioned was a woman named Rosa Lopez. You remember this in his opening statement? He said that Rosa Lopez was the maid that lived next door to 360 North Rockingham, and that she would come in here and testify that the Bronco was parked at 8 p.m. that night, the night of June 11th, that it was parked in the exact same place the police found it the next day. And that it was parked in the exact same manner. Tail sticking out. Remember that? He said he was going to present that testimony to you. He was going to call this witness. Well, where is she? Where was she? You would have liked to have heard that testimony, wouldn't you? He didn't call her. He told you about a woman named Mary Ann Gerchis, and he told you that she would testify that she was out on Bundy Avenue and that she saw 4 men running, 2 Hispanic men, 2 white men, and that a couple of the men wore knit caps. We have a knit cap at the scene, at the death scene. And that this happened at about 10:45. That's what the defense told you they would do. They told you they would call Mary Ann Gerchis to give you that information. And you may not remember all the names, but I'm sure you remember that when you heard this, that wow, the defense is going to call these people? Whoa, this is going to be some dogfight. I mean, these people are going to come in here and they're going to lay an alibi. Rosa Lopez is going to give an alibi for him by showing that the Bronco had been there all night. Mary Ann Gerchis was going to come in and testify that, hey, there were other persons, other men, apparently running from the area near 875 South Bundy. A few of them wearing ski caps, consistent with perhaps the real killer, a killer other than this man here. Did they call Mary Ann Gerchis? What happened to her? Where is that testimony? You'd want to hear that, wouldn't you? And right after they talked about Gerchis, they talked about a man named Tom Lang, who was supposedly down the street on Bundy, who also saw somebody. They told you that Tom Lang saw Nicole Brown standing on the street at Bundy, embracing someone. And that Tom Lang, as he stood there on the street, also saw a man standing some distance behind them, a man who appeared angry, a man standing there with his hands clenched, looking at Nicole and this other person, the person she was embracing. It's right there in the transcript at page 12,255. Where is that person? We already talked about Dr. Lenore Walker. Where's Dr. Walker? He told you Al Cowlings would testify. Where's AC? He told you that the defendant was out chipping golf balls. He told you Paula Barbieri was going to come in and testify about her relationship with the defendant. We didn't get Paula Barbieri. What do we get in terms of her relationship with the defendant? We got other people on the peripheral. The stuff you needed to hear to raise a reasonable doubt, and you're reasonable people. Never got presented in this case. It never got presented. What you got was a lot of smoke. You got people like Gertie's telling you that the crime lab isn't, can't be relied on. But then the substrate controls are all clean. You got guys like Professor McDonald out doing glove experiments where he's taking his own blood and then he's putting it on a new pair of Eris gloves and he's rubbing it around like this to see if they shrink. When you look at the defense in this case, you'll see that it really isn't helpful at all. It's all smoke. It really is all smoke. And you're going to have to be careful when you deal with that defense evidence. Now, some of it was pretty good, though. I mean, the stuff they did to Furman was textbook stuff from a legal perspective. But even that, you have to look and say, well, what does it do for us? It upsets us. But then you have to look at all the evidence and see how it's helpful, if it's helpful at all. They called demeanor witnesses, and witnesses to testify to the defendant's demeanor after the murders. And Marshall Clark talked to you about that. Murderers don't walk around with neon signs saying, I just killed somebody. When people do things, commit crimes like this one, especially a rage killing like this one, he will calm down. They will calm down. And they want to get away with it. He wanted to get away with it. So he certainly isn't going to do anything that's going to draw attention to himself. But they showed you these photographs. They showed you photographs of the defendant and some women at an event the night before the murders. Remember that? Because they had Carol Connor, the woman with the keyboard vest, come in and testify about the event the night before. Remember she told you that she witnessed an exquisite romantic moment between the defendant and Paula Barbieri? Well, what does that do for you? How does that help you resolve this case? It doesn't help at all, especially when you consider the fact that he and Paula had a disagreement, for lack of a better term, over his refusal to let her go to the recital the next day. But beyond that, it's a picture. He is at this big fancy event, and somebody says, will you please pose with us for a picture? Well, when somebody takes your picture, what's the first thing they say? Cheese. What point is it? What good is it? What value is it in a picture like that when somebody's posing for you? And even in that video after the recital, he sees the video camera, he looks right toward it. Posed for pictures are worthless. And they call that guy McKay. Remember Mr. McKay who worked for the AARP? Was it the AARP? Or the American Association of Psychologists or something like that in Chicago. And there was a golfing event, and the defendant came to the event as the spokesperson for Hertz. And Mr. McKay and the defendant and two other gentlemen took a picture together. They're posing for a picture. Not only are they posing for a picture, the defendant is basically at work. He's a spokesperson for Hertz. It's his job to go out and play golf with these people. So how does that help you? There is nothing in the record that establishes for you and I guess Dr. Walker could have done this. Whether or not, murderers have neon signs over their heads that indicate they're a murderer. How do you know? How do you know? Well, whenever you watch TV, you watch the news and some brutal killing happens and it's the neighbor. The neighbor did it. And they always interview the neighbors of the neighbor who did the murders and the reporters always say, how was he? How did he act? What kind of guy was he? Oh, he was a nice guy. They always say that. You don't know. You can't tell. The testimony you heard about demeanor on the airplane and at the airport, it was a waste of your time, really. But if you want to attach some significance to it, you go ahead. It's up to you. I mean, you're the jury. And the only demeanor really that's important is his demeanor that night. You know, after he got into that Bronco and headed toward 875 South Bundy. But this defense that they've put on in this case, it's what we in the profession call a shotgun defense. And it's a defense as old as the law. Way back in the day, way back in the day, even back when I was in law school. Old lawyers and old law professors shared with us the old school approach to a criminal defense case. And every lawyer knows this case. You're a criminal defense attorney and you have a tough case, this is what you do. You argue the law. And if the law is against you, you argue the facts. And if the facts are against you, you raise hell and blame somebody else. When the facts and the law are against you, blame the police. Blame the prosecution. Point the finger elsewhere. Create a smoke screen. And that's what they've done in this case, ladies and gentlemen. Smoke and mirrors. That's it. That's what you've got. They put on those timeline witnesses. Remember Ellen Aronson and Danny Mandel? Judy Thielander. Pilnack. Remember Pilnack? Was she the woman that had 2 watches? If you haven't learned anything else about this case, I'm sure that you've learned that there are people who are banging at the door to get in on this case. Those people and the testimony they had to offer really wasn't helpful at all. I mean, Danny Mandel and Ellen Aronson were on a date, right? A blind date. They went to the Mezzaluna. They say that they walked past Bundy. In fact, Ellen Aronson gave an interview to the police the day after the killings. And she told the police that she passed Bundy at 11 o'clock. But once she heard about the prosecution's theory of the case, well, what did she do? She went back to the Mezzaluna. She talked to Mandel. They got together. And they attempted to reconstruct what they did that evening. She told the police she passed at 11 o'clock. Mandel told the police they passed between 10:28 and 10:32, and he knew that because he checked his watch. But even Mandel himself didn't know whether he had passed 875 South Bundy that night or not. He didn't know. He didn't know. He didn't know until, if it ever happened, he didn't know until he and Aronson got together and started putting their notes together, trying to do, as they say, to reconstruct what happened. His time in passage at 875 South Bundy contradicts her time. They got together on this story because they got together and attempted, as they say, to reconstruct what happened. What good is this testimony to you? And if they want to say they passed at 10:28 and there were no dead bodies out there, well, fine. I don't know how they can say that. I mean, they're on a date. They're looking at each other. That pathway is pitch dark, and we know that. We know that. Because when the bodies were discovered, the police were called, and Risky said he couldn't even see any bodies up that pathway. When he first arrived and got out of his car, he had to walk all the way up the pathway and use a flashlight. The only reason anybody found the bodies was because of Cato. And not Cato the human, Cato the dog. So how much attention were they paying to that particular pathway? There are lots of pathways leading to lots of condominiums on Bundy Drive. That testimony isn't helpful to you at all, but hey, do with it whatever you like. Then they called Francesca Harmon. Remember her? She testified that at 10:20, she was driving west on Dorothy. Okay, she's driving west on Dorothy, which is just south of Bundy. She got to Bundy and she made a right-hand turn. She didn't see any bodies. Then I asked her some questions. I said, well, when you made that right-hand turn at Bundy, did your headlights hit 875 South Bundy? I mean, did they sweep across the front of the condominium? What was her answer? No. I asked her, did your lights hit the gate at 875 South Bundy? She said no. And so I asked her this, well, did you tell the defense that your lights didn't hit the gate at 875 South Bundy? And what was her response? I didn't have to. They were in the car with me. They took her out on a test drive to have her show them the route she took that night. It was clearly apparent that she could not have seen what was in front of 875 South Bundy because her lights never hit the front of the location. And they called her to testify anyway. What does that say about the defense case that you heard? Well, it says they're desperate. That's what it says. We are not wedded to a 10-15 time frame, okay? The killings very well could have happened at 10:15, but they could have happened at 10:17 also. They could have happened at 10:21. We called witnesses to the stand to testify to the point in time that they first heard the wail of that dog, of Cato. Because we know that the wail was a plaintive wail. And we know that the dog was in distress, and so we know that something was happening, something very bad was happening to the dog's master. And if the dog is first heard around 10:15, I don't know. That may mean that the defendant is hiding outside and the dog here is aware of it. It may not mean necessarily that the killing happened at that specific time. It happened sometime around 10:15. We can't give you the exact time. We can't give you the exact time to the minute. If they want to push the time to 10:30, push it to 10:30. Because any way you look at it, he's still got time to get to Bundy, because we know he's in the Bronco at 10:03. He's got time to get to Bundy to do these killings and to get back to Rockingham by 10:54 or 10:45. Their witness, Robert Heitstra, told you that on a Sunday night, you could easily drive from 875 South Bundy to the defendant's house. And he knows that because Heitstra, he worked next door at the Salingers. Okay, he worked at the defendant's neighbor's house. He told you that you could drive there from 875 South Bundy with under 4 minutes on a Sunday night easy. So it doesn't make, makes us no difference. Makes us no difference at all as far as all of the timing is concerned. But they also called Denise Pilnack, the woman that wore 2 watches, and she came in here and showed you her 2 watches so that you would find her credible and believe her, because she wanted to get in on this case. Weird stuff. Weird stuff, but you, I don't know. She testified that she drove, what did she drive? No, she came home with Judy T. Lander, and she made some phone calls, and she kicked T. Lander out of her house at a certain time and all of this. And how does she know, on all of that? How does she know that? Well, because 6 months after the murders, she put together this timeline. 6 months later. So how was that helpful? And then there's T. Lander, and she's describing her drive up Bundy or around or near Bundy. And you know what's weird? Is that when you look at T. Lander's testimony, and you look at Harmon's testimony, and you look at Heitstra's testimony, and you look at Pilnack's testimony, and you look at Aronson's testimony, and you look at Mandel's testimony, all of these defense witnesses, and what you see, what you come away with is this. These people are all at Bundy at the same time, basically, if you believe them. They are all basically on Bundy, at the intersection, or within view of 875 South Bundy. They're all there in this small area, basically at the same time. But when you talk to them, and when they testify, they all tell you they didn't see any cars. They didn't see any people walking. They didn't see each other. Mutually exclusive. They mutually exclude each other. All of that testimony, they contradict themselves. They contradict themselves. And I'm not here to say these people are lying or whatever. They may just be mistaken. I don't know. But you have to evaluate their testimony, and I just think it's important that you take note of that. And I hope as well that you would take a look back at the timeline witnesses, if that's what we can call them, the ones that we called. Mark Storfer. He was concerned that the dog barking might wake his little boy, and so he told you what time it was. He looked directly at the clock, and he was interviewed the next day, the day after the murders. He knew what time it was when he heard the dog barking. Look back at Eva Stein. She lived in the condo directly above the walkway where the bodies were found. She lived right next door at 873 South Bundy. I believe her time was 10:20. Was it, Eva? Was it 10:20? It was 10:20. Those are the people you can rely on in terms of time. They're right there. They live there. They live right there near 875 South Bundy. But so you've heard the defense and you've heard the prosecution case, and as I said before, you're going to have to make the decision in this case, and whatever decision you make, we'll live with. But after I finish talking to you today, the defense is going to talk to you, and I don't know who's going to talk to you or who's going to talk to you first. I would ask that you listen, and listen as attentively as you have listened to me, apparently. But I'm going to ask you as well that you keep in mind that as you listen to them, consider this. Hope, at least, that they can somehow extrapolate from all the evidence we've heard in this case where the defendant was at the time of the murders. If he ain't the murderer, where was he? And maybe they can tell you that based on the evidence in this case. And they put on a defense and bear in mind and insist, I think, if they can, explain to you what happened to O.J. Simpson's Aris Light 70263 gloves. The gloves found at the murder scene, the same style of gloves purchased by Nicole, the same style of gloves you see him wearing in that January 6, 1992 game photo. Where are his gloves? They called 58 witnesses. They called the maid, Gigi Garain. They called Miss Arnell Simpson. If he never owned a pair of those gloves, I don't recall the defense asking him if he owned a pair of those gloves. I don't recall the defense asking the maid, the woman who kept the closet, who put things up, who did the laundry. I don't recall them asking her if he owned a pair of gloves like that. Like the ones we found at Bundy, like the one we found behind his house. And I don't recall him asking the maid whether or not he owned a pair of Bruno Magli's. This is stuff you'd want to know. Insist that the defense explain to you who kills two people wearing $200 leisure shoes. If it ain't this man, if it isn't this defendant. And ask him to explain to you why the bloody shoe prints leading away from the bodies are size 12, his size. And where did all that blood come from? And why is it that when he spoke to Tom Lang, he told Tom Lang that the shoes he wore the night before were white Reeboks? They put on a defense, and you would expect that if the man that Alan Park saw entering the defendant's house that night was not the defendant, you would expect them to have called that man to tell you that, hey, it was me. It wasn't the defendant. Right? And if O.J. Simpson didn't create or cause those stumps on the wall behind Cato Kalin's house, then who did? This is the defendant's property. And when Kalin comes out with that flashlight, and when he finally sees the defendant sure doesn't seem too concerned about those stumps on the wall. I mean, Cato's frightened enough to grab a flashlight. He's frightened enough to tell the woman he's talking to on the phone that, hey, if I'm not back in 10 minutes, call the police. Worry about me. Or words to that effect. But when he tells the defendant about these stumps on the wall, he isn't too concerned about it. He has West Tech security. We know that because the police talked to West Tech before they entered his house. Did he Did the defendant call the police to say, hey, I may have a prowler on my property? Did he tell Cato to? Did he call West Tech, his private security, to come check this out? Did they? No. Why not? Because he knew. The defendant knew who caused the thumps on the wall. It was him. And why did he lie to Alan Park about being asleep? He wasn't asleep. And there are a variety of questions that you ought to insist be answered, that should be answered for you by the defense before you even consider acquitting this man of these very, very brutal crimes. The whole thing with the cut on his hand, what a fluke that is. You gonna fall for that? They talk about cover-ups. That's a cover-up. That is a cover-up. Ask him to explain to you how it is, if there were two killers, how the other one got out of that bloody crime scene without leaving any evidence of his presence. A major, major question in all of this is what happened to that little black bag? Remember the bag on the driveway, at the driveway? The one that Cato offered to go get that night just before the defendant left for the airport? The defendant said, I'll get it. What happened to that bag? Has it been seen since? The defense, well, we know that some of the luggage, apparently taken to Chicago by the defendant, was seized by retired Judge Delbert Wong. Remember? The Louis Vuitton bag? The one the defendant came back from Chicago with, the one he gave to Robert Kardashian. You saw it on tape. What happened to the little black bag? What happened to the contents of that Louis Vuitton bag? Remember? When you look at the tape, you see Kardashian standing there in front of the defendant's house, and you can tell that that bag is full. But when that bag comes to Delbert Wong, to Judge Wong, when it's pointed out to him, when it's seized by him months and months later, there's nothing in the bag. The bag is empty. What was in that bag? Ask him to explain to you why it is that if he didn't do it, why then is there a ton of evidence pointing to him and only to him? And ask him to explain to you, hey, if this is a rush to judgment, why then did the police go out to that house 8 times prior to 1989? Why didn't they ever arrest him? And if this is a rush to judgment, why did the police stand out in front of the house, in front of 875 South Bundy that night for a couple of hours doing nothing, as the defense has asserted, doing nothing but waiting for Van Aderen Lane? That's a rush to judgment. This is no rush to judgment. Unfortunately, this is just how things go. Those cops got out there to conduct a murder investigation, and that investigation led them to Rockingham. They followed the blood trail. Using your common sense, and when you evaluate all the evidence, you should do the same thing. Take a look at the crime scene and follow that blood trail. Because when you do, you're going to follow it right into his house, into his yard, into his bathroom, into his bedroom, right into his lap. And that blood trail went nowhere else. It didn't go anywhere else, and it didn't go to any other person. When I began this discussion with you last night, I talked to you about justice and what justice really means in this case. And it just means doing the right thing under the law. I mean, basically, that's all it means. Following his instructions. Just do what he tells you to do, the way he tells you to do it, and you'll be fine. I've spent hours talking to you, and I've talked to you about the explosion, about that fuse, how the fuse gets shorter. We've explained to you that he had the opportunity and the means and the motive to do it, and that he did it. And we discussed a little bit about the smoke. We talked about the smoke the defense has put up. You have to find your way through the smoke. One of the first things they're going to tell you is that the prosecution's case lasted 6 months and ours lasted 2 months. They're going to tell you that. But you just keep in mind who was cross-examining those witnesses for days and days and days about minutia. There was a lot of minutia in this case, and you know it was, because you didn't write it down. The defense got lost in minutia in their attempt to confuse you and to raise a reasonable doubt. Well, let me explain justice to you this way, and then I'll sit down and I'll be quiet. The people put on their case, the defense put on their case, and I assert that the defense case is a bunch of smoke and mirrors. It's all about distracting you from the real evidence in this case. So imagine the smoke, and imagine a burning house. Okay? Imagine that you're standing in front of a burning house, and from inside that burning house you can hear the wail of a baby, a baby's cry, a baby in fear, a baby about to lose its life. And you can hear that baby screaming. You can hear that wail. Now that baby's justice. This is baby justice. Now usually justice is a strong woman, but in this case, justice is just a baby. And you hear that baby, and you hear that wail, and you see the smoke, you see the defense. There's all this smoke in front of you. And you feel a sense, you have a sense of justice. And you have a sense of what the law requires. And you have a strong commitment to justice and to the law, and you want to do the right thing. Well, justice is about to perish. Justice is about to be lost. Baby justice is about to be lost, and so you start to wade through that smoke, trying to get to that baby. You've got to save that baby. You have to save baby justice. And if you happen to run into some smoke, find your way through the smoke. And if you happen to run into a couple of defense attorneys along the way, just ask them to politely step aside and let you find your way through the smoke, because the smoke isn't over, okay? The smoke's about to get heavier because they're about to talk to you. Let's use your common sense. Wade through the evidence, get down to the bottom line, and please do the right thing. It has been an honor to appear before you, and we will wait for your verdict.
Thank you, Mr. Darden. All right, let me see counsel without the court report, please. The Simpson matter, all parties are again present. Jury is not present. Record should reflect that over the noon hour, we had an informal showing of the argument boards produced by the defense. Counsel, any comment before we resume with the jury?
Yes, Your Honor, we had a couple of objections to lodge.
Ms. Clark.
We filed with the court a couple of motions. One dealt with the potential for Mr. Cochran to mention either Detective Furman's invocation, the other, and with the potential for referral to matters contained on the tapes that were deemed inadmissible by this court. And we have proposed a remedy should such violation occur. And the defense response doesn't appear to be very responsive to the people's motion. So the people would urge the court to instruct counsel that if he does violate the court's order by mentioning Detective Furman's invocation, or if he does violate the court's ruling with respect to the content of the tapes that was deemed inadmissible by referring to them in some manner in closing argument, that the appropriate sanction, and one that would prevent, that would make his violation not worthwhile, not worth doing, is to say, if you do mention such a thing, this is the remedy. I will instruct the jury that Detective Furman did not plant the glove. The remedy has to be something that makes it unworthwhile for the defense to violate the court's order. Otherwise, if all it is a monetary sanction or an admonition that it's improper in front of the jury, that would not give the defense incentive to abide by the court's ruling. And so the people urge the court to make sure that the defense does not violate rulings by making a sanction onerous enough so that it would not be worth their while to do so. With respect to the burden of proof chart, does the court want to hear that now?
Yes.
We filed the motion. Did the court have an opportunity to read our motion on it?
No, I have not seen that.
I think
Do you have that chart handy?
I do. Do you have an extra copy there? Did Mr. Robertson give it to you?
Yes.
Okay.
The boardroom?
Yes. Ms. Clark.
Okay. The problem with this board is that it's extremely misleading, and it's going to confuse and mislead the jury on a matter of law. And it's one thing to draw reasonable inferences from the record and from testimony to say, we've heard this, therefore that. But there is no misinterpretation of the law that is permitted. And counsel, although counsel can ask the jury to draw unreasonable inferences from the record, and that is what he will do, I do not think there's any authority permitting counsel to ask the jury to misinterpret the law, which is what this invites them to do. By creating the impression that the burden of proof is so overwhelming, it would be unbelievable that we could get a conviction in any case if it were as stated on this chart. It's misleading in 5 ways. First of all, it contains phrases, several of them, that supposedly describe thresholds of evidence that don't exist and have never been a part of the definition of reasonable doubt. It contains the phrases highly unlikely, less than likely, probably not, unlikely, and a variety of others, as the court has seen. All of these are used to describe thresholds of evidence that fall into the category of not guilty according to the chart, but none of them find their way into the Penal Code Section 1096 definition of reasonable doubt. So it's misleading in that respect. Secondly, it's misleading because it contains terms in the not guilty range that are consistent with guilty. For example, the phrase may not be is used to describe a threshold of evidence in the category not guilty, when in fact under 290, the jury is entitled to convict the defendant if all they have is some possible doubt. Excuse me. And as the court knows, I did go over with the jury at some length the fact that a mere possible or imaginary doubt is not sufficient to raise a reasonable doubt. What this chart conveys to the jury is that mere possible doubt is sufficient. It contravenes the burden of proof by saying that certain terms, in certain of its terminologies and some of those levels, what they say is a not guilty is actually a guilty. If you see what I mean. Mm-hmm. So, third, it's also misleading because it implies that proof beyond a reasonable doubt is absolute doubt. I mean, absolute certainty. In other words, no doubt at all. It does that by implication, by having at the bottom of it not guilty or absolutely not guilty, creating the impression that the top of that, which is the burden of proof we have to carry, is absolute certainty. There's nothing in this world that could be proven with absolute certainty. That's why we have proof beyond a reasonable doubt as a standard. Yet by implication, that is what the chart seems to infer to the jury, and that's a direct misinterpretation of the law. Fourth, it's misleading because it uses terms that are synonymous, treating them like they're distinct categories. For example, the terms probably not, less than likely, unlikely, they're synonymous, but they're, in this chart, broken down as though they're separate gradations, when in fact they're all the same. Same thing with perhaps and suspected. So they create gradations that really don't exist. It's a figmentary kind of depiction of all of the levels that a person might have of belief. And so it amplifies the burden of proof unfairly. Fifth and last, the chart is misleading because the visual nature of the representation of the degrees of proof suggests incorrect and unsubstantiated numerical levels of certainty. It would imply that there is some kind of numerical level that could be attached to what constitutes guilt beyond a reasonable doubt. And the inference drawn here by the number of levels that they have, if you work it out mathematically, is that 93% equals guilt beyond a reasonable doubt. That's improper. And we don't categorize our burden of proof by mathematical probabilities or by quantities that can be mathematically defined. That would be impossible to do. It's misleading to the jury and it's improper. So we would ask the court, urge the court strenuously not to permit this chart, as the jury will be misled as to what the people's burden of proof really is and as to what is meant by proof beyond a reasonable doubt. And then Mr. Mavis points out correctly, as we cited at the end of the motion, Your Honor, the Freeman case makes it very, very clear that to vary from the standard reasonable doubt instruction is a perilous exercise. And this chart varies substantially from the definition given to the jury in their jury instruction and from the definition given in Penal Code Section 1096. And for all of these reasons, because it is misleading, and because it is a very dangerous practice, and because it may very well give the jury a misimpression of what the burden of proof really is, it should not be allowed. Counsel's also previewed for us the laser shows they intend to play. What counsel has attempted to do is subvert the court's ruling concerning the video clips by using stills from videotape. And I thought the court said we couldn't do that. And yet that's what they've done. So instead of playing the moving picture, they took the video clip and just used a still from that.
My recollection, though, is that the prosecution array that was displayed to us also included static photos of persons while testifying.
Well, I thought that we were precluded from using them.
Not the static photos, no.
Oh, I didn't know that.
Yeah. The actual use of the videotapes. But if you want to say, this is so-and-so, this is what the person, this is who it is, this is what they testified to, that's permissible.
Oh. Okay.
All right?
Never mind.
Okay.
With respect to the...
All right.
there's one other thing, Your Honor. They showed stills of the glove demonstration with Mr. Simpson, a number of them, with him trying on the gloves in front of the jury. But there's a number of them, which is, in effect, using a video clip. Now, if they want to use that, and if the court wants to permit them to use that, then we would ask the court, in fairness, to allow us to play the whole tape, rather than just those segments being shown by the defense.
Okay. All right, Mr. Blazier, are you handling this matter?
I am, Your Honor. Let me...
All right. Good afternoon.
Good afternoon. With respect to the, I guess it's a prophylactic instruction that they want. In case we do something wrong, then this is what our punishment's going to be. I've never heard of anything like that. We know what the rules are. We know what we can say and what we can't say, and I'm sure that if we say something we're not supposed to say, they'll jump up and you'll holler at us, and whatever will happen will happen. I think it's absolutely ludicrous for us to sit here and debate whether we might do something wrong, and if we do, what should happen about it. So I think that's just a foolish motion, quite frankly. As to the charts, the burden of proof chart, I've probably used that chart in every trial I've done in the last 5 years. It's never been excluded. I've never been told by a court that I can't tell the jury what I think reasonable doubt is. They were allowed to tell the jury what they think reasonable doubt is. That's part of argument. That's what argument is for. The court reads the instruction. Those are the words of the instruction. We're entitled to say, this is how we think you should interpret that. There's nothing on there about percentages. I guess they went so far as to count up the little boxes and add them all together and divide up and say that we were going to make some argument that 93% or 7%, I guess, is reasonable doubt. That's foolish. We're not going to offer any kind of a statement like that. The Freeman case talks about the court's instruction. The last 5 years, I've also asked the court to give my own instructions on reasonable doubt, and I never get those. You always give 2.90. But I've never been precluded from saying, this is what we think reasonable doubt is. They're going to have another shot at the jury. They can get up and say, that's a lot of hooey. You shouldn't look at it that way. You should look at it this way. So I think there's nothing wrong with that chart. As to the video clips, if they want us to show the whole thing, we'll be happy to, at the glove demo.
All right, when we're talking about the glove demo, if both sides want to use that,
Well, you know, Your Honor, it's not a matter that we want to use it. It's a matter that I don't think it should be allowed for either side. And what I was saying is that, they have some stills that they want to show, which are, of course, just the parts that are most favorable to them, but I think that it would be inappropriate for either side. We could have used it in our opening argument. That was the plan that we had until it was ruled that we couldn't. But the problem with the glove demonstration is that it's an active, mobile thing. If you take still shots from that, it's very misleading to the jury, and it has penalized the people because we felt we couldn't use it.
well, my recollection is that the prosecution argued against the use of videotape because it's not the official record.
That's right.
Right.
That's right. And our position hasn't changed, Your Honor. I think the court's ruling was also that we could only, at the point that the court was saying we could use videotape, the court was saying that it can only be tape of the witness in the blue chair, and this doesn't qualify.
Well, this is not a tape of testimony. This is a picture of the demonstrative demonstration that was done. And we only had 2 stills, by the way.
When do you anticipate getting to that?
Yeah, a minute. Hour and a half.
All right, let me see it. Let me see the excerpt that you propose to use. Or the stills, I'm sorry, that you propose to use.
Stills?
Yeah.
That's it.
All right.
Submitted.
All right. Submitted?
With respect to glove photos, the only point I wanted to add, Your Honor, other than the fact that we would have used this ourselves in opening argument, is that if these photographs are misleading because they only show a portion of it, but in order to show all of it, either the clip should be shown or none of it should be shown, and I think that none of it should be shown. Counsel can argue it as we argued it, but I don't think that this is appropriate, and certainly not the stills of their use.
All right. Thank you, counsel. All right, as far as the prosecution motion for preemptive instruction, admonition, or warning to the defense regarding Detective Furman and regarding the McKinney tapes, the court finds that to be premature. I trust that counsel know what the law is regarding appropriate argument by counsel. The evidence code is clear that the counsel may not argue or mention the invocation, and I'm sure defense counsel know that the sanction will be swift and severe, and I don't think it's necessary for the court to take any action at this time. As far as the chart regarding burden of proof, reasonable doubt, that is a very familiar chart to the court. I've seen it before. I'm sure I'll see it again. The objection to that is overruled. The objection to the clips of the glove demo is sustained. It is not part of the official record. All right, anything else? Are we ready? All right, Deputy Tarrant, let's have the jurors, please. 3:15? 3:15, and we're going to quit at 7:45 tonight. 5 to 6 break. Go to 7:45. Sure. Ms. Clark? All right, the record should reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. And as I mentioned to you, we had some preliminary matters we had to take up out of your presence. We're now ready to proceed with the defense argument. Mr. Cochran.
Thank you
You
very
may
kindly.
proceed.
Judge Ito, my colleagues on the defense, my colleagues in the prosecution, the Goldman family, the Brown family, to the Simpson family. Good afternoon, ladies and gentlemen. The defendant, Mr. Orenthal James Simpson, is now afforded an opportunity to argue the case, if you will. But I'm not going to argue with you, ladies and gentlemen. What I'm going to do is to try and discuss the reasonable inferences which I feel can be drawn from this evidence. At the outset, let me join with the others in thanking you for the service that you've rendered. You are truly a marvelous jury, the longest serving jury in Los Angeles County, perhaps the most patient and healthy jury we've ever seen. I hope that your health and your good health continues. We met approximately 1 year and 1 day ago on September 26, 1994. I guess we've been together longer than some relationships, as it were. But we've had a unique relationship in this matter in that you've been the judges of the facts. We have been advocates on both sides. The judge has been the judge of the law. We all understand our various roles in this endeavor that I'm going to call a journey toward justice. That's what we're going to be talking about this afternoon as I seek to address you. The final test of your service as jurors will not lie in the fact that you've stayed here more than a year, but will lie in the quality of the verdict that you render and whether or not that verdict bespeaks justice as we move towards justice. Now, you'll recall during a process called voir dire examination, each of you were thoroughly questioned by the lawyers. You probably thought, gee, I wish they'd leave me alone. But you understood, I'm sure, that this is very serious business. Our client, Mr. Orenthal James Simpson, is on trial for his life. And so we had to be very, very careful, both sides, in trying to get people who could be fair to both sides. You'll recall those questions, that you keep an open mind, which I hope you still have even to this day, that you wouldn't be swayed by sympathy for or passion against either side in this case, that you would give both sides of this lawsuit the benefit of your individual opinion. No one can tell you what the facts are. That's going to be your job to determine. It's not a question of age or experience. We talked about that. This is one of those jobs where you kind of learn on the job. And so it's important that you fully understand that. And that's why voir dire was so very important, as we ask you all of those questions before you were sequestered, before you were actually picked. Now, each of you filled out the questionnaire, and you answered the questions honestly, I'm sure. You know, Cicero said a long time ago that he who violates his oath profanes the divinity of faith itself. And of course, both sides of this lawsuit have faith that you live up to your promises. And I'm sure you'll do that. You know, Abraham Lincoln said that jury service is the highest act of citizenship. So if it's any consolation to you, you've been involved in that very highest act of citizenship. And so again, we applaud you and we thank you as we move toward justice. One other entity or group of ladies, or two ladies that I should thank, are our marvelous court reporters. They have been patient with us. They've been here from the very beginning. We very much appreciate them and their services, and I especially appreciate them because sometimes I speak rather rapidly, and they have a tough time keeping up with me. So I trust that today, if I start to speak too fast in my zeal, Ms. Moxham and Chris will bring that to my attention. I'm sure they will. Now, in the course of this process where we're discussing the reasonable inferences of the evidence, I ask you to remember that we're all advocates. We're all officers of this court. I will recall the evidence and speak about the evidence. Should I misstate that evidence, please don't hold that against Mr. Simpson. I will never intentionally do that. In fact, I think you'll find that during my presentation, unlike my learned colleagues on the other side, I'm going to read you testimony, what the witnesses actually said, so there'll be no misunderstanding about what was said about certain key things. But remember that we're all advocates. And I think it was Ms. Clark who said, saying it so doesn't make it so. I think that applies very much to their arguments. Ultimately, it's what you determine to be the facts. It's what's going to be important. And all of us will live with that. You are empowered to do justice. You are empowered to ensure that this great system of ours works. Listen for a moment, will you, please? One of my favorite people in history is the great Frederick Douglass. He said shortly after the slaves were freed, quote, "In a composite nation like ours, as before the law, there should be no rich, no poor, no high, no low, no white, no black, but common country, common citizenship, equal rights, and a common destiny." This marvelous statement was made more than 100 years ago. It's an ideal worth striving for, and one that we still strive for. We haven't reached this goal yet, but certainly in this great country of ours, we're trying. With a jury such as this, we hope we can do that in this particular case. Now, in this case, you're aware that we represent Mr. Orenthal James Simpson. The prosecution never calls him Mr. Orenthal James Simpson. They call him defendant. I want to tell you right at the outset that Orenthal James Simpson, like all defendants, is presumed to be innocent. He's entitled to the same dignity and respect as all the rest of us. As he sits over there now, he's cloaked in a presumption of innocence. You will determine the facts of whether or not he's set free to walk out those doors or whether he spends the rest of his life in prison. But he's Orenthal James Simpson. He's not just the defendant. And we on the defense are proud, consider it a privilege to have been part of representing him in this exercise and this journey toward justice. Make no mistake about it. Finally, I apologize to you for the length that this journey has taken. But you know, when you're seeking justice, there are no shortcuts. If you were to trade places with either side, you'd want someone who'd fight hard for you and vigorously, especially who was a person who had maintained their innocence from the very beginning of the proceedings. Some of you in voir dire talked about that you've been involved in other cases where you felt the lawyers didn't stand up. Well, I certainly hope that in this case, on both sides, you felt the lawyers did their best to represent their respective positions, and we will continue, I'm sure, to do that, so that, although I apologize for the length of the trial, I hope and I trust that you will understand that in a journey toward justice, there is no shortcut. Finally, with regard to your responsibilities, we ask you at the very beginning to don't compromise. This is not a case for the timid or the weak of heart. This is not a case for the naive. This is a case for courageous citizens who believe in the Constitution. And while I'm talking about the Constitution, think with me for a moment. How many times you heard my learned adversaries say, the defense didn't prove, the defense didn't do this, the defense didn't do that. Remember, back in voir dire, what did the judge tell us? Judge Ito said the defense could sit here and do absolutely nothing. One of you is from Missouri, and he reminded you, who's from Missouri here? Say to the prosecution, you show us. Now, we didn't do that. But we don't have an obligation, as you'll see. You've heard from the jury's instructions, and at the end I will show you some others. We don't have to do anything. We don't have to prove anything. This is the prosecution's burden. And we can't let them turn the Constitution on its head. We can't let them get away from their burden. My job, one of my jobs, is to remind you of that and to remind them of that that's their burden. They must prove Mr. Simpson guilty beyond a reasonable doubt and to a moral certainty, and we will talk about what a reasonable doubt means. And so now, as we have this opportunity to analyze the facts of the case, I agree with one thing that Mr. Darden said. To this task, I ask you to bring your common sense. Collectively, the 14 of you have more than 500 years of experience. I know you're all young, but you multiply by 14, you won't hold that against me, I don't think. 500 years of experience. You didn't leave your common sense out in that hallway when you came in here. And we're going to ask you to apply it to the facts of this case. I'd like to comment and to compliment Ms. Clark and Mr. Darden on what I thought were fine arguments yesterday. I don't agree with much of what they said, but I listened intently, as I hope you'll do with me. And together, hopefully, these discussions are going to be helpful to you in trying to arrive at a decision. In this case, where you don't compromise, where you don't do violence to your conscience, but you do the right thing. And you are the ones who are empowered to determine what is the right thing. Let me ask each of you a question. Have you ever in your life been falsely accused of something? Have you ever been falsely accused? Have you had to sit there and take it and watch the proceedings and wait and wait and wait, all the while knowing you didn't do it? All you could do during such a process is to really maintain your dignity. Isn't that correct? Knowing that you were innocent, but maintaining your dignity and remembering always that all you're left with after a crisis is your conduct during it. So that's another reason why we're proud to represent this man who's maintained his innocence and has conducted himself with dignity throughout these proceedings. Now, last night as I thought about the arguments of my colleagues, two words came to mind. I asked my wife this morning to get the dictionary out and look up two words. The two words were speculative and cynical. Let me see if I can get those words that she got from me. Excuse me one second. I asked her, as I was thinking about this case, to go to Webster's, and I want you to tell me what does it mean to speculate? What does it mean to be cynical? As I thought about my colleagues' arguments and their approach to this case and their view of this case. Cynical is described as contemptuously distrustful of human nature and motives, gloomy, distrustful view of life. And to speculate, to engage in conjecture and to surmise, is to take to be the truth on the basis of insufficient evidence. I mentioned those two definitions to you because I felt that much of what we heard yesterday and again this morning was mere speculation. Understand this, ladies and gentlemen, that none of us in this courtroom were out at 875 Bundy on June 12, 1994, after 10:30 or 10:45 in the evening. So that everything we say to you is our best effort to piece together what took place in this case. When people theorize about things that may have been and talk to you about short fuses, you're going to see that's just that. It's speculation. People see things that are totally cynical. Maybe that's their view of the world. Not everybody shares that view. Now, in this case, and this is a homicide case and a very, very, very serious case. And of course, it's important for us to understand that. It is a sad fact that in American society, a large number of people are murdered each year. Violence, unfortunately, has become a way of life in America. And so when this sort of tragedy does in fact happen, it becomes the business of the police to step up and to step in and to take charge of the matter. A good, efficient, competent, non-corrupt police department will carefully set about the business of investigating homicides. They won't rush to judgment. They won't be bound by an obsession to win at all costs. They will set about trying to apprehend the killer or killers and trying to protect the innocent from suspicion. In this case, the victims' families had an absolute right to demand exactly just that in this case. But it was clear, unfortunately, that in this case, there was another agenda. From the very first orders issued by the LAPD so-called brass, they were more concerned with their own images the publicity that might be generated from this case than they were in doing professional police work. That's why this case has become such a hallmark. And that's why Mr. Simpson is the one on trial. But your verdict in this case will go far beyond the walls of Department 103, because your verdict talks about justice in America, and it talks about the police and whether they're above the law, and it looks at the police perhaps as though they haven't been looked at very recently. Remember, I told you, this is not for the naive, the faint of heart, or the timid. So it seems to us that the evidence shows that professional police work took a back seat right at the beginning. Untrained officers trampled. Remember, I used the words in the opening statement. They traipsed through the witness, through the evidence. And it was interesting because the prosecution didn't agree with that at the beginning, but later on in this trial, we heard Mr. Goldberg and talking to witnesses use my words, traipsing through the witness scene. That scene there at Bundy. He used our words because they understood. We knew what we were talking about. We were able to demonstrate it through the videos. They delayed unconscionably routine procedures in notifying the coroners. They didn't call the criminalists out on time. And yes, they allowed this investigation to be infected by a dishonest and corrupt detective. They did that in this case, and they may try to back away from it all they want, but that's very important, as you're going to see, to this case and the resolution of my client's innocence. Because of their bumbling, they ignored the obvious clues. They didn't pick up paper at the scene with prints on it. Because of their vanity, they very soon pretended to solve this crime, and we think implicated an innocent man. And they never, ever looked for anyone else. We think they'd done their job as we have done. Mr. Simpson would have been eliminated early on. And so this case is not, let me say at the outset, is not about attacking the Los Angeles Police Department. We're not anti-police in making these statements. You're not anti-police. We all need the police. I just said we have so much crime in this country, we need the police. But what we need, and what we must demand, what all of us should have, are honest, effective, non-biased police officers. Who could demand less? Can any of you say that's not what we should have? And so let me tell you about how we're going to proceed here this afternoon. The defense has one opportunity basically to address you. This is after the prosecutors are finished. I will address you first, and after I'm concluded, and I will talk generally about the lay witnesses and an overview of the evidence and what you've heard. I'll strive not to bore you. I'll strive to be honest in my discussions, to be relevant, to be concise in what we talk about here. When I'm finished, Mr. Barry Scheck will come before you and address some of the forensic issues. And then finally, after Mr. Scheck finishes, I'll come back and conclude some concluding remarks regarding what you've heard over the course of the last 2 days at any rate. Now you understand that because the prosecution bears the burden in this case and in all cases, Ms. Clark will argue last to seek to rebut that which we bring up. And presumably she won't be back up here talking about all kind of new things. Seek to rebut that which we bring up. And let me tell you in front, if she brings up anything, we may be precluded from standing up and saying, wait a minute, Your Honor, here's the answer to that. But you can then substitute your common sense, your judgment in that place. And that's required in this journey toward justice. Now, at the outset, let's talk about this timeline for the defense. I said earlier that Mr. Darden did a good job in his argument. But one thing he tended to trip over and stumble over was when he started to try to talk about our case. He doesn't know our case like we know our case. It was interesting, wasn't it? Because first he stood up and started talking about the timeline being at 10:15. Then he said, well, they didn't prove anything, but golly, well, it may have been as late as 10:30. That's interesting, isn't it? Never heard that before. You look back and see what Ms. Clark promised you a year ago. 10:15. 10:15 was all they talked about. And they were going to use, because of the incompetence of this investigation, the wail of a dog. So we've been relegated to in this case because of this very, very poor investigation. But having said the defense doesn't have to prove anything, in this case, we did, in fact. And so Mr. Darden could talk all he wanted to about his theories about motive. They're just that, his speculative theories about motive. But when he came down to the end, he wasn't talking about motive, was he? He was trying to talk about our timeline. Why would he do that? Let's talk about why he would. Because the defense in this case called many witnesses who corroborate each other and who shatter the prosecution's timeline. Now, these are witnesses to a person who were known by the prosecution but discarded by the prosecution. Why? Because they didn't fit their tortured, narrow window of opportunity. So when you would visualize for me that jigsaw puzzle, where they want to reduce this case down to a jigsaw puzzle, the part that deals with opportunity is the timeline. And we're going to start off with that because in a search for truth, let's look for the truth. Not some contorted, twisted truth, but the real truth, the facts that you've heard during the course of this particular case. We think after you look at this timeline for the defense, you will agree with our earlier analysis. This is a case about a rush to judgment, a case where there's been an obsession to win at all costs, and in the words of Dr. Henry Lee, something is wrong with the prosecution's case. Let's start off with Francesca Harmon. Francesca Harmon is the lady who left the dinner party on Dorothy at about 10:20 p.m. She drove west on Dorothy and Bundy and turned north on Bundy, so she'd be heading north toward 875. She saw nothing, heard nothing, no barking dogs. It's a lady known, of course, to both sides. And so you see this graphic regarding Francesca Harmon. And I think to familiarize you with that, I think at 10:20, as I understand, that's the approximate time that she would pass by or near Nicole Brown Simpson's home there. Oh, you see it with the X mark there in this graphic. That's Miss Harmon. We followed Francesca Harmon with Ellen Aronson and Dan Mandel. Remember the two people who'd been on their first date? They'd gone to Metzaluna. And they were interesting young people. I think you would find them credible. And by the way, you hold all witnesses up to the same standard. No side has a priority on the truth. These are witnesses known to both sides. We're the ones, however, who elected to call them and bring them here for you. You know how they walked home from this first date at Metzaluna, walking directly by the walkway at 875 South Bundy. And they said they passed by there. Remember, they were clear. They passed by there at 10:25. And you'll see the little kind of purple lines. Shows you the route they took. So they passed right in front of Miss Nicole Brown Simpson's home at 10:25. And you remember, they continued on. So they were over on Darlington Street by 10:29. She said that it took them about 4 minutes from the time they passed 875 South Bundy to get home that evening. This was their first date, and I guess, as I recall, this was also their last date. They saw no blood. They saw no barking dogs. I submit to you, if the bodies had been there, they could have been seen. Now, why do I say that? I say that because we have a contact print in evidence I'm going to ask Mr. Harris, if he can, to show us this contact print. This is an item you'll be able to take back in the jury room. Now, this is a photograph taken by Mr. Rokar at night, and it will let you see, Mr. Harris gets it focused, that scene that particular night, what you could see with regard to this body. Your Honor, you may want to cut the feed on part of this. $33, Howard. Now, and this exhibit is what number, Mr. Do you have it? I believe it may be 86. I'll get it for you as soon as he takes it off, Your Honor. Now, this exhibit, and we'll try to give them to you, Your Honor, just when we first get them up there.
Thank you.
This exhibit, number 86, was a photograph that we got late in the trial from Mr. Rokar. The photographer was called by us. You see that document over there? That's a contact sheet. Remember, he talked about all of these photographs in sequence in this first roll were taken at night. This is going to be a very, very important role for you as this case progresses. This is a photograph at night of what you could see from across the street, and there were lights in and around there. And so when Mr. Darden stands up here as an advocate and tells you it was pitch black and you couldn't see anything, this is the photograph that was taken before the sun came up. This photograph was taken at night. It's not pitch black. We know also that according to the evidence, blood had flown down that walkway. There were bloody paw prints that went southbound on Bundy there. So you see that photograph? You see that photograph? Now, you can be an advocate, and we're all sworn to do the right thing. We talked about his oath. Well, your oath is also to tell the truth. It's not pitch black. We have the evidence. And I'm going to try to do that throughout. Where they have misled you or not said things that weren't correct, I'm going to try to straighten it out for you. Mr. Harris, why don't you tell the court now what that number is? So it's number 1369, and that's Mr. Rokar. We're going to come back to some other photographs on that, but you'll recall his testimony. And the reason why 1369 is so important is because it is undisputed that at 10:25, Mandel and Aronson walked past there. If there was blood down on that sidewalk, if there had been a killing had taken place, if there were dogs barking or wailing, don't you think, given that, and you've been out there, you'd see it. So the time has come now to stop all this folly and fantasy. Let's deal in reality and in the facts of what took place and what you can see with your own eyes. I don't want you to speculate or theorize. When I sit down, I want you to understand what the facts are of this case. Hey, Mr. Harris, you can take that down. After that, we had Denise Pilnack and Judy Tillander. You know, and I think, again, as advocates, we have a responsibility to treat all of these witnesses with respect. These people didn't ask to come down here. These people don't ask to be maligned. I don't think anybody really wants that, with the exception of one or two. And most of them were called by the prosecution. So when Denise Pilnack, the lady who wore 2 watches, comes in here and tells you, I ask you to judge her credibility like you do all the witnesses. The court has instructed you. You hold all witnesses up to the same standard. You look at the reasonableness of what they have to say. You look at their bias or interest. You look at their demeanor on the stand. You use your common sense. You use your visceral reaction, if I can use that word, to make a determination of whether or not you think this person is telling you the truth. None of these people know or knew O.J. Simpson. With the exception of the people who are together, they don't know each other. They're witnesses available to both sides. But in the search for truth, we're the ones who subpoenaed them and brought them in. Let's look at Denise Pilnack. She tells you that she was at home with her friend Judy Thielander. She's across the street from 875 South Bundy. She's south and across the street. You recall that. She spoke of how eerily quiet. Remember those words? It was at about 10:24 p.m. when Thielander left her house. And she remembered that because she wanted to get Thielander out of there. She'd been there all day, and she wanted to use a computer or something to type some letters. Remember that? So she went outside on the porch with Thielander, as I recall, and Pilnack just didn't come to you and tell you that. Pilnack did something else. She, and I believe, Your Honor, that's Exhibit 1237. She showed us
Phone records.
the phone record, Your Honor. She showed us that she got on the phone as soon as Pilnack left and called her mother, remember she said, in Gardena. And you look there on June 12th at 10:25 p.m., she made a call to Gardena. She was able to fix the exact time that her friend left. And she said to us something very interesting, that there was quiet when her friend left, and the quiet continued for at least another 10 minutes. So that would be 10:25 to 10:35 at the earliest. She says that at 10:35, it's the first time she heard dogs barking loudly that particular night. And so that she, as you will see along with Robert Heidstra, confirm each other. They don't necessarily know each other, but they confirm each other as to when this barking really began. Now, they weren't laying in bed and had been asleep like Eva Stein. They weren't like Miss Elsie Testert, who's across the street, who didn't really know what was happening. These are people who are either outside or in that area who can come in here and tell you why they remember these particular times. They were wide awake, up and about, outside, around the time when this barking took place. Then we call this man Robert Heidstra. You know, because it came out that Robert Heidstra had been talking to the prosecution. You remember what he said. Now, this is the man who's an interesting man who details cars. He's the man who is well known to the prosecution. Remember, he talked to Detective Payne almost right away during the investigations, to Payne. And he told Payne the same thing he told you during the course of this trial. Here's what he said. He says that he lives nearby, and he has these two elderly dogs, one of whom I recall was 14 years of age. And so these dogs walk kind of slowly. Remember that? He walks and he takes this route. Now, that graphic up there shows you the route he takes. Remember, he told you he left home a little bit late that particular Sunday evening. So 10:15 he leaves home, and he proceeds on this route. And you know he's in that alleyway that runs parallel with Bundy. And he knows this neighborhood. He's been doing this for more than 14 years. He knows not only the neighborhood, he knows the dogs, he knows their barks, he knows the gates, he knows when they clank, he knows all of that. And isn't it an interesting situation? When you thought that of all the witnesses in this trial, in this journey toward justice, this is the only witness who ever heard any voices. But they didn't call him. You know why? Because it doesn't fit in their timeline, as you're going to see. And so he tells you that, and you recall, he's directly opposite Miss Nicole Brown Simpson's condo in that alley when he hears what he believes is the Akita start barking. And that's at about 10:35 p.m. He recognizes, he says, the Akita's bark since he walks that way, that same way, each and every evening. So while in that alleyway, east of 875 South Bundy, here's a voice yell, hey, hey, hey. And he says he then hears a gate slam. Now he goes on and says that at about 10:40, 10:45, he sees this white vehicle, which he describes clearly as a van or a Jeep. Now they would try to tell you all these things about it being some Bronco, but he never said anything about any Bronco. He said a van or a Jeep. And the important part was, that's what he tells the detective, but he says it goes southbound on Bundy, away from where Mr. Simpson would live. And could you imagine in this area, in West Los Angeles, in Brentwood, the number of white vehicles there are and must be in that particular area? But the reason why they didn't call him was because at 10:45, O.J. Simpson cannot be guilty of this crime, can he? Now, how do we know that? How do we know that, ladies and gentlemen? Well, yesterday, in her zeal and advocacy, Ms. Clark tried to push the time back from 10:40 or 10:45 that Cato heard those thumps. She tried in her chart there to push it back, remember, to 10:53. Some of you probably were surprised. There's been no testimony about that. So let me tell you, let me quote for you. Counsel, this is page 19873. This is Ms. Clark talking to one of her favorite witnesses, Mr. Cato Kalin. By Ms. Clark. And what happened with that picture when the thumps occurred? The picture tilted from, that would be right to left. The picture moved. Answer, yes it did. At that point that you heard the thumps on the wall, sir, approximately how long had you been on the phone with Rachel Ferraro? Remember, he called his friend, called his girlfriend. About a half hour. Just after he went back in the house, he called his girlfriend. And so approximately what time was it when you heard the thumps on the wall? Answer by Mr. Kalin, at about 10:40. At about 10:40. Now this is the time when the dogs first start to bark over there. At about 10:40. Is that exact 10:40, Ms. Clark says? Well, what I remember, I didn't look at the clock, but around 10:40. Question, do you recall previously testifying that it was 10:40 to 10:45? Answer, yes. Question, okay, and is that correct? Answer, yes. Now, that's their witness. That's their witness. That's what he has to say. There's no question he's there. They know he's there. You know he's there. They don't call him. What about this search for truth? Can they handle the truth? You will be making that kind of decision. And so, we then know, according to this, that by the time Hydra sees this vehicle turn south on Bundy, Cato Kalin has already heard the 3 thumps on the Rockingham wall outside of his room. And you know, that's so interesting because yesterday Ms. Clark tried to change how those thumps sounded. Now remember, this is something that you will never forget probably. I won't come all the way over there, but let me just see if I can duplicate. Cato Kalin said, here's how he said those thumps sounded. 1, 2, 3. Except he used that place up there. He said they were thumps. Almost like a signal. 1, 2, 3. Is what he had to say. And of course, you'll recall that. Your notes are much better than ours, I'm sure. Apparently the prosecution, in their zeal and their obsession to win, would have you believe that Mr. Orenthal James Simpson is so amazing that he can be in 2 places at the same time, even though they're miles apart. And when Darden was talking to you today, remember he used Heitzer to say, well, on a Sunday evening, you could make it over there in about 4 minutes. And he said that? Well, in their own drive-through, that Van Adder did, took between 5 and 6 minutes. You saw it. Took close to 6 minutes. He didn't tell you that again today. And if you want to get a flavor for how, we heard the word desperate a couple times, but how witnesses were treated. Just ordinary witnesses, regular citizens. Let me share with you a transcript regarding Heitster. Counsel, I'm going to be looking at 36368 through 36370. This is how Mr. Darden treated this witness who helped to shatter their timeline and establish O.J. Simpson's innocence. Didn't you tell us yesterday that the voice was a youthful voice? Yeah, it sounded like a young voice. Okay. And when you heard that voice, you thought that that was the voice of a young white male, didn't you? And there was an objection, you may recall. The voice sounded like the voice of a white male, Mr. Darden said. Answer, how could I say that it is a white male? I don't know the voice. It could be anybody there. Question, did you ever tell Mr. Stevens, my investigator, that it sounded like a white male? Answer, no. Never saw Mr. Stevens come in here and say that. Never said that? Answer, I don't recall that at all. I said it was a clear voice, but never what kind of white or brown or yellow. And then there was that second voice, correct? Right. And that second voice, that voice sounded deeper than the first voice, didn't it? Answer, a little bit, but I couldn't hardly hear it with the dogs, the commotion, with two dogs there. It was very short. Did you ever tell anyone that the second voice was a deep voice? Answer was deep. It was deeper than the other one, than hey, hey, hey. Okay. And then we get to the question. At line 22, counsel. The second voice that you heard sounded like the voice of a black man. Is that correct? Objection. The witness, of course not. Now, you know, we can be advocates. Those questions, nobody ever came in to impeach that man. He told you he heard two voices. He told you when this took place. He told you why, because he walks his dogs. He knows that neighborhood. A search for truth, you see, their job is not to just try to convict. Their job as prosecutors is to make sure the innocent go free also, to make sure all the witnesses come to your attention, as we've had to do in this case. So you can see that these responsible citizen witnesses who came before you were oftentimes treated roughly and ridiculed and attacked by the prosecution in their obsession to win. You don't think Heister was attacked? Remember, he was asked the question, something to the effect, are you a citizen here? Because he's from France, apparently. And something about his job and his little apartment, because he's a car detailer. Everybody is entitled to dignity. That's what we fought for in this country. You don't treat witnesses who just come in here, they don't get paid to tell the truth like that, just purely and simply because they're not saying what you want them to say in your contorted version of what the truth ought to be. But you saw that yourself. I don't have to tell you about it. Interestingly enough, they chose not to mention even one of the defense witnesses in Ms. Clark's discussion of her timeline. The prosecutors noted that none of their timeline witnesses asked to be involved in this case. Well, none of the witnesses that we call asked to be involved in this case. They came forward. You saw how they were treated. But yet they told you what they observed. But perhaps the most important thing about them is these aren't any family members. These aren't people who know O.J. Simpson. These are just people who happen to be out there that particular night. And I think you can now see from that graphic how they all passed by there. We tried to make it as clear as we could. It's common sense. It's common sense, just like he said. It becomes very, very clear right at the outset. So if you accept the prosecution scenario, there's not enough time for O.J. Simpson to commit these murders, given the evidence that we understand. Let me just succinctly at the beginning help you understand where I'm going on this. Remember Bodziak, that they like to talk about so much? When F. Lee Bailey cross-examined Bodziak the first time he was here, remember Bailey got him to say this remarkable thing about whoever left out that back gate turned and went back the other way. It's pretty interesting because I didn't see all those prints, but that's what he says. They went back to the scene. Remember that? That's what Bodziak said. Darden said this morning. The killer or killers that went that way, they weren't in any hurry. They went that way and then came back. You take that along with the fact that the credible evidence regarding this struggle is it took between 5 to 15 minutes. Now that's what Dr. Henry Lee, Dr. Michael Batten said. They not only told you that, they showed you why that was true. You know, while I'm about it, just to digress for just a moment, Mr. Darden talked this morning about calling witnesses and not calling witnesses. Isn't that interesting? Now, they're the prosecutors. They are the ones who have the burden. In the history of man runneth not to the contrary. Nobody around here can remember any time that the coroner who did the autopsy, the actual autopsies on these bodies, wasn't called by these prosecutors. Why do you think that was? They didn't call the coroner. They chose instead to call Dr. Lakshmanan, who came in here. They showed you what they thought about him. They talked about this man so badly. I mean, for 8 days, we heard Dr. Lakshmanan talk to you. They talk about length of time in this trial. Let me put that in perspective for you. For 8 days, Lakshmanan sat on that stand and went through direct examination by Brian Kilburn. Check your notes if you think I'm wrong about that. Bob Shapiro got up and took 3.5 hours and demolished him, because at the end of the day, Lakshmanan told you this. Well, these were deaths that were caused by stab wounds. And the time of death was between 9 and 12. Remember all those discussions about big-ticket items and big-ticket items? And when you get back in the jury room, you'll have a lot of fun trying to figure out all those red and blue marks that they drew all over the corners. They spent 8 days trashing their own coroner. And they didn't call him. Now, why is that in this search for truth? They call somebody else who's not even there at the autopsies, who has the benefit of our experts, Michael Batten and Barbara Wolf, who point out to him the mistakes that Golden has made. He then runs in here and testifies about those mistakes that we had discovered. Remember, ladies and gentlemen, in this search for truth, our experts were in place right away. O.J. Simpson was paying for these experts to find the killer or killers. And you'll recall the evidence that Dr. Lee, Michael Batten, Barbara Wolf were offered to them at the beginning. So the idea is that from the beginning, there was this search for truth. So I mentioned that parenthetically at this point because I think it's important. We talk about not calling witnesses. In every murder case, it's basic that you got to call the coroner. But they did a number of things in this case, ladies and gentlemen, that had never been seen before. Off the top of our heads, 4 detectives going to the scene to notify somebody who's not even the next of kin. The detective carries blood 25 or 30 miles around in his pocket. They do things that you have never heard of before. In this case, is it because it's Orenthal James Simpson? And so as we look then at the timeline and the importance of this timeline, I want you to remember these words. Like the defining moment in this trial, the day Mr. Darden asked Mr. Simpson to try on those gloves and the gloves didn't fit. Remember these words. If it doesn't fit, you must acquit. And we're going to be talking about that throughout. So to summarize, if you take the witnesses who we presented, who stand unimpeached, and if you are left with dogs starting to bark at 10:35 or 10:40, let's say, and we know from the most qualified individuals, Henry Lee and Michael Batten, this was a struggle that took from 5 to 15 minutes. It's already 10:55. And remember, the thumps were at 10:40 or 10:45. O.J. Simpson could not be guilty. He is then entitled to an acquittal. And we have talked to you, and you've heard from the court, and my colleagues talked to you about this whole idea of circumstantial evidence. I want to talk to you a little more about that now. We've shown you the incredible evidence that it would be impossible. O.J. could not, would not, did not commit these crimes. And where you have a circumstantial evidence case, this becomes very, very important. The prosecution then must disprove our timeline beyond a reasonable doubt. And if they don't, you must acquit. He would then be entitled to an acquittal. So let's see if we can look quickly at this jury instruction, sufficiency of circumstantial evidence generally. Mr. Douglas is going to help me today. Have just a second here.
Fairly.
Douglas? Now, in both places, you can see this instruction. It's called sufficiency of circumstantial evidence, evidence generally. And to be as accurate as possible, let me allude to all of it, lest I favor one portion or the other, and together we can consider it. This is the law that His Honor has already given you as relates to circumstantial evidence, which this is in this case, about opportunity to commit these crimes. However, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only, one, consistent with the theory that the defendant is guilty of the crime, but two, cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count, either one of these counts, is susceptible of two reasonable interpretations, one of which points to guilt, the other which points to innocence, you, as jurors, must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. I put that up at this very moment because you've just seen the timeline, which is circumstantial evidence of O.J. Simpson's innocence because he couldn't have done the crime given this time. So under that scenario, even if the prosecution's timeline was reasonable, if they're both reasonable, I think you must agree ours is reasonable, it becomes your duty to adopt that which points towards innocence. But even further, if theirs is unreasonable and ours is reasonable, he's still entitled to an acquittal. The only way they're entitled to conviction, ours is unreasonable and theirs is reasonable. And I think you can see and understand that's not true. That shouldn't happen. That's not the facts of this case. So before I look at their timeline, let me just see if I can summarize what I believe the prosecution has tried to tell you about their theory in this case. And this is just kind of rough, but listening to them yesterday, they tried to tell you that an insanely jealous man stalks his ex-wife, stabs her and a male visitor in a murderous rage, leaves a trail of blood to his home, barely catches a plane for Chicago, in a rush to go there, leaves one glove at the murder scene and one glove behind his house. In the defense of this case, you have heard evidence about O.J. Simpson's great life. Not only was he have a great life, he had a great day that day. playing golf, comes back from being out of town all week long, comes back to go to his child's recital. He goes to that recital, prepares in the evening, gets something to eat, a hamburger. By the way, I have to stop at this point. I'm glad Miss Clark doesn't know this, but you know, if you've ever been to McDonald's, they don't like you to bring $100 bills in there. You know, you can't get $100 bills changed there generally. So some of these things about common sense, some people don't know.
Beyond the evidence here.
Well, all right, thank you.
Proceed.
Use your common sense about fast food places. He then takes a shower, barely catches his plane in Chicago. Someone murders his wife and this male visitor for reasons unknown in this trial. Others seek to implicate him as the most obvious suspect. The investigation becomes a tragic combination of sloppy errors and cover-ups to try and achieve his conviction. Those are going to be pretty much the hypotheses that you've heard and will be hearing in this case. Under whatever scenario, based on what I've already told you in this first hour of the argument, this man is entitled to an acquittal. But let's now turn briefly to the prosecution's timeline scenario. And you heard Ms. Clark yesterday talk about this timeline and talk about these witnesses, and she relies very heavily on this Pablo Fenves. You remember him. He's one of the early witnesses who started off, I think, talking about a plaintiff wail of a dog at 10:30, and he got pushed back to 10:15. But it's interesting because now Darden, not Marcia Clark, has now come back and conceded, well, you know, maybe it really was later. They did a pretty good job. You know, so he's saying that. But Fenves told us that he's in that alleyway, down the alleyway and across from Nicole Brown Simpson lives. 10:15, 10:30, whatever, 10:20. Eva Stein, next door, was asleep. Claimed she was awakened. You ever wake up at night? You might see the time right, you might not. She says about 10:20 or so, she thinks she hears dogs barking. Well, I presume that dogs bark throughout that neighborhood all the time. And we don't know, and that's the problem with trying to convict somebody or set the time of death by a dog barking. Louis Karpf, her boyfriend, comes home sometime after 10:20. And then, of course, Miss Elsie Tistert, the lady from across the street, doesn't know when or what was precisely when she heard the barks. Then there's Mark Storfer. And Mark Storfer is an interesting man because you remember he's the man who always set his watch 5 minutes fast, he says, presumably. He told us here in testimony, counsel 17190, says at 10:28 is when I looked at the TV, which was a couple of minutes after I'd gotten in the room. Right? Okay. And then he talks about, I looked out the window of our bedroom that faces North Bundy to see if I could see where that dog was or what was going on. It was pretty dark, and I couldn't see anything unusual, and I couldn't locate the dog. I also looked out the west-facing window of our bedroom to see if the dog was further over to the west. We faced the alley on the west side, and I could not see anything at that time either. Now, this witness becomes kind of important, doesn't he? Because the prosecution is going to tell you that no matter what time it is, whether it's 10:40 or 10:45, or whether it's 10:15 or 10:20 or 10:25, or Mr. Darden makes this big quantum leap. The Bronco was there. Where's Mark Storfer, who looks down that alley, and what exhibit is this, Mr. Harris? Do we know? Exhibit number 38, Your Honor. This is looking northbound down that alleyway. And you recall this because we've all been out there, and you'll recall where Miss Nicole Brown Simpson's condo is located, and you'll recall that it's sitting out in the driveway there, right there. It was a black Jeep Cherokee, as I recall. And you see, this man can presumably look up this alleyway. He didn't see any white Bronco. Nobody ever tells you about any white Bronco parked back there. Doesn't tell you about any car parked back there. So when you see people tell you about mountains of evidence and oceans of evidence, their oceans soon become little streams. Their mountains become molehills when you look at the facts. And so we go on. In addition to Mark Storfer and looking up that alley and seeing nothing or seeing no car or doesn't see a dog, we hear about the other witnesses who become pretty much part of the timeline. Ms. Clark does take some licenses regarding time. She says that Mr. Goldman leaves Mezzaluna, she says about 9:50 p.m. Says he goes home and he changes clothes, that he talked to Stuart Tanner about getting together later that evening. Remember that? Talked about going to Baja Cantina out at the marina. You know, wouldn't you think it would be logical to expect if he worked all day, when he went home to change clothes, he might have showered, he might have gotten something to eat. Especially if later on, when you hear Mr. Scheck, you look at the amount of food, undigested food, that was still in the stomach of these two victims. But in a rush to judgment, in a rush to contort these facts, Ms. Clark tells you yesterday, let's give him 5 minutes. He's been working all day, he's got to change clothes, he's got to come home. Let's give him 5 minutes or 10 minutes. Be correct, she says, let's give him 10 minutes. That seems to me to be really, really fast. And what it really is, ladies and gentlemen, is more of that speculation. She doesn't know how long Mr. Goldman was there. None of us know that. We know he changed clothes. She has absolutely no idea. But so you understand that when you look at when somebody says something like that to you. And then as part of their timeline, she tells you yesterday that there's something sinister in Mr. Simpson seeking change to buy a Big Mac from McDonald's. I suppose that if you're in this jealous rage, if the fuse is running so short, it's interesting, isn't it, to stop, go get a hamburger at McDonald's. Does that make any sense to any of you? Does it make any sense to you to drive to McDonald's? And there's no evidence that he tried to tell Cato Kalin not to come. The evidence is that these two men got in the Bentley and went to McDonald's. The evidence is that while O.J. Simpson is in this murderous rage, he's worried about money to tip the skycaps at the airport because he has $100 bills. So he gets $20 from Cato Kalin. What's unusual about that? Cato Kalin's living there for free, so I suppose he could give him $20. Then Cato Kalin wants to go get something to eat. And Ms. Clark says they could have gone to a restaurant. Well, you could do anything, I suppose, but the facts are they went to McDonald's to get a hamburger. O.J. Simpson ate the hamburger. Presumably, he was hungry. Now, what's sinister about that? Unless you're cynical in your view totally of this case. Cato Kalin, their witness, they called him. They turned on him. You observed him. I ask you to hold him up to the same standards you do all the other witnesses. But I ask you, don't misquote him. Tell the truth about what he had to say. And so when he says 1040 or 1040 to 1045, don't try to make it 1052. So if you believe in this prosecution's theory, there's this blood leading down to this rear walkway, and Ms. Clark told us yesterday and unveiled her theory. Here's what they ask you to believe. O.J. Simpson comes home from these brutal murders in a Bronco that he must be driving awfully fast to get back in this time frame. He parks this Bronco out there, the Rockingham gate, somehow gets in the gate, gets down the side of his house, and what does she tell you? He bumps into the air conditioning. Now let's examine that for a minute. The evidence is that O.J. Simpson has lived at this house for 17 years. Who do you think knows this place better or the best of all? This is his estate. This is where he lives. This is where he's raised his children. This is where he's been married. This is where he had 2 marriages. He knows this place. So as part of their fantasy, their theory, their speculation, they have O.J. Simpson walking down this walkway, running into an air conditioning. Well, he ran into the air conditioning. Where's all the bruises that he got from running the air conditioning? Where's the sound that he made? That doesn't make any sense. You see, the reason why they come up with this running into the air conditioning, because they can't say he climbed over the fence, because there's too much shrubbery there and it's not broken. Now, you really don't know if he could climb over the fence with this arthritis. But they have him then walking down this walkway, bumping into the air conditioning. But ladies and gentlemen, you know, we're talking about common sense here. Bumping into the air conditioning, and then he just leaves. Is that what happens? And let's look at this. Thank you, Mr. Douglas. You all remember this. And what exhibit is this, Mr. Douglas? Excuse me. I'll stand over here so I won't be in your way. Thank you. Under this scenario, under their scenario, while Allen Park is out here somewhere looking over in this direction, they have O.J. Simpson rushing back, parking the Bronco out here, and somewhere or other, he gets all the way down here. Remember, Furman told you how far that was. Gets all the way down here where this air conditioning is, out here by Cato Kalin's room. You'll see this right here. And they have him running into this air conditioning, so he doesn't know his own house. And he's all the way back here, and she says the reason he's back here is because he's going to go back here and he's going to bury the knife in the clothes. Now, isn't that something? How does she know that? Just make that up out of whole cloth? Do you believe that's reasonable? Is that reasonable to you? Does anybody on this jury believe that? That's what you were told yesterday. He runs in this air conditioning and then just, you know, he bumps in it and he drops his glove. That's what she told you. Doesn't make any sense at all, does it, ladies and gentlemen? Doesn't make any sense at all. No sound from Cato Kalin. And then what kind of, you know, the sound has always been very confusing. Maybe not to you, but to me. Cato Kalin goes, it's more like a signal than anything else. Come out here or whatever. But those are the facts of Cato Kalin and what happened. And that's her theory. That's her reasonable, rational theory that you have to buy into, which I think that you will find to be totally ridiculous. Now remember, down this same way, there is a door into that side room there. Mr. Simpson wanted to get in his house. What would stop him from going in that side door? Who knows his house better? If he wanted to not be seen, I'm supposed that he would know better than anybody else. It doesn't make any sense. It doesn't make any sense at all, what they are now trying to tell you. And here's something else that's equally implausible. She tells you that the reason why Mr. Simpson couldn't stop and hide these clothes is because he's too famous and too well known. Remember that? She said O.J. Simpson is too famous and too well known to stop and try to hide clothes or whatever of that nature. Well, let's take that just a little bit further. Part of what makes their theory so ridiculous is it is O.J. Simpson going to get in a white Bronco that's well known in Brentwood, drive over to his ex-wife's house, park the Bronco in this well-lit alleyway that you've just seen, leave the car there, everybody knows him, knows that car. That's equally preposterous. So she can't have it both ways. He's too famous to stop and try to throw things in a dumpster, the way she put it. Isn't he equally too famous to be driving this car to go over there under these circumstances? That is preposterous. So if you believe the prosecution's theory, and they told you all this about a bloody trail, where's the blood back there, ladies and gentlemen? There's not one drop of blood. Where's the blood back there? Where's the trail that leads to that glove? And further, look at this. Look at this, ladies and gentlemen. That's something I'm making up. You're seeing this with your own eyes. Look at the glove. Now, when that glove is picked up, remember, is there any blood on the ground? Any blood on that shrubbery? Any blood on anything there? Where's the blood? Furman and Van Adder, as we discuss them later, will say that when they get that glove after 6 o'clock in the morning, it's still moist and sticky. Remember their testimony? Where's the blood on the ground? Where's the blood on the leaves around there? Where's any of that? That glove looks as though it's been placed there. That glove looks as though it's been placed there. If you look at A, you'll see how far it is out to the street. So their theory doesn't hold water. It doesn't make sense. And so they get mad at Cato Kalin. And they tell you why he's biased. He's just indebted to O.J. Simpson. So we just can't trust him. But yet they want you to trust him about the knocks on the wall. And he becomes part of their theory. But their theory doesn't make sense. And when you were back there deliberating on this case, you're never going to be ever able to reconcile this timeline and the fact there's no blood back there, that O.J. Simpson would run into an air conditioning on his own property. And then under her scenario, he still has the knife and the clothes. But what did she tell you yesterday? Well, he still has the knife and he's in these bloody clothes and presumably in bloody shoes. And what does he do? He goes in the house. Now, thank heaven, Judge Ito took us on a jury view. You've seen this house. You've seen this carpet. If he went in that house with bloody shoes, with bloody clothes, with his bloody hands, as they say, where's the blood on the doorknob? Where's the blood on the light switch? Where's the blood on the banister? Where's the blood on the carpet? That's like almost white carpet going up those stairs. Where's all that blood trail they've been banding about in this mountain of evidence? You'll see it's little more than a river or a stream. They don't have any mountain or ocean of evidence. It's not so because they say so. That's just rhetoric. We, this afternoon, are talking about the facts. And so it doesn't make any sense. It just doesn't fit. If it doesn't fit, you must acquit. And so she has him then still with the knife, still with these bloody clothes, and then she does something very unusual. Again on the time. Remember, she gave Mr. Goldman 10 minutes to get dressed and to go over to Nicole Brown Simpson's house with this envelope. Mr. Simpson, she says, who walks in this house in the walkway, and by the way, they were wrong. She was wrong about something else again I'd like to read you. She's wrong in her description of Allen Park. If I can locate it. Allen Park says he saw this figure in the walkway only. And so that we're clear about that, let me just read it to you. I don't have to just tell you what I think it is. I'm going to read it for you. 20571, counsel, line 17. Yes, I saw a figure come down, well, not come down, but I saw a figure come into the entranceway of the house, just about where the driveway starts. So a figure come into the entranceway of the house, just about where the driveway starts there. Do you see that right there, the driveway is? That's what he said. Yesterday they were trying to put it all down here and have him come, because that was convenient to their theory. But that's not what the witness said. You look at the facts of this case and you'll see, not what they tell you. Continuing it on. There is absolutely no evidence at all that Mr. Simpson ever tried to hide a knife or clothes or anything else on his property. You recall that Furman, and when I get to Furman, we'll be spending some time on him, as you might imagine, but one of the things he said was that he encountered cobwebs further down that walkway, indicating, if that part is true, and I don't vouch for him at all, there'd been nobody down that pathway for quite some time. And so she talks about O.J. being very, very recognizable. She talks about O.J. Simpson getting dressed up to go commit these murders. And just before we break for our break, I was thinking last night about this case and their theory and how it didn't make any sense and how it didn't fit and how something is wrong. It occurred to me how they were going to come here and stand up here and tell you how O.J. Simpson was going to disguise himself. Was going to put on a knit cap and some dark clothes, and he was going to get in his white Bronco and this recognizable person and go over and kill his wife. That's what they want you to believe. That's how silly their argument is. And I said to myself, maybe I can demonstrate this graphically. I'm going to show you something. This is a knit cap. I'm going to put this knit cap on. And you've been seeing me for a year. If I put this knit cap on, who am I? I'm still Johnny Cochran with a knit cap. And if you look at O.J. Simpson over there, and he has a rather large head, O.J. Simpson in a knit cap from 2 blocks away is still O.J. Simpson. It's no disguise. It's no disguise. It makes no sense. It doesn't fit. If it doesn't fit, you must acquit. Good time, Your Honor.
All right, ladies and gentlemen, we're going to take our mid-afternoon recess at this time. Remember all my admonitions to you. We'll stand in recess for 15. All right, back on the record in the Simpson matter. All parties are again present. All right, we'll let the stragglers get in here. All right, Deputy Trier, let's have the jurors, please. Please be seated. And let the record reflect that we've been rejoined by all of our jury panel members. Good afternoon, ladies and gentlemen, again. And Mr. Cochran, you may continue with your final argument.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Thank you for your patience thus far, and we'll start up again and see if we can make it to dinner. When we left, just before we broke, I was sharing with you a knit hat or knit cap that we've heard so much about in this case. And it reminded me that there was testimony early on that Detective Lang had refused basically to pick up a knit cap inside the Brown residence that was shown to him, I think, by some of the lawyers and one of the investigators on that date. I guess these are fairly common. But they don't really disguise anybody who's noticeable, do they? And although I was the guinea pig here this afternoon, if you were to put a knit cap on, how's that going to disguise you? We've been together. I'd know your face anywhere now, and you'd know mine. And the people in Brentwood, in West Los Angeles, would know O.J. Simpson. They know his car. They know him. That's where he lives. Even the prosecutors say he's so famous that he can't go anywhere where he wouldn't be recognized. Now, one of the things about this people's timeline or whatever is that you recall that some of O.J.'s bags were already packed outside of the house on that bench when Cato came outside to investigate the thumps, which he'd heard. And this is interesting because the prosecutors have kind of talked at cross purposes on this. Cato at some point comes out because he hears these thumps, allegedly. And he has a little tiny flashlight, or I think the court called it a pen light or a mag light or something like that. And it was something small because it's dark back down that walkway. And apparently he went part way down that walkway, and then he came back. It's interesting, isn't it? He came back, and at some point he lets Park in. I remember all these questions about opening the gate and everything. Remember, there's a dog there. Isn't there a dog there named Chachi? There's a lot of talk about these dogs, and you've heard a little bit about these dogs. But one thing that I think is the prosecutors make these kind of wild speculations. You now know that the Akita dog was bought by O.J., as was Chachi. Because remember, one of the dogs died, and like a good dad, he let the dog stay at the other house sometime with his son Justin. And they named the dog after Cato. Because I think the understanding of what you've heard from Arnell. But at any rate, I point that out because we know there was another dog over there named Chachi, a black dog, black chow. But while Cato is out looking for these thumps, what happens to these thumps, Mr. Simpson talks to him. In fact, they go in the house together because Mr. Simpson is going to help him look or help him find a larger flashlight. And then someone says, or he's reminded, that Mr. Simpson is running late for his trip. So then he takes off. My understanding of the facts is Mr. Simpson said, I'll call you later and have you put the alarm on. Because he was getting out of there. Parks was already there. But I think the interesting thing to remember is that some of the bags were already down, including that golf bag, were already down there. This was not any unexpected trip. He started putting things down there. If you look at everything in a cynical fashion, you heard this morning, aha, there was a knapsack over, or a nap bag, or some little bag they were talking about over in the driveway. Well, if you're a golfer, isn't it reasonable to assume there's golf balls in there? And if you put that in your golf bag, I mean, what's the big deal? Because they've got to try to theorize and try to explain everything, which they can't explain. They weren't there, they rushed to judgment, and it leads to this kind of wild speculation. You have to do that when you don't have a case. And that's all you've seen them do time after time after time. With regard to that walkway, lest I be totally clear to you, if O.J. Simpson had been the one, for whatever reason, to walk into that air conditioning, where's the hair and trace? Where's the fiber? Where's the blood? They want to tell you about his hands, fingers bleeding 1 minute, and it stops bleeding. In Miss Clark's scenario, he bleeds, it coagulates, stops bleeding, then it starts bleeding again. Because that's convenient for her theory. You know, as I listened to both of them, I wanted to call them Dr. Clark, because Dr. Clark told you, well, gee, look at that blood drop. That cut wasn't big enough for that blood drop. She's not any doctor. How does she know that? Dr. Darden, for the love and the forlorn. He knows everything about relationships and just speculates on and on and on. He's got this great, vivid imagination. The only thing is, this is real life. This isn't anything from Murder, She Wrote. If they tried to sell this story to Murder, She Wrote, they'd send it back and said, that's unbelievable. You're going to see that as we tie it together. But it's nice to have vivid imaginations, but not in this courtroom. Because here, you are searching for truth on this journey for justice. So we know that Cato had some concerns. He was looking around. We know that at some point, Mr. Simpson comes down the stairs carrying the Louis Vuitton bag or whatever, and then Mr. Simpson leaves about 11:02 for the airport. I think that's pretty clear based upon the evidence. And you'll recall that Ms. Clark again gives Mr. Simpson 5 minutes to rush in. According to her theory, he rushes in, changes clothes, disposes of all these clothes, showers, packs, does everything, and comes downstairs and says, composes himself. Now, can you imagine that? I mean, who do they think they're talking to? In 5 minutes, he does all these things. And then they tell you that, you know, under this post-homicidal way you act, you get yourself all composed and you just do this. This is preposterous. They're not experts. They can't testify. Those are just their wildest, rankest theories. You use your common sense when they tell you things like that. O.J. Simpson was O.J. Simpson. the way he always appeared by the people who knew him and talked to him. We'll talk more about that when we talk about demeanor. But the reason they can't explain his demeanor and the way he acted like he always acted, they then talk about, well, you can't tell who's a murderer. I mean, those are all real convenient words, aren't they? But they fly in the face of reasonable activity by a reasonable man on that particular night. So there's Allen Park. O.J. Simpson comes down within 5 minutes of the time they believe he goes upstairs. No time to dispose of bloody clothes. What about blood on the carpet? What about dirt on this white carpet? How does he shower? How does he get dressed? I mean, it doesn't make any sense at all, does it? Park himself says the golf bag was already packed and ready to go when he pulled into the driveway. And Miss Clark went to great trouble to tell you how credible she thought Mr. Park was and how he tried to lay everything out. And I think, by and large, we agree with that. But I think if you're going to quote Mr. Park, you ought to quote him accurately and not attempt to mislead or whatever. And so what I did was I went back to the transcript again, where Ms. Clark told you and showed you that photograph yesterday about whether or not Mr. Park saw or was looking at the Bronco or looking for the Bronco on the night of June 12th. Remember that? She told you yesterday I spent a long time with him. And so I remembered that I asked him questions and his response. I asked him at some point, I'm asking you if you looked to, made an effort to see if there was a car parked. Answer, no. Was that a correct answer at that time? Answer, yes. All right. Question. There might have been a car parked there and you didn't see it? Answer, correct. And the reason why you don't know one way or the other is because you weren't focusing on any cars or paying any attention. Isn't that right? And I went on to ask still another part of this question. Basically, your goal was to get Mr. O.J. Simpson, try to get him to the airport on time, isn't it? Answer, that's correct. Question, that is what you ended up doing, isn't it, sir? Answer, yes. Now that's the testimony. So it's fine to come up here and tell you, because they want to fit their theory that, well, he didn't see that Bronco out there and do all this drama, but isn't it better to read the record if you want to be accurate, which I've just done for you? Now, isn't it reasonable to ask Mr. Park also, well, Mr. Park, if you were around the premises there and you were up at Ashford and down at Rockingham, did you ever hear a Bronco come driving up? Did you ever hear a door slam? Did you ever hear an engine of a Bronco? And fortunately, we asked him some of those questions. I'd asked him about seeing a Bronco in the past, and remember he talked about seeing one back in '88 or something of that nature. And so then I asked him this question. And would I be correct in assuming that those engines can be loud on occasion, those cars, meaning the Broncos? Answer, could be. Question, you didn't hear the engines on any cars or anything that sounded like a Ford Bronco that night, did you? Answer, no. Now, again, I've read from the transcript for you. I previously read to you about where Mr. Park said he saw Mr. Simpson in the entranceway of the house. We'll put that aside. So we know that Mr. O.J. Simpson was preparing to leave for this trip that had been long planned. And when we summarize then the two timelines, it seems to me that their timeline is not even reasonable. It doesn't make any sense. It's a much less credible version than the testimony you've heard from our witnesses. Their version does in no way disprove the defense timeline. We don't have to even put that forward, but we did. There then must be a reasonable doubt. Consider everything that Mr. Simpson would have had to have done in a very short time under their timeline. He would have had to drive over to Bundy as they've described in this little limited time frame where there's not enough time. Kill two athletic people in a struggle that takes 5 to 15 minutes. Walk slowly from the scene. Return to the scene, supposedly looking for a missing hat and glove and poking around. Go back to this alley a second time. Drive more than 5 minutes to Rockingham, where nobody hears him or sees him. Either stop along the way to hide these bloody clothes and knives, etc., or take them in the house with him, where they're still hoisted by their own petard, because there's no blood, there's no trace, there's no nothing. So that's why the prosecution has had to try and push back their timeline. Even to today, they're still pushing it back, because it doesn't make any sense, it doesn't fit. That's why they abandoned Ellen Aronson, why they abandoned Dan Mandel, why they didn't want to call Denise Pilnack, why they didn't want to call Robert Heidstrup. That's why we're now hearing this preposterous add-on of time that the thumps may have occurred at 10:15. That's Ms. Clark's wish list, but that's not the evidence in this case. Now let's turn our attention for a moment and let's look at some other things that don't fit in this case. So I started to say before, perhaps the single most defining moment in this trial was the day they thought they would conduct this experiment on these gloves. They had this big build-up with Mr. Rubin, who had been out of the business for 5, 6, 7, 8 years. He'd been in marketing even when he was there. They were going to try to demonstrate to you that these were the killer's gloves, and these gloves would fit Mr. Simpson. You don't need any photographs to understand this. I suppose that vision is indelibly imprinted in each and every one of your minds of how Mr. Simpson walked over here and stood before you, and you saw 4 simple words: the gloves didn't fit. And all their strategy started changing after that. Rubin was called back here more than all their witnesses, 4 times altogether. Rubin testified more than the investigating officers in this case, because their case from that day forward was slipping away from them. And they knew it, and they could never, ever recapture it. We may all live to be 100 years old, and I hope we do. But you'll always remember that those gloves, when Darden asked them to try them on, didn't fit. They know they didn't fit. And no matter what they do, they can't make them fit. They can talk about latex gloves. Doesn't make any difference. They could talk about shrinkage. But we did something even better, didn't we? We brought a man who won the Dondero Award, Dr. Herb McDonald, who did an experiment on these Eris-like gloves. They wanted to talk about liquid or blood shrinking them. You'll see it up there. And what did he say? They don't shrink. Put as much blood as you can on them. They don't shrink. It doesn't work. They have the power of the state. They could have done their own demonstration. They didn't, because you know he's right. So we went about and proved to you these things. We didn't just stand up here and speculate as to what might be. We called a leading witness who came in and passed that on for you. So you could see the overlays on there. They cannot explain that. They could have called witnesses, they didn't. We called the witness. Proved beyond any doubt those gloves don't shrink. Gloves didn't fit Mr. Simpson because he's not the killer. Now, then they will say, and Ms. Clark said the other day, well, gee, these gloves have been thawed and they've been frozen and they've been all those things. But remember Susan Brockbank? Those gloves were measured on June 21st, 1994. Those gloves are basically the same size now as they were June 21st. So that won't work. They come, they tell you all these things, but it won't work. And so, if you looked at gloves, here's the overlay. And there's something else about these gloves that I want to take a minute and share with you before we talk about Mr. Rubin and his testimony. You saw these pictures of the gloves? We had a couple of pairs of Aris Light. And when you have gloves that don't fit, you can hardly do anything with them. Makes it very, very tough. I put on a pair of Aris Light gloves that are real tight. You can see how tough it is to try to get these on my hands. But I put them on anyway here. It's the same kind of gloves that Dr. McDonald did his experiment with. So there'd be no mistake about the leather and all those things they like to talk about. It's hard to get on. Not as hard as Mr. Simpson, but they're hard to get along. The reason I want you to see these gloves, because they want to tell you that when you take off gloves, you take them off by this V portion. Remember this? Somebody testified. You don't take off gloves that way. One of the people's witnesses said that. You don't take them off that way. So we're asked to believe that in this tremendous struggle that night in which Ron Goldman fought so valiantly, that somehow or other, in that struggle, somebody took these gloves. The way you pull gloves off, I have to tell you this, you pull them off like this. Even Rubin knew this. Pull them off like this. The gloves came off like this, not through any way like that. And so I think it's interesting when you look at these gloves and you look at what they're trying to have you believe. They talked a lot about in their rebuttal case about the glove pictures and the glove photographs. Remember that each of the glove photographs were taken, or pictures of Mr. Simpson, were taken in the winter. You know the evidence. Mr. Simpson was living in New York, generally from August through January when he's at football season, or working for NBC Sports. Generally in Southern California, you don't need or wear winter dress gloves in California. You don't go skiing in Aris Light gloves. And you remember that the police, in searching Mr. Simpson's house, remember Detective Lang? They searched O.J. Simpson's house for gloves, for shoes, for clothes. Found one brown glove. But I want you to look at it at some point, the brown glove that looks very similar to the brown gloves that Mr. Simpson. Objection?
Sustain.
One brown, what?
Outside
One
the
brown
record.
glove? This glove was picked up on June 28th. But what I was saying was, this glove came out of Simpson's house. And I ask you to look at this glove. You'll have this back in the jury room. Look at it compared to some of the gloves he wore that day, on the photographs. There were no Aris Light gloves in O.J. Simpson's house. That's the point. They took this one glove on June 28th. That's the point. And the point is, quite simply, Richard Rubin. Let's put him in perspective. Bob Blazer questioned him. On his fourth trip here, we discovered a letter that he sent to the prosecution. This man had become a soldier in the prosecution's army. Wrote him a letter saying he wanted to come to their victory party. The problem with that letter was he wrote the letter before we'd ever had a chance to put on our case. That solidifies the rush to judgment, doesn't it? Because in America, you have a right to wait until you hear all the evidence. That's what makes this country great. People are not making up their minds at the beginning. You don't decide a baseball game or a football game at halftime. You wait until the end. That's what this judge tells you every day. Keep an open mind till you've heard everything. But Rubin wasn't going to do that. He was getting ready for the victory party. In his own letter that he wrote to them, and he asked further, send me your cards. I want Mr. Hodgman's card and Miss Clark's card. He's going to build a memorial to himself on his wall. The number of times he'd come out here. You talk about people who want to be involved in this case, You stack him up to those other people who didn't want to be here. Richard Rubin is one of those people, and it goes to his bias. It goes to his interest. I'm telling you the facts. We told you about this letter. You've got to deal with that if you're going to be fair and impartial in this case. And then, as with all the prosecution's evidence, they're going to tell you that something is not like what it seems. They take a Bloomingdale's receipt in which there's no size or color or anything else on this receipt. And I find this particularly interesting because it's part and parcel of the prosecution's case, isn't it? The way they've done things in this case. Look at this receipt from Bloomingdale's, and this is in evidence. We have the number for the court. 372B, Your Honor. Now, this is this famous purchase in December of 1990, wasn't it? The lot number or the style number is 70268. That's what it says. It doesn't say anything about 70263. It's two items. It says $77. It's $77 is what it says for those two items. It doesn't say anything about $55. It says $77. And it doesn't say anything about color or size or anything of that nature. It doesn't say anything about any mufflers. But yet you've been treated and told, oh, these had to be Eros. Nicole Brown Simpson bought in the Eros lights and gave them to O.J. Simpson. There is no such witness because it didn't happen. And the rest of it is speculation and theory on their part. Cynical speculation, I might add, to try to rush to judgment and win at any cost. Now, you heard during Mr. Darden's effective argument last night a lot of statements. And just before I get to that part, let me say a couple other things about Mr. Rubin. Might be appropriate. Remember, Mr. Rubin's an interesting witness. When he was brought back out here this last time, he was asked, well, look, how many glove manufacturers are there in the world? I mean, he acknowledged there are over 100. And then Bob Blazer asked him a question, well, you know, how many did you check with? 2. He checked with 2 and then he stopped looking. Because remember, he found out that this Brosser stitching could be made on Singer sewing machines. Some of you may know more about that than I do, but they stopped making them after a period of time. But he stopped looking after a period of time, never called anybody else. And that's interesting because that compares the way the prosecution witnesses have conducted themselves throughout. Compare the fact that he stopped looking after 2 with Agent Martz, who finds 3 of the 4 things you need to find EDTA on the sock and the back gate. Rather looking carefully for the characteristic, the 4th one, he stopped searching. He uses a far less discriminating test. Consider the EAPB found under Nicole Brown Simpson's fingernails, where they try to come in and tell you it's a degraded BA. And on cross-examination again, Blazer got Matheson to admit there was no specific support in any of the literature for a BA degrading to a B, and this was, by all accounts, a double-banded B. The reason they didn't want to pursue that? Because she may have scratched somebody with the B type. But they never pursued those things. The second had at Bundy. The Bundy location inside. When the defense investigator finds this hat, nobody wanted to collect it. They refused, in fact, to collect it. When we, in this trial, before you, discovered that evidence had been moved at Bundy, and that a key piece of evidence, the piece of paper, had disappeared, they didn't do anything to find out about it that we know of. We're concerned about those kinds of things. But it's important then when you look at Rubin, because you put him along with the other prosecution witnesses and the things that they've had to say. I told you about that Bloomingdale's receipt. I told you about Brenda Vimich who came in. And one other thing about Brenda Vimich that was interesting, she was a lady who, that was the day, I won't forget that day ever probably, because that was the day that, she's a pretty tough witness. I was just trying to talk about receipts and things. She's pretty tough. And I was asking some questions. And remember, we asked her the question, well, who's the lady, who's the person, who's the salesperson for this? And that lady, whose name was Hollings or something like that, was in this building. And they never called her on that receipt. They didn't have to call her, but we know she was here because Brenda Vimich told us about that. We also learned something else about these gloves. even an extra large. There's probably 3 different sizes. There's the undersize, the standard, and the oversize. And it depends what lot you get. That's what it boils down to, ladies and gentlemen. We know that. That makes sense, doesn't it? And so when you look at everything regarding these gloves, by the way, the lady's name was Helena Phipps, Phipps. She was in the courthouse and, of course, was never called by the prosecution. She was the actual sales clerk. But I think that the important thing about these gloves that Mr. Rubin was helping us with, in a couple of the pictures of the photographs of the gloves, Mr. Simpson obviously had a heat pack on his hands inside the gloves. You could see the heat pack. If you lived in cold weather, you know about that. And try though they will about shrinking, and they're going to show you, gee, it's raining out there, and it's doing all those things. Isn't that preposterous? They'll do anything to try to contort and distort the facts. Try to get away from that tactical mistake, showing you the gloves didn't fit. So spend all this time on that, and the gloves still don't fit. Rubin can't help you. Rubin is biased. Can't find those gloves because O.J. Simpson's never had those gloves. For them to say otherwise is rank speculation. Now, as I said with Mr. Darden, we heard a lot of information about this so-called domestic discord that he talked about last night and today. And you know, we've been told in this case over and over again that you are to do your job devoid of sympathy or passion or emotion. And I dare say you are very, very intelligent people. And it is very, very hard for any of us to sit here, have to look at photographs of dead bodies, people who did not deserve to die. This case is about who committed these crimes. Not trying to make you and the audience cry about what happened back on June 12th. So they can do it over and over again. But it's not going to work because you understand. This case is not about trying to appeal to your emotions. This case is about the facts and whether these facts establish guilt or innocence beyond a reasonable doubt. You all understand that. So we heard last night, and we're treated to this morning, some very, very interesting observations by my learned colleague, Mr. Darden. Let me start off by sharing with you, and I'll use his board on evidence of other crimes. Now, this is interesting because Mr. Darden started off by saying, well, you know, we're going to put together this other piece. It's not really one of the elements of the crime of murder, motive, but we're going to talk to you about motive now. We're going to tell you and convince you about the motive in this case. And then he spent a long time trying to do that. And as I say, he did a fine job in trying to address the facts and conjure up a lot of emotion. But you notice how at the end he kind of petered out of steam there, and I'm sure he got tired, but petered out because this fuse he kept talking about kept going out. It never blew up, it never exploded. There was no triggering mechanism. There was nothing that would lead you to that. It was a nice analogy. It was almost like that baby analogy of the baby justice in the house of fire. You don't have to go through any house of fire. You just have to keep your eyes on the prize, and the prize is justice. It's a city called justice, and it's a journey that you're leading toward. That's all you got to do. And so this is what this is all about. It's evidence of other crimes. The court, Mr. Darden kind of looked at this and said, oh, Judge, well, whatever, limited purpose. But let's talk about the limited purpose for which all of his argument was about. When they talk about this evidence of other crimes, such evidence was received, excuse me, sir, and may be considered by you only for the limited purpose of determining if it tends to show a characteristic method or plan or scheme about identity or motive. For the limited purpose for which you may consider such evidence, you must weigh it in the same manner as you do all other evidence in the case. You are not permitted to consider such evidence for any other purpose. So this isn't about character assassination of O.J. Simpson, which you might think at first blush. This is about Mr. Darden trying to conjure up a motive for you. And at the outset, let me say that none, not one little bit of domestic violence is tolerable between a man and a woman. O.J. Simpson is not proud of that 1989 incident. He's not proud of it. But you know what? He paid his debt to that. He went to court. He went through that program. And the one good thing, and no matter how long Darden talked, from 1989 to now, there's never any physical violence between O.J. Simpson and Nicole Brown Simpson. And those are the facts. He kept going back and forth to 85, 89, 93, but there's no physical violence. In fact, let's look at the incidents that he talked about just quickly. And keep this in mind, this is supposedly for the limited purpose of determining if it tends to show a common scheming plan, identity, or motive. Only for that limited purpose. So keep that in mind. He didn't bother reading all this to you. Let me read you something else again that goes along with this as we consider this evidence. The court's already instructed you about motive. And I listened very carefully as my friend read this. He got to one part and he stopped, but I want to read you the rest of it. Motive is not an element of the crime charged and need not be shown. However, you may consider motive or lack of motive as a circumstance in this case. Presence of motive may tend to establish guilt. He stopped after that last night. Let me read you the rest of it. Absence of motive may tend to establish innocence. You will therefore give its presence or absence, as the case may be, the weight to which you feel or find it is entitled. Now, I want to go ahead and read you the part about absence of motive in this case. Because as long as he stood up here and tried to talk to you, couldn't show any physical violence after 1989. He could talk about 1985, the incident involving the Mercedes. Mr. Simpson wasn't arrested then. He can talk about 1993. And certainly, he would hate to think that two people could have an argument like that, but there was no physical violence. In fact, the police came out, if you recall, and did some further taping. These people were upset and they were arguing, but they never fought on this occasion. There were no blows on this occasion. And certainly no one wants you, if you think in your background, would not want your worst argument ever tape recorded. O.J. Simpson had perhaps his worst argument tape recorded. And then he had the audacity to stand up here and say, well, they didn't call Lenore Walker. We didn't call Lenore Walker because it wasn't necessary. They could have called her. Talked about her having some tests that showed that Mr. Simpson was not antisocial, had no antisocial personality. That wasn't true. Why didn't he call her? Because you don't have to call all witnesses. Just like he said, at some point, all of us, I think, got the message. There are certain horrors of sequestration. I dare say we could still be trying this case, left to our own devices. Somebody had to have some good sense in this courtroom. We had to bring this matter to a close. We did what we set out to do, to demonstrate to you reasonable doubt. We think we've done that. We could call a lot more witnesses that I talked to you about in opening statement, but I don't think that's necessary. Another word about opening statement. In opening statement, I stood before you, and I told you this is what we expect to show. This is not evidence. That was in January. This is what I would hope the evidence would show. If there's a witness that I didn't feel was credible, or we didn't feel was credible, I wouldn't call that witness. If there's a witness who was not available, we wouldn't call that witness. If we didn't feel a witness was necessary, we wouldn't call that witness. The defense doesn't have to prove anything. We've done that in this case, prove things, however, but we don't have to prove anything. So the witness wasn't called. Don't hold that against O.J. Simpson. You hold that against me, and I don't think you can hold that against me because the defendant doesn't have to prove anything. And remember, the judge has already instructed you as follows. Let me read it to you again so we make this clear. Hey, Mr. Darden will remember this. The prosecution has the burden of proving beyond a reasonable doubt each element of the crimes charged in the information, and that the defendant was a perpetrator of any such crimes, such charged crimes. The defendant is not required to prove himself innocent or to prove that another person committed the crimes charged. Now, that law is not just for O.J. Simpson. That's the law of the state of California for everyone, and they know it. I told you at the beginning, in this search for truth, in your courage, we cannot let them turn the Constitution on its head. I am going to be your reminder of that. So continuing on, he talks about what might sound like character assassination over and over again about these incidents of controlling and jealous rage. And just because he says that, supposedly makes it so. Isn't it interesting? 17 years these folks were married. Had 2 beautiful kids, a beautiful life. Think they had any good times together? Think they ever want to talk about any of the good times? Think about even after 93. Remember, they got a divorce in their chart in 1992. They tried to get back together. Dr. Christian Reichardt told you. It wasn't O.J. Simpson. It was Nicole Brown Simpson who asked to get back together in 1993. They tried to work it out for about a year. They didn't live together, but they tried to work it out. They talked about this. They tried to date exclusively. They tried to salvage a 17-year marriage. And you could understand that. It was her idea. It didn't work out. And they went their separate ways. The evidence is he'd been dating Paula Barberi back in 1992 for almost a year. But when he got back with his wife in April or May of 93, he stopped dating her. When he broke up with his wife again, he started dating her again. He wanted to give it a fair shot. Remember Orenthal Simpson said they would wake up sometimes in the morning and Miss Nicole Brown Simpson would be over there with the kids at the house. This was during this period of time. They were trying to get back and get along. They all went to Cabo San Lucas. They had a good life together. It's interesting how the prosecution doesn't want to talk about that at all. In their cynical view of life, they two or three incidents and say, this just tells us the whole picture. Well, all of us, there's more to the entire picture. And I ask you rhetorically this question: who would know O.J. Simpson better? His mother Eunice, his sister Shirley, his sister Carmelita, his daughter Arnell, or Marsha Clark and Chris Darden? Who do you think knows him when they stand up here and talk about his public persona and he's got this dark side? Those are all just words. He's a human being and he's not perfect. He's not proud of some of the things he did, but they don't add up to murder. There's no escalation of force and violence throughout 1989. It's not there. We don't have to call Lenore Walker. Your common sense tells you this. And then he goes into this kind of make-believe fantasy world where he's going to try to tell you on June 12th, he's going to conjure up this rage. June 12th. Very interesting day, isn't it? It's wonderful that we live in the age of videotape, because he tells you about how O.J. Simpson was. Cindy Garvey was telling you how O.J. Simpson was. He was this mean, dark, brooding person at this concert, that he was going to kill his ex-wife because he didn't like his seats. I guess that was what it was about, that he didn't like his seats or because he didn't invite her to dinner. Can you imagine that? That's how silly what they're talking about is in this case, as he tries to play out this drama. But let me show you, rather than talk. A picture is worth 1,000 words. So let me show you this video. You watch this video for a moment, and we'll talk about it. This is for Chris Darden. You'll recognize some of the people in this photograph after a while. There's Mr. Simpson kissing Denise Brown, kissing Miss Juditha Brown. It's Mr. Lewis Brown. He's talking to a friend. That's his son Justin, and he kisses. Smiling and happily waving. Mr. Brown's happy. Laughing, falling down, laughing again, bending over laughing. Now you see that. You see that with your own eyes. You'll have that back in that jury room. How does that comport with this tortured, twisted reasoning that he was angry in some kind of a jealous rage? He's in a jealous rage like that to you? Your eyes aren't lying to you when you see that. Thank heaven we have videotape. I didn't tell you about that in opening statement. Think that's pretty compelling? Thank heaven we have that. And we know in this city how important videotapes can be when people don't want to believe things, even when they see it on videotapes. And you saw that yourself. So when you're back there, somebody tries to tell you there was some kind of jealous rage on June 12th. Look at O.J. Simpson interacting with the Brown family and everyone else. Doesn't fit, doesn't make any sense. He isn't brooding. He's not angry. He kisses these family members. He's laughing and joking. He's playing with his son Justin. Those are the facts. Not what I made up. These are items that don't fit. And if you want to go a little bit further, let's talk about what we know about him that evening. That video is what, about 6 o'clock in the evening? Let's start at 6 o'clock on June 12th. We know he had a good day that day. He had a good week. We'll talk about part of the week in her demeanor, but let's just talk about that part of the evening. 6 o'clock, he's at that recital. You know, you go to a recital because you're proud of your child. You know, and at these recitals, and you all can think back, and those of you who don't have kids will live for this day, you know, these programs are long. Your child is like 33 or 34th on the program. You love everybody else's child, but sometimes you don't want to sit there doing the whole thing, you know. We're told some stuff about he moved a chair around. You ever been in an auditorium where you can move chairs around? Most auditorium seats are like those. You can't move those seats around. This is preposterous. Mr. Darden wasn't in that auditorium. And even after that video, like any proud papa, you know what O.J. Simpson did? Took a picture, a photograph, with his daughter. Let's look at this photograph for a minute. You want to see how he looks while he's in this murderous rage, while this fuse is going on that Darden talks about? Where's the fuse now, Mr. Darden? Where's the fuse? Look at that look on his face. Like any proud papa, he's proud of that little girl. And who wouldn't be proud of her? This is post the dance recital. She has the flowers. Apparently he went out and bought for her. He's standing there with her. The photograph's taken. There's no way of knowing. He would have no way of knowing that would be important. He'd have no way of knowing that Chris Darden someday would stand before you and try to make you believe that that man was in a murderous rage at that same time, and that we would bring forward that picture so you would see it with your own eyes, so you'd understand. What exhibit is that, Mr. Douglas, sir? Look on the back of it. Oh, it's a smaller one. Okay. We'll get that for you, Your Honor. So thank heaven again for the visual. A photograph is worth 1,000 words. So he could speak 1,000 words, and I could show you one photograph. He could speak 1,000 more words, and I can show you that video. And what it does is it puts the lie to this theory about some kind of murderous rage. But we don't just stop there. We didn't just stop there, because this is serious business. A man's life is at stake. So what do? We talk to Gigi Guerin, his housekeeper. O.J. Simpson, by and large, has a great relationship with all the women in his life. And you've met a number of them. Gigi Guerin is the housekeeper. So she came in here, and the great witness said that she was at Knott's Berry Farm on June 12th. She's out with her family. And at 8 o'clock, She wanted to stay over because she's due to come home that evening. She said, "Can I stay over?" And Mr. Simpson says, "Yes, you may." And so I asked her, "How did he sound to you?" He sounded like Mr. O.J. Simpson always sounds. The employer that she knows, the relationship that she has with him. You saw her. You observed her. You saw her go through cross-examination. She seemed believable to you? 8 o'clock? I think so. I think you'll find so. And then we know that at 9 o'clock, he talked to Christian Reichard, his friend, Dr. Christian Reichard. And you saw Chris Reichard come in here and talk to you. I thought he made a very, very, very good witness from a standpoint of what he had to say. He told you that O.J. Simpson sounded even happier than usual. He was more jovial. He got his life back together, and he was moving on. Now, isn't that interesting? Isn't that an interesting way of looking at circumstantial evidence? Let me show you how we differ in this case. The doctor witness comes in and says O.J. Simpson is jovial at 9 o'clock on June 12th. Pretty good evidence, wouldn't you say? I think you'd love to have that. Anybody would in the case where you're supposedly in a murderous rage. Instead of Chris Darden standing here and saying, "Well, you know, that's pretty tough evidence for us to overcome," he says O.J. Simpson was happy because he was going to kill his wife. Now, if you believe that, I suppose I might as well sit down now, and I'm probably wasting my time. I don't think any of you believe that. That is preposterous. It flies in the face of everything that is reasonable. If you have these two reasonable hypotheses, his isn't even reasonable, but extremely reasonable. You'd have to adopt this, that he's jovial, he's happy. They make a date for that next Wednesday when O.J. Simpson returns from back east. You remember that? That's the testimony. Now, Mr. Darden tries to make a big thing of the fact, well, gee, you know, golly, was he depressed about the fact that they had broken up or they finally broken up? He said, yeah, he'd been down. I don't think he never said he was depressed, that he was down or upset. And who wouldn't be? Remember the last questions I asked? If you had just ended a 17-year relationship, it was over, you feel down. For a short period of time, you got your life on. You wouldn't go kill your ex-wife, the mother of your children. O.J. Simpson didn't try to kill or didn't kill Nicole Brown Simpson when they got a divorce, when they went through whatever settlement they went through, when Faye Resnick moved in, when any of these things, none of these things happened. Because of their rush to judgment, they have to try to come up with some kind of a motive that doesn't make any sense. It doesn't stop with just Christian Reichard and what he had to say. And of course, I have his testimony also of what he said. He talked about the demeanor of the various people he talked about, but most importantly, he talked about O.J. Simpson's demeanor and how it was that night and how he appeared to be. Let me just read you this part here. This is 42537, counsel. Question. Now, with regard to the statement about whether or not you talked about Miss Nicole Brown Simpson, that was not the thrust of any of that conversation, was it? Answer, not at all. She wasn't on his mind. This time he's talking about getting ready to go to McDonald's. In fact, do you recall that Mr. Simpson had said that to you, that he was out of the loop, that he was glad to be out of the loop, that he'd gotten his life together with his new lady? Remember him telling you that? Answer, that's correct. And who was that new lady? Answer, Paula Barbieri. Let me just take a moment about Paula Barbieri. One of the most outrageous things heard yesterday was this wild speculation that O.J. Simpson had some kind of falling out with Paula Barbieri on that Sunday. Where is the evidence of that? I mean, that's preposterous. The evidence is quite to the contrary. Remember when O.J. Simpson came back into town on Friday? First person who met him and they spent the evening together was Paula Barbieri. And it was interesting because I was having trouble hearing her. She said, I stayed at the house till one of you reminded me, she said, till I went to the prayer meeting. It's where she left. They'd been together that day. And then on the very next day, they went to this dinner in support of Israel. And I guess Mr. Douglas can show us that. This is that dinner. I guess he's really working up that murderous rage that day with those little ladies that he's with. They seem to be really happy to be taking a picture with him. had no idea we'd ever have to use this to show, to counterbalance this specious, cynical, speculative theory that he's had some kind of a time fuse. But that photograph, again, demonstrates that. And then we have the testimony of the lady who was there, Carol Connor, about what she called that exquisite moment. And I suppose that she's an artist. You could tell by the way she was dressed when she's here, and she's written this Academy Award-winning love tune, and I guess she sees things maybe that we don't quite see, but she said it was an exquisite moment between O.J. Simpson and Paula Barbieri as they were in each other's arms at that particular dinner. Remember, she told you that. Was he thinking about Nicole at that point? Only in Chris Darden's mind. Not in yours, not anything else reasonable. And so you have, again, these photographs and these word pictures, which I think amply destroys this. So he continues on about Paula Barbieri. He says, you knew about Paula Barbieri, isn't that correct? Yes, I did. Also, Mr. Simpson had told you that he began dating Paula Barbieri on a regular basis, isn't that correct? Answer, yeah. And that you had said and indicated to the police in an interview that Mr. Simpson seemed to like Paula a lot and seemed happy, or at least happier, than he had been before once he was with Paula. Isn't that correct? That's correct, yes. That's what you told the police, isn't it, sir? That's correct. When you talked to the police, Dr. Reichart, were you telling them the truth? Answer, absolutely. And when you are coming here today to testify to this jury, are you telling them the truth? Answer, absolutely. And so, once again, I haven't tried to speculate. I've read to you what the witness said. Now what about this thing that Darden keeps talking about that he knows isn't so, that the police have been out there 8 times on so-called domestic discord cases. They told you that a whole bunch of times. And this is why you have to look with some suspicion at what the prosecutors tell you in this case. You remember Officer Farrell? The officer who was a sergeant, I believe, who after the '89 incident went back to the station to try and check and see whether or not there'd ever been any other incidents where any of the police officers in that division in West Los Angeles had been called. You check your notes. And so what he did was he had occasion to check for other domestic discord incidents. This becomes rather important later, as you're going to see. So he talks to us. He says, the question is, all right, so you talked to some officers. How many? Just tell me in number how many officers did you talk to altogether? Answer, I can't recall. Maybe 10. And did you take any reports from any of those officers? Answer, I requested, if they had any information, to write out a report and give it to me. Question, and you got a report from one officer, did you not? Answer, that's correct. Question, and that officer's name is Mark Furman. Question, that's correct. And was that the only written report that you received? So now, when Darden stands up here and talks to you about these 8 incidents or whatever where there's nothing happened, they checked with at least 10 of the police officers in that division. Nobody had any recollection of anything of going out there. Now, we know from Ship, the police would stop by there. We know that. Ship told us that. There's some photograph and evidence of O.J. Simpson with Ship and maybe some other police officers. That was a place they would stop by on occasion. But this, to tell you 8 to 10 times, when they know that was their own witness, Farrell. Then he has the audacity to tell you about stalking. He tells you in opening statement, he's going to tell you and show you O.J. Simpson was stalking Nicole Brown Simpson. Now, this is the prosecutor. Did he prove one incident of stalking? Absolutely not. In fact, yesterday, when he stood up here and told you about O.J. Simpson looking in the window of Nicole Brown Simpson's house, I was somewhat dismayed. So I thought, gee, I better get the transcript out again, since the record is the best evidence, not what they say. Because they say it so, isn't so. They said that themselves. And so we talked about this. And you remember Mr. Colby and Co., 2 people who lived next door to Nicole on Gretna Green. Remember them? You remember those 2. And Mr. Colby was testifying on this date. It's 13176. I saw him observe the residence next door, then walk around the corner, which would be southerly, then westerly on Shetland, and go back around again and look again at the residence. Well, let me just stop you there, all right, so that it is clear. When you first saw the man who was on the sidewalk 5 feet from Nicole Brown's driveway, there's an objection? Yes. Then he walked in a southerly direction, then back around the corner. Our house is on a corner like this, indicating. He then went southerly and then westerly and then back around again. Okay. Did he walk back to the same spot he was in when you saw him initially? Yes, he did. And he goes on to talk about him walking within 5 yards of Nicole Brown Simpson's driveway and then walks back. And you remember this was the incident where Mr. Colby said he was embarrassed because he saw this black man in Brentwood and he called the police. And then he found out it was O.J. Simpson. Now, nowhere are you going to find in that testimony O.J. Simpson was up looking in a window or stalking anybody. He was on the sidewalk out there, presumably waiting for his wife or the kids to come home, and then he left. That's how the people have twisted and turned things in this case. That becomes his incident of stalking. And when you go back, you look at this evidence, and I know you're going to be fair and honorable. You look at this and you'll see. You'll make short work of this. You'll make short work of an emotional argument. It was very emotional. But it doesn't add up. It doesn't fit. It wasn't factual. It's for a limited purpose. And here may be the coup de grace. All of these things are supposedly for motive, to show how somebody might have acted on June 12th. Interesting, isn't it? Again, in the words of Shakespeare, they are hoisted by their own petard. They talk about these incidents involving Nicole and Mr. O.J. Simpson. Every time they would have an argument, everybody would know about it, whether it was in '89 or the '93. Everybody would know about it because it would be loud. They'd be arguing back and forth. There was drinking on the time in '89, January 1st. Remember what the evidence was? They'd both been drinking. It certainly doesn't make it right, but they were loud arguments where everybody knew about it. What kind of characteristic is that in this case? This is a case about stealth. This is a case about somebody who, it seems to me, is a professional assassin who kills these two people. And the thing that is so outrageous, for them to stand here and tell you that this is all about Nicole Brown Simpson. Have any of you thought during the last year, what if the perpetrators were after Ron Goldman and that envelope that he had in his hand that Dr. Lee found that smear on? Who in this courtroom would know? The rest is speculation. This is their theory that they tried to come up with. We don't know. This is a case of reasonable doubt. This is a case of an innocent man wrongfully accused. They can't answer those questions. No one can under these circumstances. And so we move on and look at other things that don't fit. We know that there was this terrific struggle involving primarily Mr. Goldman as he fought for his life. Why no bruises on Mr. Simpson's body here? Admittedly, this was a violent struggle involving two very, very fit adults. And let's look briefly at the bruises on Mr. Goldman's hands. I don't think we have to cut the feet on this, Your Honor, I don't believe. We talked about this in the opening statement. And that large bruise on the knuckle, according to Dr. Baden and others, is consistent with Mr. Goldman's fight that he put up for his life. He struck something, probably a person at that point. But Ms. Clark and the others can't even admit that. In the face of doctors, a doctor who did the re-autopsy, re-examination of the death involving Martin Luther King and John F. Kennedy, tells you one thing. The prosecutors say, oh, no, he must have been flailing back, must have hit his hand against a tree or something like that. Only the facts that they want to put into this little contorted theory. But we prove to you otherwise. We prove to you what's reasonable under the circumstances. So I think you saw that in my opening. And I think that is further evidence this was a very, very real fight. And of course, in a real fight, in real life, fights are awkward and clumsy. Oftentimes the combatants are rolling around the ground. And one of the very interesting things in this case is this dugout area near Mr. Goldman's body. The feet should be cut. This area I thought was very, very interesting. Remember, I asked Detective Lang about this, and this is going to become very, very important later on. See this area, this dugout area? Remember, there's the pager over there, and there's this dugout area. That gives you some idea of the ferocity of this altercation that took place. Remember, Dr. Henry Lee talked about the blood all around in this area, the keys one place, the beeper someplace else. This dugout area. Interesting, isn't it? Now, think with me for a moment. If you fought for 5 to 15 minutes in an area like that, I suppose both parties would have a lot of bruises and marks on them, wouldn't they? Mr. Goldman did, and I bet you his perpetrator does. But there's something else again. They want to tell you, and you'll hear a lot about socks before we're finished, that these socks that all of a sudden appear for that video, the foot of his bed, were being worn by Mr. O.J. Simpson. Well, ladies and gentlemen, when you see these socks, what do you think the dirt and dust was on these socks? Now let's see if they can ever explain this. Where was the dirt that was thrown up and moved around on these socks? You're not going to see any. You're not going to see any dirt because those socks weren't there. You see that dirt? You see that dugout? You remember this photograph. What number is this, Mr. Douglas? You remember this when you talk about this case and you wonder whether or not there's a reasonable doubt, whether or not this is an innocent man wrongfully accused. And so you look at this. When you expect, common sense would tell you there'd be bruises and nicks, being kicked, there'd be marks on all the perpetrators. With the heavy foliage there, with the fence and the trees, you would expect scratches on everyone. Whereas Mr. Goldman has more than 30 stab wounds, you would expect this struggle, 5 to 15 minutes, to have left that. But there's nothing like that in this case. Nothing like that on Mr. Simpson's body. And you've seen that before and you'll see it again. Now, in this case, in this case, in the opening statement I showed you, with Bob Shapiro's foresight and wisdom, he had these photographs taken, I think on June 15th. Instead of praising this lawyer who was interested in the truth, the prosecution says, well, they went to Dr. Heisinger. That wasn't really his doctor. Isn't that preposterous? Dr. Heisinger, by all accounts, is a qualified doctor. He was the Raiders team doctor. So I suppose he's qualified. And this is Mr. O.J. Simpson's body as it appeared on June 15th. Would you expect to see a lot of bruises and marks on that body? See his back? Some of these aren't very flattering, but this is not about flattery. This is about his life. Now on his hands. There's some slight abrasions on his hands, but nothing consistent with a fight like this. You know it, I know it, we all know it. And we'll talk more about this so-called fishhook cut and where he got that. It'll become very clear when we talk about demeanor, where that came from. Ms. Clark wants to try to confuse that, but that's very, very clear. And so with regard to Mr. Simpson's physical condition, I don't want to just tell you to take my word to stand there and say, oh, he was in great shape on that day, or he looked good or whatever. Fortunately, we had photographs again. We had graphic evidence of this man's body. This man had not been in a life and death struggle from 5 to 15 minutes. Ms. Clark herself said it. She used a boxing analogy. saying that a boxer's fight for 3 minutes per round. Sometimes it's a knockout in the first round, but in this instance, we know because of the way the injuries were and the blood, this lasted for this period of time. This was a violent struggle. That man that you saw up there was not involved in that violent struggle. And so we did call, Bob Shapiro called Dr. Robert Heisinger as a witness in this case. And you recall that Dr. Heisinger was a very, seemed to me a very credible, honest witness. What did he say? He said that O.J. Simpson looks like Tarzan, but he moves more like Tarzan's grandfather. That's not to say that O.J. Simpson wouldn't be capable of committing a crime. It's never what we're trying to say. What we're trying to say was that see this man for who he is. See this man for the arthritis that he suffers. That everybody in his family suffers with arthritis. You saw his mother, you heard his sister, and you heard he has it worse than they have. Now he can still play golf. You can still do that. And some of you, I hope, don't, but if you have in the early stages, you know what it is, certainly on certain days. What I think it means is you don't go out looking for anybody to be in an altercation with. O.J. Simpson, by all accounts, has trouble with lateral movement, from moving from side to side, because you saw when I had him come over here, those knee operations that basically spelled NFL, National Football League, 4 or 5 times on the left knee, maybe a couple times on the right knee. That's the price that a running back pays. And while I'm talking about running backs, wasn't it interesting yesterday that Ms. Clark in our argument says O.J. Simpson was a football player, and he has to run through the line, and he has the killer instinct. Is that really stretching it, ladies and gentlemen? O.J. Simpson hasn't played football for 15 years. Man's 46 years old now. He's not going to run with anything anymore. But she didn't know much about sports, does she? Because a running back avoids trying to be hit. That's what he does. The problem with them, they don't block. They always run. They try to get out of the way. So he's not looking for contact. He gets tackled. But running backs don't try to run over anybody, only like maybe Jim Brown or somebody like that. The rest of them run out of bounds. So, I mean, they grab at everything. Killer instinct. Played football 15 years ago, and he was the best at what he did. He won the Heisman Trophy, according to his daughter, the day she was born. Emblematic of the best football player in America. And so, this was brought to you only to give you some further factors about who this man is, what limitations, if any, he has, to give you a complete picture of who he is. Now we shift our attention to Mr. O.J. Simpson's demeanor, and I want you to examine with me the conduct both before and after June 12th, 1994, and the manner in which this man reacted and handled himself. You'll remember, and let's start off with the week before. We could have gone further back. You know from the evidence that he travels all the time. He hardly has any time to have any fuse for anything. He's never here. He's always traveling for Hertz. He's doing something with sports. He's not here. This particular week was typical of the kind of weeks he has, it seems. He was here on Monday. On Tuesday, he and Paula Barbieri got together and met with this interior designer who'd done work on his house before. She brought out that he's done other work on that house to change the bathroom around and do some other work. She had a budget, and they gave her a check. Now, it's so interesting, isn't it? You change your house or get some work done. Mr. Darden says that's to get Nicole out of the house. Is that stupid? I mean, does that make any sense to you? That's preposterous. Man's moved on with his life. He's having some work done, some interior decorating work done. We prove that. You can't see the positive side of that. O.J. Simpson, a check for Collins & Collins, was Mary Collins. June 7th, $1,000. That was a down payment on the work she was going to do. Again, you saw her. You saw her come in. This work was to be done. They wanted to do it, and Paula Barbieri played a role and a great part in that work. After that, he was on the road. Went back east to play golf with Jack McKay. And you saw Jack McKay, and you remember they were golf buddies. It was a Hertz thing, or not a Hertz thing. This was this association of a retired or something or other. Played golf. But the most important thing I thought was Mr. McKay indicated that, and there was the foursome, Mr. McKay indicated that he observed Mr. Simpson walking and walking with a limp. You'll recall that. And then we came to the Carol Connor dinner, where Carol Connor observed the magic moment on this Saturday. And then we called witnesses from the family. And just before we take the dinner break, let's talk briefly about these witnesses from the family and what they had to say. We first called Orenthal Simpson. And you saw Orenthal on the stand. Orenthal Simpson, the defendant's daughter, born the day he won the Heisman Trophy. Now, any daughter would be proud and want to testify for her father. But you saw her on the stand. You got a chance to judge her like you do the other witnesses, to observe her credibility and what she had to tell you. She told you that her father always rushed around. Told you something about him, too. And when she got out of college at Howard University, she wanted to come home. He had a place for her to come home to. You know, children go away and they come back a lot these days. And so, Cato Kalin, they make a big thing about Cato Kalin living there. You know, I choose to think he said something about O.J. Simpson. He didn't know Cato Kalin anything. If he wanted to say, look, I don't want you living with my wife, we're trying to get back together. I suppose a guy could say that if they're trying to get back together. He didn't say that. Let him come and live there in the other guest house. They turned that around to something bad. That's something positive about this man who with such dignity has sat there for all these months. This human being, this Orenthal James Simpson. That tells you something about him. And so his daughter tells you a lot about him. She can tell a lot about a person, I suppose, by their children. She tells you a lot about him and their living together and their life together and what he meant. About how her little brothers and sisters would come over there in the early morning hours after they were trying to get together in 1994 in May. They'd be out by the pool. She'd see them. About the kind of life they had together and the dogs that they purchased and the kind of things they did. Maybe a little bit of the other side of what these incidents they want to talk about in the distant past. The way O.J. Simpson really is and really was. You saw her and you observed her. And she told you how her father reacted when he got the news that his ex-wife had been killed. She told you she had never before heard her father sound like that. How upset he was. How he lost control of himself. How distraught he was. You heard her. You saw her on that stand. That's why we called her, so you'd have a better understanding, because I knew there'd come a day that Marcia Clark would stand here and say, well, you know, he didn't react like somebody does when they get this information. Just like she did yesterday. But what Miss Clark forgot, because I examined Detective Phillips, and you look back through your notes, the first thing that O.J. Simpson said to Detective Phillips was, what do you mean she's been killed? And then he kept repeating himself and repeating himself, and Phillips, to his credit, said he became very, very upset, kept repeating himself, and Phillips gave the phone to Orenthal Simpson. So she can again theorize, fantasize all she wants. Well, he didn't ask if it was a car accident. You ever had some bad news given to you? There's no book that you go to. The only book you should go to is the Bible or your God, whomever you believe in, to help get you through it. There's nothing that says how you would handle yourself in those times. These prosecutors don't understand that. They would stand here and tell you that that's preposterous. This man was upset. And you're going to see that everything he did from that moment that he found out that his ex-wife had been killed was consistent only with innocence. Absolutely that day. And so Orenthal Simpson helps us in that regard. She's followed to the stand by Carmelita Durio. Sister, loves her brother, but you knew that. She was called to talk about Ron Shipp, one of the witnesses in this case that the prosecution called. It's interesting, isn't it, that neither one of the prosecutors wanted to talk about this dream, because I think they're embarrassed by this. They didn't talk about it. They should be embarrassed. A dream. They listed evidence about some dream. Was it a daydream? Was it a night dream? Was it a nightmare? Was he looking out the window? What did it mean? Even the judge, his instruction, you can totally disregard that. I mean, you got to figure out, I mean, who knows what that means? It probably doesn't mean anything because Ship did not tell you the truth. If you listen to Carmelita, if you listen to Shirley, if you listen to Miss Eunice Simpson, Ship was never alone with O.J. Simpson that night. He was an O.J. wannabe, bringing police officers over there, still wanted to be a police officer, off the force for whatever reason, drinking that night, drinking in the past as he said he was. He's not credible, and the evidence he brings is so unreliable and so irrelevant that I don't want to spend much of your time with it. But you saw it, you heard them. I ask you to consider Carmelita, Shirley, and Eunice as against Ron Ship, and I ask you who you're going to believe. I think it'll be no contest. And so you remember what Miss Eunice Simpson said when she said that he seemed a bit spacey, was the way she described it. He was never alone, never talked about any dreams. When Shirley went upstairs with her husband, they spent the night with O.J. Simpson. This was a time for family. This was a time where people gathered around. This is the time for people being sad. They sat on the couch with O.J. Simpson holding his mother's hand. You remember that. My mother always told me that you could tell a lot about a person, about how they treat their mother. You probably have heard that too. How they treat their mother. You probably have heard that too. And your mother is the one who always comes for you and to you in times of tragedy and stress. True to those words, there was Eunice Simpson as she is this very day, right there by her son's side, sitting on that couch. Who are you going to believe? Eunice Simpson or Ron Ship, this wannabe? I submit that you're going to believe Eunice Simpson. She knows her boy. He knows his mother. And then, each of these witnesses who dealt with O.J. Simpson, and let me just quickly come to, and we'll get a logical breaking point so you can get to your dinner. Alan Park, who she put such great credence in, found O.J. Simpson to be, his demeanor to be normal. Never met him before. He was a normal guy. He was glad to be carrying O.J. Simpson around. The only thing he said was interesting. He said, you know, he said he was hot in the back. Now, O.J. Simpson himself said he was hot in the back of the car. And I thought about this today. And this morning when I was rushing around, trying to get dressed and come to court today to look forward to seeing you all again for another year and a day, I took a shower and I was trying to get dressed, and I kept sweating. I kept sweating. And I thought about how that applies to this case, because you know we talk about common sense. You ever rush around and take a shower and you're sweating? O.J. Simpson always rushes around, according to his daughter, according to Gigi. Those are the kind of common sense things we know. And so when we come back this afternoon, we're going to talk about Cato Kalin and how he found O.J. Simpson to be the same O.J. Simpson. And we're going to talk about a range of people who see this man from 11 o'clock on till the next morning till he comes back. We'll take them one at a time, but they all have one thing in common. It's O.J. Simpson. And he's acting normally. He's himself, not acting. And the thing that I think is probably best, and there are a number of good witnesses in that regard, but Howard Bingham is a well-known person around here, and let me end on this point. Howard Bingham gets on the plane, and it was funny because he was in coach, and he wanted to try to explain that to you, why he was sitting back there in coach, and O.J. was in first class. And he sees O.J., and he runs up there to say hello to him before the plane takes off, remember? And I asked him, well, how did O.J. Simpson seem to you this evening? He said, it was the same O.J. I've always seen and known. And so rhetorically, I ask you again, Howard Bingham, in this area for years, known O.J. for years, who do you think knows O.J. Simpson better? Howard Bingham or Marcia Clark and Chris Darden? When we come back, we'll answer that question. Thank you.
All right, ladies and gentlemen, we're going to take our recess for the afternoon. Please remember all my admonitions to you. We'll stand in recess until 6 o'clock. All right, have a pleasant evening meal.
Please 34.
We have back here that, which has helped all of us immensely, so thank you, Susan. Everybody says thank you. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good evening, ladies and gentlemen. It is strange to say that, but I appreciate your hanging in there. A little chilly? Okay. All right, Mr. Cochran, you may continue with your closing argument.
Thank you, Your Honor. Good evening, ladies and gentlemen. I'm glad you all came back. I appreciate that. Oh, I guess so. Now, where were we when we left off? We were talking about demeanor, Mr. Simpson's demeanor, and I think I had posed a question with you just before we took our break about Howard Bingham, the photographer who testified here, and I asked you the question, a rhetorical question, about who would know O.J. Simpson the better in his mood and how he appeared on this night, the prosecutors or Mr. Bingham, who'd known him for such a long time. It was a serious question because prosecutors, I presume, never met Mr. Simpson before we started this process. So I think it would be relevant for you to know about how somebody who knew him over a period of time saw him on that particular date, especially when they go into their doctor mode and they use terms like post-homicidal conduct. There's been no testimony in this case at all about post-homicidal conduct and about demeanor, about anybody acts in a post-homicidal conduct. That, again, is more speculation. But what we did in this case was we tried to call for you a number of witnesses who I think bear on this issue of demeanor, which it seems to us is totally relevant. For one thing, it totally rebuts this specious theory about any kind of a fuse or any rage that you've seen. We've done that. We've shared that with you already. And in the course of wrapping that up, keep in mind that both Cato Kalin and Alan Park fall into the category of demeanor witnesses who place Mr. Simpson's demeanor as being entirely appropriate. And these are people's witnesses. So it doesn't matter whether we call the witnesses or they do. If you're in a search for truth, you look and see if there's a common thread of truth that runs throughout these witnesses. And I think we found that. Now, one of the things that I wanted to share with you, yesterday, Ms. Clark in her argument tried to indicate something to the fact that Mr. Simpson didn't want Cato Kalin, I believe, to spend time with him or something of that nature, as though he wanted to get rid of Cato Kalin. It was part of her theory there. And I went back and I looked at the testimony at 19854, Ms. Clark herself, when questioning Cato Kalin, when you got to that location, what did you do? When I got to the door, yes, I turned. Okay, what did you see? OJ. And where was he? At the driver's side door of the Rolls. Did you say anything to him? No. What did you do? I looked and said, I'll eat in my room. And then he went off and ate in his room. But there was no, further on it says, did you have any conversation with Mr. Simpson? Answer was no. And he said nothing to you? No. So I think that was important to understand and put that record straight, that there was no discussion about whether Cato would go in the house with Mr. Simpson or whatever. They didn't talk. Cato went back to his room. Simpson was still out at his Bentley, presumably trying to get ready to go on this trip, which was long planned. There'd been some mention earlier of an argument at a Christmas party, and I wanted to again try and set the record straight before we went on with demeanor, because I pulled up Cato Kalin's testimony again. And what he says was that after question, did everybody go home together? Answer, yes. Everybody celebrate Christmas Eve back at home? Answer, at Rockingham, yes. Question, Nicole, OJ, and the kids? Answer, yes. Question, and yourself? Answer, and Arnell and Jason? Question, whole family? Yes. Now, what they do is they tell you, well, there was an argument at the Jenners, and what they don't tell you was, remember the testimony was, they left the Jenners to go back home because it was Christmas Eve, and they all celebrated Christmas Eve together. So you got to have the whole picture, don't you? Don't you think that seems reasonable? And there was some question about the flashlight, and here's what Cato Kalin had to say about that, where he says, then I said, OJ, do we have a better flashlight? And when I told him about the noise, he was going to take one way, I was going to go another way. But that is when I said, we have this lousy flashlight, we need another one. And so he was going to go inside and check. And then they went in the house, he followed behind. And then that's when Mr. Simpson had to then leave for the airport. So I think that, again, I promised you I would always try to read the actual testimony to make it as clear as I could about where we were. A few other housekeeping things before we get directly into the demeanor aspect. Ms. Clark yesterday had made a number of points about phone calls and boards to Paula Barbieri. And you'll recall we saw a number 305, which I think is in the Miami area code. And I think the evidence is that's a cell phone of some kind. And certainly if you call that phone number out here, you can reach people on a cell phone. And I find nothing unusual about that in regards to the calls that were made. There also was some discussion about what Dr. Batten had to say about these cuts or cut on Mr. Simpson's hand. You recall that Brian Kilberg came back down here again, and he asked some questions of Dr. Batten. And I tried to pull up this testimony so I'd have it clear about when Mr. Simpson had gone to the Bronco to get the portable phone, when he went back to the Bronco apparently to get the paraphernalia in that phone, and try to piece together as to when he got a small cut on his hand, not any large fishhook cut, which I think was clear from the evidence, at what point that he may have bled inside that Bronco and may or may not have known that. And so we read Batten, and this is at page 41182. Question by Mr. Kilberg, I believe. What, if anything, did Mr. Simpson have to say as to the manner when he got the cuts? Answer, that he recalls some blood after trying to retrieve his phone or some material from the Bronco, from a car that he had his phone. I think it was the Bronco, that he'd gone to the Bronco to get something and may have somehow cut himself while getting stuff from the Bronco to bring with him to Chicago. But I think that it's important to tie this in with the fact that, remember that Cato Kalin, and I think even Alan Park indicated, that by the time they were there, when Mr. Simpson finally came down the stairs when he left, there were bags already down. Certainly the golf bag and this other bag, there were bags already out there. So he'd been outside in that yard, and apparently, according to Ms. Clark's testimony, had been at some point out to the Bronco, and at some point he'd gotten this phone, this portable phone. But we know he'd gotten it because he'd made a phone call on that phone by 10 o'clock or by 10:03. Car wasn't moving. This is a portable phone. And remember, I asked Gigi Guerin, were there any portable phones inside that house? The testimony, there were none. So there was no wireless telephone at Rockingham. So I think the testimony is, and the reasonable inference is, that Mr. Simpson made that cell phone from that location to her cell phone number 305, area code. And then once they left, as I told you, they left with Park, and we know that was around 11:02. So now Mr. Simpson's in the car, and as you know how Park describes O.J. Simpson. Nothing out of the ordinary. He says he's hot, but that's nothing unusual. And then Mr. Simpson gets to the airport. Do you remember those two young men who came in? Michael Norris and Michael Gladden. And these are the two airport couriers who were parked at the curb there. And one of them, Gladden, wanted to get Mr. Simpson's autograph. You'll recall that. And so, even though Mr. Simpson was rushed and trying to get to the plane or whatever, he stopped and he gave his O.J. Simpson Peace to You. That was a signature that he gave at about, I think the testimony was 11:25 that particular night on June 12th. That was a testimony of Gladden. Remember, they described O.J. Simpson as being kind of like a model or some kind of a poster boy for these jeans or whatever he had on. I think the way they described it, they felt that he was dressed very neatly, looked very clean, is the way they described him. And he was very approachable. He put some luggage down and then turned around and forgot about the autograph and then gave the autograph. You recall that. It was very interesting because Ms. Clark said yesterday something to the effect, well, Mr. Simpson didn't put on his socks because he left his socks at home. Now, that was one of the most interesting things she said. You've been in this man's closet. You think that O.J. Simpson has one pair of socks? I don't think so. I think you saw his closet. You saw the clothes, the way they were lined up, and the way they were. In fact, remember, I asked the witness the question, is it trendy, is it fashionable that a lot of people in that part of town don't wear socks when they get dressed up to go out? Somebody said, yes, that's fashionable, that's what happens. O.J. Simpson has lots of socks. And the evidence is, and it's so interesting, isn't it? Because under the prosecution's theory, if you follow their theory, you're asked to believe that Mr. Simpson is in sweats and tennis shoes, and I presume tennis socks. That he gets this urge to go and kill his wife, and he takes off his tennis shoes and his tennis socks and puts on some dress socks and dress shoes. That doesn't make any sense, does it? But keeps on his sweat clothes according to them. That's how preposterous their theory is, to try to make things fit. And you're going to see, you're going to understand that even better when we talk about these socks. So as O.J. Simpson then gets on the plane. And it was interesting because not only did he deal with Norris and Gladden, but he had an interesting man in the first class across from him, Steve Valerie. You saw Valerie, a young man who, for pretty much most of that flight, watched O.J. Simpson. Mr. Douglas, what's that number, sir? 1245. 1245, it just gives you some idea of this plane. We've talked earlier about Bingham, and remember Valerie was right across from O.J. Simpson as he sat up there in the fourth seat or something like that. And he watched him and noticed him and described for you Mr. Simpson's demeanor. He looked at O.J. Simpson's hands. That was really one of the important things about it. Because, again, when Ms. Clark, who was Dr. Clark in this regard, talked to you about this cut or whatever, she was describing how a little cut wouldn't make this amount of blood, but this larger cut. By all of the witnesses who didn't know each other, O.J. Simpson did not have this fish hook cut on his hand when he went to Chicago. That's unanimous. All the witnesses. You heard them. You saw them. Further, you heard the testimony of Drs. Heisinger and Baden, who said, this is not consistent with a knife cut, it's consistent with some kind of glass cut because it's raggedy, it's jagged. Do you remember that? You remember the testimony? And we can prove it further by witnesses who saw him before He was in that room in Chicago, and witnesses who saw him after. And we'll talk about that. So on the plane was Bingham, and then we had the pilot on the plane. And the pilot who was flying the plane came back and asked Mr. Simpson to autograph the logbook, which he did, and I think we have a photograph of that. Again, you saw Pilot Stansfield, who described how Mr. Simpson was seated there reading a book, a light shining down on him, not trying to hide from anybody, not anything, sitting there reading his book, looked up, talked to the pilot, and gave his autograph, and they both continued on with their business. Then he gets to Chicago and he lands, and he deals with Jim Merrill, the Hertz driver. You'll recall him. The Hertz driver describes the number of bags that Mr. Simpson has. The luggage when he arrives, he describes the duffel bag, the black duffel bag, the garment bag with OJS, the golf bag, the Louis Vuitton bag. All those bags are described by Merrill. And then, of course, you remember we talked about the knapsack bag, which we think logically had golf balls in it. It was inside the golf bag. So Merrill watched O.J. in the luggage area meet with some, I think, say 20 different fans while waiting for his luggage. Merrill says he was friendly, relaxed, and he saw no noticeable cuts on his hands. That's what Jim Merrill told us. This was his testimony. So we brought him here from Chicago to testify in that regard. Now I want you to contrast Mr. Simpson's demeanor and behavior after he goes to this hotel room in Chicago. After he learns of his ex-wife's death, everybody is consistent. And again, these witnesses don't know this person. He was emotional, concerned with a cut finger. Dave Kilduff, and Mr. Simpson gets the call. Here's what I want you to think with me for a moment. I want you to look at how he reacts to this information. We've already covered how his daughter describes him. She's never heard him like this before. He immediately gets plane reservations to come back to Los Angeles. He's then trying to get back, frantically trying to leave this hotel. It's early in the morning. He's trying to get back to Los Angeles on the first thing flying. He's trying to get somebody to take him back to the airport. He's there to play in a golf tournament that day. Obviously, that's never going to happen. So we know that Dave Kilduff, the Hertz manager, drove Mr. Simpson to the airport. Remember how he describes? Now, this is the first witness. O.J. Simpson's finger is bleeding. And this fishhook cut, this cut that he got in that room when that broken glass was there. For the prosecutors, again, with a cynical view, say, well, that couldn't have happened. Dr. Baden says that in talking to Mr. Simpson, he got that cut when he brushed this glass into the sink. It's entirely consistent. Doctors deal with cuts, and they said this was consistent with a glass cut. Kilduff says that O.J. Simpson is crying and he's upset. He finally makes the plane, and I think it's important to note that when he makes the plane, he sits next, I think in seat 9, to a lawyer by the name of Mark Partridge, just fortuitous. And I thought it was very interesting about this man Partridge. Remember, he's the man who was a patent lawyer, who'd gone to Harvard, and he observed O.J. Simpson on this flight back. He saw him make these phone calls. He saw his emotional state. He saw him trying to gather information. He saw his finger. He saw the Band-Aid he'd had that came off. He saw that it was cut. You saw his testimony. These were all citizen timeline witnesses, like you or I, who were brought here pursuant to subpoena. They didn't ask to be here. They didn't volunteer, but they had relevant information about what had taken place and what had happened. So it seems to me that we, in our search for justice, in our journey toward the city of justice, must take these witnesses seriously. But you understand, with the power of the state, the prosecution had an equal access to all these witnesses, but they didn't call them. They didn't call them because they didn't fit. They didn't fit and they didn't want to hear. So the prosecutors decided to attack. And you'll remember how these witnesses generally were treated. I thought Partridge was treated especially bad. Here's a man who was so concerned about no one stealing his notes. He wrote notes about what took place. Not to publish them. He's a patent lawyer, so he understood. He put his name on the side in the margin to write down his notes because he knew it would be important. Remember he said he knew this would be important. And he sent those notes to the prosecution and to the defense. He said, I'm just a witness here. This is what I saw. Can I be of some help? They chose not to call him. They chose to attack him as though he had like something to hide. In fact, I remember Ms. Clark standing and saying something to the effect, well, do you know how busy the LAPD was when they didn't have time to respond to you? Well, maybe not. But this was an important witness. That was the only person in the world who sat next to O.J. Simpson on a flight back from Chicago when everything he was doing, continues to do, was consistent with innocence. They didn't want to hear it, but we brought this again for you to hear. And I ask you to judge this witness as you do all the others. You remember Mark Partridge, and I think you will. And remember that it was unfair to attack a witness, a citizen witness, who seemed to be totally objective and careful. Then there was Ken Barris, the police officer in Chicago. Ms. Clark talked about him coming out here, but we brought him out here. We brought Ken Barris out here. He was the police officer who maybe 3 hours after O.J. Simpson left that room, went into that room at the O'Hare Plaza, was it? 11 o'clock or thereabouts, I believe. He said he went in the room. He found the glass. He found the doily. He found the towel. He found the bedding because the maids had not done anything with regard to that room. He found this broken glass. And the evidence is, contrary to what the prosecutor would try to tell you, is that this glass was consistent with O.J. Simpson cutting his hand on it. And this is the cut as the Fisher cut. Now, you characterize witnesses like Cato Kalin and Partridge, Denise Pilnack and some others who felt the wrath of the prosecution, and you have to ask yourself why in a search for truth. Why did that happen? Then Mr. Simpson returns back from Chicago. And this was very interesting. And you will recall, because Officer Don Thompson, I saw some of you looking at him, he's a very, very impressive big fellow. He's about 6'7" or 8". He's a big guy. And you remember, he's the officer who is very interesting and very honest. Because he said that immediately upon Mr. Simpson coming back to Rockingham at 12 noon now, on June 13th, what happens? Van Adder had told him to hook him up. Let's see that if we can. We'll give you the number in a minute, Your Honor. You'll recognize Officer Thompson and Mr. Simpson. You notice he grabbed hold to him at that moment. You'll recall that Officer Thompson had testified how he'd been told by Van Adder to hook him up or to handcuff him. He grabbed him by the arm as he went in there. And you recall the photograph. I think that's Thompson there in the background, in the foreground. Mr. Harris had that, but at any rate, you'll recall Mr. Simpson was standing over under a tree and he was handcuffed until the lawyer Howard Weitzman came. You recall that because we saw that during the trial. Howard Weitzman, lawyer, he's talking to Mr. Simpson. See that Mr. Simpson is taking out Van Adder's going over to him and taking the handcuffs off, I believe, as the conversation goes on with Harold Weitzman. All right, he's unhandcuffed at this point. Thank you, Mr. That was number 1250, was it? 527? 1250, Your Honor. The point of that was, we have said, and I told you at the beginning and told you in the opening statement and told you again today, this was a rush to judgment. At 12 o'clock on June 13th, Van Adder told Thompson to handcuff O.J. Simpson or to hook him up. Van Adder lied about that because he said in his testimony he never told him that. Thompson was very clear that he told him. He didn't do that on his own. But it shows this rush to judgment. Van Adder did not want to admit that and never did. We'll talk more about him when we discuss the officers together. But it seems to me the important thing for us to remember is that after this video, Mr. Simpson, you'll recall, is on his way downtown in a vehicle with Van Adder and Lang. You remember Howard Weitzman talks to Van Adder. Simpson gets in the car with the police in the back. Goes downtown without either his business lawyer or Howard Weitzman. Rides with the police. We know, according to the testimony in this case, he talks with Van Adder and Lang once he gets down there. I think we asked both of them about this conversation. We've heard nothing else about this conversation. He has no lawyer in there with him. Has no lawyer in the car when he goes downtown. After he makes this statement to the police, which we haven't heard, he then gives a blood sample sometime around 2 o'clock or whatever that afternoon on the 13th. He voluntarily gives his blood sample. He then has a photograph taken of the cut on his finger. There's no lawyer present during all that. The lawyers are someplace else at that point. Mr. Simpson is dealing with this himself. He wants to clear this up. He's innocent. He wants to get it over with. Everything this man does is consistent with innocence. He finds out. He gets the first thing smoking. He comes back here. He goes right to his residence. He talks to the police. He goes downtown with the police. He goes in a room with the police. He has his finger photographed. He gives blood. His lawyers are off someplace else. That's what this man did on June 13th. They weren't there then. That's what he did, consistent with innocence. They want to talk about luggage. The testimony, again, of this honest police officer, Thompson, is that they wouldn't let O.J. Simpson's luggage on the premises. They talk about Bob Kardashian. They smear Bob Kardashian, a good and successful, decent businessman and friend. He can't come on the premises. They have to take the luggage away. Now, these people have search warrants. They can do whatever they want to do at that point. They have the power of the state. And they have the audacity to stand here and tell you that when retired Judge Delbert Wong brings in the Louis Vuitton bag months and months and months later, there's no clothes in it? Now, is that folly? They're not supposed to unpack it? That is silly. I shouldn't waste my time on it, but that's what was said here. You heard it. And they are the ones who turned away the luggage. So you remember that when they stand up here and try to talk to you about any luggage and they didn't have it or was in the luggage or was it. He brought the luggage back. And if he didn't have, by the way, that portable phone in his luggage, you'd hear about that also. So understand, we're going to talk about the facts, not any speculation. So what more then could an innocent man do? We talked briefly about the cut or cuts on O.J. Simpson's hand. It's interesting, isn't it? Because the one cut, and these officers are there with their photographer. They take a photograph of this cut. But you remember in those other pictures, there was a cut on the side of his finger here, or nick or something like that. Looked like a paper cut, I think they said. And it's interesting, because if that cut had been there, June 13th, at 2 o'clock or whatever time they took it, do you think the police would have taken a photograph of that? They didn't, because it probably wasn't there at that point. So it's very interesting. This is the only cut they got. But we know that he nicked himself in several places, according to what he told Dr. Michael Batten. Ms. Clark makes a big thing about some smear or some little tiny smear of blood in the bathroom upstairs. O.J. Simpson had been back home since Friday. Shaved, whatever. I don't know when that got there. He didn't know when that got there. Doesn't it strike you as strange that under her hypothesis, under her theory, he comes back home with these bloody shoes on, bloody clothes, with his white carpet, goes upstairs, there's no blood anywhere. A little tiny speck in the bathroom. Does that seem to you to be reasonable or rational or related to this case? One thing about blood spots, you can never date them. You can never tell generally how old they are. Another thing that doesn't fit, the fingerprints. They didn't call them, but we called. Gilbert Aguilar. You remember that. He's the fingerprint expert. He examined and dusted and found 17 latent prints that he was able to lift at Bundy. The crime scene, the gate, the fence, the front door. He was able to identify 8 of the prints after comparing the known exemplars of the known ones being the police officers and people that you might expect around there. But there were 9 identifiable prints that were never identified. Remember I asked about these various systems that you can put the prints in. It doesn't work for palms, but it works for prints. What efforts did you take to try to find out who do these 9 identifiable prints belong to? To this day, we don't know. Are those the prints of the real killers? We will never know. They have not found those prints. We brought this witness in for you. We established this for you. The fingernail scrapings. Mr. Scheck will talk more about this EAPB. But remember, there's no literature to justify how they'd want to contort and twist this. This double-banded B is more like a B than anything they can ever justify. And it doesn't fit. It doesn't fit in their case, so they can't explain it. It's like the number 4 allele on the steering column. There's no number 4s in this case. It doesn't fit. If it doesn't fit, you must acquit. They don't, and they cannot explain that. Dr. Irwin Golden, the missing corner. This man was trashed by his own department. It was brutal by his own boss. And if he thinks he was going to be treated any better, remember how Kelberg dismissed him at the end. He said, by the way, next time you come and testify, learn how to speak slower. That was his last remarks to a man. You look at your notes. His last remarks to a man he kept on this stand for 8 days to tell us that the cause of death was stabbing. The time of death was between 9 and 12. That it could have been a single edge, a double edge knife. That's how they treated their own witness they kept there, the coroner of Los Angeles County. But they didn't call Dr. Goldman. Why not? Why is that? Why are we left to speculate about that? They didn't like his testimony? He couldn't help them. It's the more logical and reasonable inference, isn't it? Whenever there's a witness that they couldn't fit within their little theory, they abandon him and talk bad about him. A rush to judgment. Detective Phillips, the very, very beginning of this case. Remember, I had Phillips as a witness. He's a nice man. And I quote him when he said, remember when he called the coroner after all these hours out there. Now, you remember, he's off the case by then, too, because, you know, the robbery homicide division has taken over. They find that out at 2-something in the morning, remember? And they wait for Lang and Van Etter to come until after 4-something. Here's Phillips still out there now. They're over at Bundy, and they call the coroner. It's like 8 hours later now, as I recall. And what does he say? There's a little tape, I think, that we may have. He says, I think, quote, we're sort of breaking the rules here. They're worried about how they're going to look. They're worried about the press more than they're worried about these bodies that are still out there, more than they're worried about people traipsing through that crime scene, more than they're worried about trying to protect the innocent and pursue the guilty, which they should be doing, which they're required to do under the law. Notify the coroner immediately.
We're kind of not following procedures, but we're kind of asking a favor and, you know, kind of work a little bit on this one.
Okay, you're at the scene now?
Yeah.
Okay, but what is your callback number at the station? 310?
575-8441.
Do we have names on these people?
No, I don't.
Okay, both males or?
A male, female, a female, and a male.
Alright, are they Caucasian?
It appears as both.
Sorta breaking the rules, not calling criminalists. This is in the early morning hours. You remember that? Look at your notes. It's like 8 o'clock or so, isn't it? 6 o'clock. Now it's 8 o'clock because they're back on Rockingham. It's 8 o'clock in the morning now. His bodies were found by Risky at 12:13. Coroner didn't come until about 10 o'clock. Remember that? Fung, when he does come, goes to Rockingham before he goes to Bundy. Sort of not following the rules. That's what this case is all about. Not following the rules. They're more worried about vanity and things like that, not about these victims. We can demand more and should demand more of our police, and it does become very relevant. Tied in with this, and so let me make it clear. We heard yesterday some snide comment about, well, we have the best witnesses that money could buy, or something like that in this case. Consider Dr. Henry Lee. By all accounts, the #1 criminalist in America, probably in the world. He didn't take any money. The money for his time that O.J. Simpson had to pay went to the state of Connecticut to help the police and police funds. You heard that testimony. So it's a real unfortunate thing when lawyers stand here and demean people with national wonderful reputations who come in here who get compensated only for their time. The only ones not being compensated for their time here are you, and we apologize for that. But these other witnesses, the law allows them to be paid for their time out of their offices. You heard that. Not doing this to make money, be subjected to this, be on television every day, have people probing into your private lives. Nobody wants that. It's not any fun for any of these people. But it's certainly not right to stand here and say things like that. And those aren't the facts at all, as you know them. Earlier I said that there had been an offer that doctors Lee and Baden and Wolf would assist the prosecution, not accepted, but they were out here, at least to the extent they were allowed to do things. You'll hear more about the testimony of Henry Lee on that. You remember how they rushed him to this thing when he came back from Seattle and how he was treated. That was the only time he seemed to be a little bit upset. He rushed back here from Seattle and how they treated him. This Los Angeles Police Department, that's how they treated the #1 criminals in the world in their search for truth. Then Detective Lang. Lang's different than these other detectives and things. You saw Lang for about 7 or 8 days. Lang is different. He made mistakes. He has misstatements, as you're going to see, but he was different. Remember that one day, and I'll tell you how you can characterize and understand he's different. It's very interesting. He'd been on the stand for 7 or 8 days. One day he came in and he was a little different. He was a little more testy, it seemed, and I asked him. I said, Detective Lang, there's an article in the paper today. That's part of the evidence.
Oral, it's in the record.
There's an article in the paper today where Mr. Darden says that you're being too nice in answering my questions. Are you going to be tougher now? You know about that, don't you? I said, no, Mr. Cochran, I'm just going to tell you the way it is, regardless. And no matter how you ask this man a question or what anybody would want him to say, he seemed to try and answer it as best he could. Now, we don't always agree with everything he did, but it was refreshing to have somebody like that who wasn't going to be told by these prosecutors, anybody else, what to say or what to do, even when he's criticized in the paper. That was Lang, but I said I didn't always agree with him because I asked him, I said, when Risky said about that melting ice cream, now we're not Henry Lee, not by a long shot, but it seemed to me that if there were ice cream that was still melting or partially melted at 12:40 when Risky saw it, and that's Risky's testimony, partially melted ice cream at 12:40 that they don't bother picking up, And that ice cream, remember when you were at Bundy? That ice cream is when you go down those steps, and it's on that little banister there as you were going out into the garage. Might mean that Nicole Brown Simpson went down there and was letting somebody out who'd been there earlier that evening. We'll never know. When he saw all those candles lit around the bathtub and water in the bathtub, we'll never know because they didn't bother checking. They were too worried about how they would look, notifying them, worrying about the press. We'll never know. They said the ice cream wasn't important. But it was important enough that they had, and this is the evidence, they had an ice cream melting test. Remember, I asked Lang about this again. Lang's experiment showed that this ice cream, it went back to Ben and Jerry's. It was Ben and Jerry's ice cream, remember that? It melted in an hour and 15 minutes. Should be totally melted by that time frame. If you extrapolate backwards, if Risky finds the ice cream at 12:40 and is partially melted, let's give him the benefit of the doubt, but let's say it's all melted. If you went back an hour and 15 minutes, that's 11:25. Now, if the children are asleep, Nicole's the one eating that ice cream, that seems important to us. Maybe not to them. That seems important. That's another bit of evidence. When you cannot, because of negligence and incompetence, determine the cause of death, you have to look at other things. Isn't that reasonable? Those are the facts, ladies and gentlemen. That's what happened in this case. So they tell you it's not important. We think that is important. Another factor. And you remember that photograph in the kitchen where there's a butcher knife on the table and you see some flowers there? Seems to me that when they came home, that butcher knife was used to cut whatever was off the flowers, if it was a string or some rubber band, place those flowers in a vase or whatever in that kitchen. You look at those photographs when you get a chance. And I'm always intrigued about the things they didn't do in this case, even Risky, who said, and it was candor was refreshing, have you had any training at crime scenes? He said, well, they kind of glossed over that at the academy. Remember he said that? People could have fallen over when he said that. They glossed over training at crime scenes at the academy. And boy, was that ever more true. The first officer on the scene told us that. We knew that right early on, didn't we? It's not anything we made up. It's not about being anti-police. You saw the police you could believe, and you now know the ones you can't believe. And anybody who believes that all police are perfect, that they don't lie, that they don't have the same biases and racism that the rest of society has, is living in a dream world. So this is not for the faint of heart. This is not for the timid. As I said, this is for the courageous who understand what the Constitution is all about. That's what we're talking about here. And so let's look at Risky at the very outset. In addition, he doesn't get any training, but he goes in the house and the first thing he does, he picks up the phone and uses it. I said, well, didn't you think that might mar some fingerprints? Or if it had one of those numbers where you could get the last number call, wouldn't that be important? Did you think about that? Well, he didn't think about that. Did you think about the fact that, you know, that you shouldn't be touching that phone and you have a rover? You have some on your hip, some way to call. You could have used those portable phones that Phillips had with all those private numbers on them. You could have done all those things, but you didn't use any of those things. You walked in there and then you didn't notice that on that phone in the kitchen, when they're looking so hard for Mr. Simpson, that there's a speed dialer that you press a button and it says Dad, and it says Nana, and it says all the people. If they'd wanted to notify the next of kin, when they press the button, they could have called Nana. But not these investigators. They didn't think about doing that. They're too busy hatching a plan, standing around in the street, doing nothing from 2 till 4:30. These are the facts. This is what you heard. This is this case, the so-called trial of the century. This is how they conducted themselves. And then we come to those socks. Those socks. They just don't fit. They just don't fit. They just don't fit. Watch with me now a video. I want you to watch the time counter in this time frame, and you'll understand how important this is. Now where it says 3:13 p.m., Mr. Willie Ford says, All right, back it up, please. This is Mr. Willie Ford going up into the bedroom. It's 3:13, which he says is 4:13 because it hadn't been changed. This is 4:13 p.m. on June 13th, 1994. Okay, thank you, Howard. You look at the foot of the bed there, where the socks are supposed to be. You'll see no socks in this video. And you'll recall that Mr. Willie Ford testified about this. And I asked him, well, where are the socks, Mr. Ford? I didn't see any socks. So now, that's interesting, isn't it? At 4:13, on June 13th, 1994, these socks, they supposedly recovered. These mysterious socks. These socks that no one sees any blood on until August 4th, all of a sudden. These socks that are picked up, that Looper says he picks them up because they just look out of place. I don't have any reason to pick them up. I'll just take these socks. They're out of place. The only items that they took out of that place on that day is Lang. Lang takes the Reebok tennis shoes, the ones he takes home. You remember that? That's all they really take because they don't come back on the 28th before they get that one brown glove. But these socks will be their undoing. It just doesn't fit. None of you can deny there are no socks at the foot of that bed at 4:13 p.m. Where then are the socks? Where are these socks? This important piece of evidence. Well, let me show you something. This board here was a board used by Dr. Henry Lee. And this is interesting. Bear with me for a moment as you look at this.
52. Thank you.
In this photograph here, the one on the left, Your Honor, so you notice something. The socks are at the foot of the bed. If you look close at this photograph, you'll see it. There's no little white card there. You notice how they put these little evidence cards there when they're going to collect something. No little white card on this photograph here. And this is interesting because you see these straps on the bed. Now, Looper told us when he testified, these straps were like, he called them some kind of luggage straps. And these luggage straps are down at this point, aren't they? See how they're down? And no evidence card, and the socks are there. And we come over to this photograph here. You notice how the strap is now up on the bed. It's no longer hanging down anymore. It's been moved up, and Looper says that's when he looks under this bed and he sees that photograph. By the way, how wrong can they continue to be? That's no wedding photograph. That's a photograph they took at some formal event. You look at that photograph and see. That's how they speculate, and most times they've been wrong. But this is interesting. The strap is now up on the bed. And you look at the socks. Now it's been posed for you. Here's this number 13 out here with these socks. Now, if you look back at that video, and you'll have it, you'll notice that the video has the strap down. So the video is at a time before this card is placed, before the strap is up, before this is about to be collected. Now, isn't that strange? Because at 4:13, there are no socks there. Now, how do we tie all this together? You remember, Fung and Mazzola have a log. And on their log, they tell when they collected things. They tell us that they collected the blood in the foyer at 4:30. That they then come upstairs. That they collect. Here it is as we speak. Got to move it over a little bit, Mr. Harris, I think. Do we? Now you see this. Where they collected things sequentially, and they kept this log. And I think that you'll remember the testimony that at 4:30, they collected the blood in the foyer. Remember that? Let me see if I can point that out for us. In foyer, red stain. And there's testimony. They testified at 4:30. 16:30 is 4:30. This is at least 17 minutes after Mr. Ford's up there with that camera where there are no socks, right? So 16:30, right there. They're downstairs. Then they say they go upstairs. They leave this time blank, but at 16:40, They go and they look at this little red spot in the bathroom. Remember that? And they say in their testimony that the socks are collected between 1630 and 1640. So let's give them the benefit of the doubt. 1635. How could the socks be there at 435 when you just saw they're not there at 413? Who's fooling whom here? They're setting this man up, and you can see it with your own eyes. You're not naive. Nobody's foolish here. And then they forget about this little strap exercise. When they're posing stuff here, they move this off the bed, move this under the bed. They're going to make a big thing about this photograph under the bed. And then they put this number down here and they take these pictures for you later. But they didn't know that we would know or find out about Mr. Ford's video. See, they took that video. You know, we talked about this early on. LAPD should always take videos of everything at that crime scene. They don't do that. But they took this video, not because they wanted to help Mr. Simpson. If anything was missing or got broken, this was a civil liability video. Remember, they was going around taking photographs of things that might be missing or whatever. There was ever a suit later on. But they got hoisted by their own petard again because the video has the counter and the number. They will never, ever be able to explain that to you because we got their testimony in black and white as to when they went upstairs and collected this. Those socks from the beginning have been a thorn, and it's going to bring them down. So those are the socks, these socks. No dirt, no soil, no berries, no trace. Nobody sees any blood until August 4th. And all these miraculous things start happening. And then, Mr. Sheck will talk more about this, then we find out it has EDTA in it. It's a planet along with that back gate. How would it be on there? Why didn't they see the blood before that? There's a big fight here. Where's the dirt? Why would Mr. Simpson have on these kind of socks with a sweat outfit? Wait a minute. Now, you don't have to be like from the fashion police to know that. You don't wear those kind of socks. You wear those kind of socks with a suit. You don't wear those kind of socks with a sweat outfit. Doesn't make sense to you that those socks were in that hamper from Saturday night when Mr. Simpson went to that formal event. Those kind of socks is what you wear with your tuxedo when he was dressed with those other ladies. If they went and took it out of the hamper and staged it there, then you see what happened. Is that not reasonable under these facts? I think you'll agree it is. It's the only reasonable explanation. It's posed there, and the reason for doing this is because they were out of place. But isn't that interesting? In the hamper in which Looper went and they all went, they didn't take anything else. You think the police would ask, Mr. Simpson, what were you wearing in addition to suits? What were you wearing that night? They didn't take one thing. Yet we hear all of this talk about, wonder where the clothes went, wonder where the clothes went. You think Mr. Simpson, who told them everything, who cooperated with them fully, told them like he told them about those shoes, what he was wearing. They didn't bother collecting those, did they? No towels, no nothing. She's worried about him taking this quick shower. If he took a shower and there's so much blood and he's covered with blood, why didn't they bring the towels in here? Something is wrong in this case. It just doesn't fit. If it doesn't fit, you must acquit. So the socks, I could talk about these socks forever, but I'm not going to because Mr. Sheck will talk about the forensic aspect of it. But let me just remind you of two quick more things. Dr. Herb McDonald came in here and he told you there was no splatter or spatter on these socks. These socks had compression transfer. And he used his hands to show you somebody took those socks and they put something on them. And it went all the way through to side 3. Now, with all their experts, bring people back 3 or 4 times, they never had anybody to contravene that. How'd that get over to side 3? How'd it get over there? It wouldn't get there if there was a leg in the sock. Can anybody explain that? Any of you explain that? Maybe Ms. Clark can explain that. The experts can't explain it. Something is wrong. And then finally the EDTA, which indicates the anticoagulant from a purple top tube. That's where that blood is from. The socks, as you know, is something that one can get emotional about because we've known about these socks for some time. This is, to say the least, disturbing. It's worse than that, though. In my opening statement, I told you about evidence that would be compromised, contaminated, and corrupted. And I told you something then. I said, in this case, there's something even far more sinister. The socks are one example of that. Now, if you want to be fair, decide in this case, you got to deal with these socks. You'll get a chance to see them. Look for the dirt that you expect on them. Look for the spatter that you expect on them. Look and see why it went over to side 3. There's a leg in it. And, you know, isn't it interesting how you get this blood on this sock with your pants? Your pants have to be almost up. This would take a real contortion to do it. There's no way they can explain it. So let's just leave it where it is, and Mr. Scheck will pick up on that. And then we've heard a lot about the so-called blood in the Bronco. And I want to tell you I'm not anything like a scientist. In fact, when my mother and my father wanted me to become doctors, I didn't because I wasn't that good at science. So I became a lawyer so I could talk. But let me tell you something. Even I know about amounts of blood, especially after this case. They tell you about all this blood in the Bronco. And you remember one of the early witnesses testified the total amount of blood on this console is 0.07 of a drop of blood. Now that's supposedly a mixture of Goldman and someone else. So now I'm going to do a little Henry Lee experiment, and I hope that it doesn't cause you any problems. Now 0.07 of a drop.
Douglas, you're going to have to take this down.
That is your Honor. 0.07 of a drop. Not even that much is the amount, the testimony in this case is, of the alleged blood on that console. Now, this is an amazing thing because you remember this is the vehicle in tradition of everything else they did in this case that's picked up. It's towed away from Rockingham. You've all seen that photograph. It's taken over and ultimately it ends up at Vertel's. Remember Blazzini? William Blazzini. Before we got to Blazzini, we dealt with John Mraz. Mraz says that the vehicle was just open. You can just go get in it. The press was waiting for him before he even drove it back. Everybody knew this was O.J. Simpson's vehicle, and they were all looking in it, supposedly for all this blood that's supposed to be in here. This killer must have been covered in blood. And they say he drove this Bronco, and he got in the, it'd be covered with blood, wouldn't it? So everybody's looking for the blood. So Mraz said, he gets inside the car, he didn't see any blood. Mraz said that. They maligned Mraz because Mraz said, yeah, I did take those receipts out of there that had, one had Mr. Simpson's name on it, one had Mrs. Simpson's name on it. But he said he didn't see any blood in there. They never called anybody to contravene that. But we want to make sure you understood what was happening. So we called William Blazzini, the man who works for Pick Your Part as far as vehicles. And he was a pretty good witness, wasn't he? He said, look, this is my business, is looking in cars because I go in and buy them. He says, I got in that car on June 21st. And first of all, I said, I went looking for blood because I'd heard in the news there's going to be lots of blood in this car. So I went and got in the Bronco. It's not secured as usual. Bob Jones said, oh, there it is over there. Go get in it. Now, this is the same vehicle. No holes on it. Could be released to Hertz. LAPD at work. He gets in the car on the driver's side where he stays almost 5 minutes, looking down, looking for blood, looking in the front. And remember, he takes his fingerprints or hands and puts them in the mirrors, kind of like a souvenir, in the right front window of the car. Doesn't see any blood. He looks all over for blood. Then he gets out, walks around, and I guess on the rear panel, says, I'll leave him again. Puts his fingerprints there again. And he walks around, looks inside the driver's side, looks back, looks all down on the console, looking for blood. He's looking for blood, ladies and gentlemen, on June 21st. Doesn't see any blood. Then he gets in the car. I ask him, did you look on the dash? Did you look on the door? Did you look on the console? Doesn't see any blood. He says that the patch on the bottom was cut out, the floor mat there. Doesn't see any blood. And Miss Clark cross-examined this man. He said, look, Bronco's kind of high up. When I was getting ready to get in there, I rested my hands on the thing, and I looked right up there, and there was no blood in that Bronco. Now, this is very strange, isn't it? Here's the Bronco that has blood that appears, disappears, and then reappears, and then disappears. This is a vehicle that's supposed to be secure, but it's not secure. Everybody gets in it. Mirage got in it, takes stuff out that could have been helpful. We know that there was a receipt in there from Nicole Brown Simpson. There's testimony. She rides and drives that car on occasion. That's forever lost to us because they didn't do their jobs again. Blazzini comes along. There's no blood in there. How do you explain all this when they talk about, they stand up here and talk about an ocean of evidence and, I mean, as I said, it's a little tiny trickle of a stream, if anything. They're just words that they use. So this Bronco is particularly troubling. Less than that, 7/10 of that drop of blood is what's in that alleged console. Dr. Batten says the perpetrator would be covered with blood. Your common sense tells you the perpetrator would be covered with blood. A 5 to 15 minute battle and struggle of this dimensions. And so, it just doesn't fit. Something is wrong. How does anyone drive away in that car with bloody clothes, with no blood there on the seats, no blood anyplace else? Every police officer came in, talked about how bloody this scene was. It doesn't make any sense. You can't explain it because Mr. Simpson was not in that car and didn't participate in these murders. That's the reasonable and logical explanation. None other will do. And it's too late for them to change now with these kind of shifting theories. So the prosecution then has no shoes, no weapon, no clothes. They don't have anything except these socks, which appear all of a sudden under these circumstances. Now, when you want to think about the depths to which people will go to try to win, when you want to talk about an obsession to win, I'm going to give you an example. There was a witness in this case named Thano Paradas. This is a man who's their man who took O.J. Simpson's blood. This is a man who had a subpoena at one point, said he could have come down there and testified. They didn't call him. So by the time we wanted to call him, he's unavailable because of his heart problem, remember? So what we did was we read you his grand jury testimony, I believe, and we played for you his preliminary hearing testimony. And in that testimony, he was very, very consistent. Been a nurse for a number of years. You saw him. Works for the city of Los Angeles. Says that when he took this blood from O.J. Simpson on June 13th, he took between 7.9 and 8.1 cc's of blood. That's what he said. That's real simple, isn't it? We knew that. It's sworn, tell the truth, under oath, both places. Grand jury and preliminary hearing. Pretty clear, isn't it? Pretty clear. Except you remember that in my opening statement I told you, I said, you know, something's wrong here. Something sinister is here. Something is wrong. Because if we take all their figures and assume they took 8 cc's of blood, there's 6.5 cc's accounted for. There is 1.5 cc's missing of this blood. There's some missing blood in this case. Where is it? Prosecution wants to explain that for you too, make everything real easy for you. So what do they do? What do they do? We've been talking about the police here before, but what do they do? Hank Goldberg doesn't give us any notice. Goes out there with the video camera with Oppler and this other lady, Miss Ramirez. And they take this bizarre home video of Paradas sitting there talking and mouthing words. It's the most bizarre thing. I mean, it's yours. I'm sure you've seen some pretty high quality testimony here. But this was bizarre. He's sitting there talking about, well, you know, gee, I don't really remember how much I took, and he's going through all these gyrations. It was sad, the depths to which they had sunk to try, as part of this cover-up, to try and convince you that this man hadn't taken 8 cc's of blood. And at the very end of this case, we put in a syringe for you, the kind of syringe they used. And this syringe, is interesting enough, has markers on it. Not only, this wasn't a guessing game, it has 8 cc's right on it. I think it was a 10 cc syringe. It's like proof by what she says. You know, there's conversations and there's conversations, but she has the conversations on tape. These prosecutors, if you don't fit, you're going to have trouble. So much so that when Mr. Darden is questioning her, remember her famous response? Quote, "Why are we having this adversarial conversation? Why do I detect this negativity? I'm just here to tell the truth. Aren't you in a search for truth, Mr. Prosecutor?" She said that. And then they wanted to ask, well, why didn't you stop him from using this so-called N-word? She said, I was in a journalistic mode. I didn't try to stop him from using that word any more than I tried to stop him from talking about cover-ups where male police officers have no respect for women police officers because they don't cover up the misdeeds. But that was her testimony. From that witness stand, you saw her. She's credible, don't you think? She has tapes to back her up. But look how she was treated by this. And Mr. Darden said something very interesting today. He said, I'm just the messenger. Now, how many times have you heard that? I'm the messenger. Don't blame me. I'm just doing my job. That's no way out. He's a fine lawyer, but he can't hide behind just being the messenger. Well, whose message is he sending? Who is he representing in this message? He's a man of integrity. That statement is not going to fly. I'm just the messenger. He's not any messenger. He's the prosecutor with all the power of the state of California in this case. We're not going to let that get away. They're not going to turn the Constitution on its head in this case. We're not going to allow it. And so now let me bring you to a segment of this discussion where we talk about if you can't trust the messengers, watch out for their message. Van Adder, the man who carries the blood. Furman, the man who finds the glove. Remember those two phrases. Van Adder, the man who carries the blood. Furman, the man who found the glove. Now, Detective Van Adder has been a police officer for 27, 28 years, an experienced LAPD robbery homicide man. He was put on this case because of his experience, presumably, because they had the resources downtown. You know what time he got there and knew what happened. One of the things that has been totally unexplainable to me is the fact that here you have Mr. Simpson cooperating fully, gives his blood. He gives 8 cc's of blood, we now know. Van Adder, the blood is then turned over to Van Adder. Now, we know that he could have booked that blood in Parker Center, or he could have gone over to Piper Tech. You see these two residents here. Thank you, Mr. Douglas. And Your Honor, this is, okay, this is just the board. Apparently there's not a number on this. He's at Parker Center, right over here in the police building, right down here at 150 North Los Angeles Street. Takes this blood. Could have gone a couple of floors and booked the blood. Their manual requires. But he didn't do that, did he? Could have gone over to Piper Tech, another facility right downtown here, and booked that blood. This is the reference sample of Mr. O.J. Simpson. He doesn't do that. What he does is he goes way out to this area marked Brentwood Heights. Must be 20, 25 miles, 20-some miles to go way out there, carrying the blood in this unsealed gray envelope, supposedly. Why is he doing that? Why is Van Adder carrying Mr. Simpson's blood out there? Why is he doing that? Doesn't make any sense. Violates their own rules. Why is he doing that in this case? Has he ever done it in any other case? No. Name another case where this has happened. Or you can ask him those questions all the time with Bushy. Officer Bushy, when have you ever sent 4 people, 4 detectives over
to notify somebody who's not even the next of kin. Well, Mr. Carter, there must be somebody, but I can't name you a case. There are no cases. These are the things they did in this case. So he goes way out there with that blood. Why did he do that? Doesn't make any sense. And so we know because much of what happened here is on video. It's the strangest thing about this blood. He can't explain either why he carries it out there. And then it gets even stranger, doesn't it? Because supposedly, after the blood is carried out to O.J. Simpson's residence, Van Adder gives the blood to Fung, according to what we hear. But Fung then uses some kind of a trash bag, a black trash bag, and gives it to Mazzola, but he doesn't tell her that it's blood. Isn't that bizarre? Remember the video when Mazzola's walking along carrying it, almost bumping into the hedges and the shrubbery? It's the most bizarre thing you've ever seen. She doesn't even know it. And then, talk about cover-ups, Mazzola is asked, well, did you see when Van Adder gave the blood to Fung? And she says, no, I had sat down on the couch and I was closing my eyes in Mr. Simpson's couch at that moment. I wasn't looking at that moment. Sound like a cover-up to you? Always looking the other way, not looking, don't want to be involved, covering for somebody? It's bizarre. Absolutely bizarre, and it's untrue. It doesn't fit. So Van Adder, the man who carries the blood, starts lying in this case from the very, very beginning, trying to cover up for this rush to judgment. Those are words. That's rhetoric. Let me prove it for you. He tells us, and this is a board. The board's entitled Van Adder's Big Lies, the man who carried the blood. He tells us that O.J. Simpson is not a suspect. That's the biggest lie we've heard probably in this entire trial. O.J. Simpson is not a suspect. They handcuff him within 30 to 45 seconds of the time he gets back here. He lies about that. Weitzman succeeds in getting him unhandcuffed, and they take him downtown. But he does more than that. Not only does he lie about that at the beginning, he then feels comfortable enough to talk to these two brothers, the Fiato brothers, and an FBI agent named Wax. And isn't this bizarre that the lead detective in this case, put on here because of his experience, is talking with these two guys who've been in this witness program for quite a while, testifying for the government. Now, we know that in a rather unusual set of circumstances, they're in a room somewhere in some hotel drinking beer. It's not even Van Adder's case. And they're sitting around talking. And I asked the FBI agent, weren't you a little surprised that a detective would be talking to these two people about the Simpson case? Well, we found out that there was a relationship allegedly between Denise Brown and one of these brothers, and maybe he felt comfortable. But why would he do that? And what does he say? He tells them that we didn't go up there to save any lives. O.J. Simpson was a suspect. The husband is always the suspect. But then he comes into court here, this lead detective, takes the stand again and lies to you under oath. Says, oh, well, no, I never said that. Never said that. That'd be a mistake if they said that. I never made that statement. He lied. He lied from the very beginning. He lied when they went over there. Then they bring in Commander Bushy, an otherwise good man. They get him involved in this. Let me tell you something interesting about what you heard about Phillips's voice. Phillips was talking to the coroner's office about 7, 8 o'clock in the morning on June 13th. The man asked him to identify, well, yes, we have one male, female, one white female, one white male, as though he didn't know the names or whatever. Now, this is 5.5 hours after Bushy said, go over and notify O.J. Simpson, who's not even the next of kin, because we don't want the family to find out about this like they did in the Belushi case. Remember he said that? Now, he's doing all this from his house, from his home. Phillips, if you look through his testimony, look back through your notes as to when he says he knows who this person is. But isn't it amazing that the children are already down at the station? They're at her house. They got a phone with a speed dialer. They know.
Bushy knows they don't follow his orders out. They stand out in the street, not investigating, stand out in the street, planning, doing whatever they're going to do. But one thing they do, they decide that O.J. Simpson is a suspect in this case. And let me tell you why you're going to know that. They want to talk a lot about 1985, but he missed the whole point. In 1985, something interesting happened in this case. In 1985, Mark Furman responded to a call on Rockingham. Mark Furman is a lying, perjuring, genocidal racist. And from that moment on, anytime he could get O.J. Simpson, he would do it. That's when it started in 85, when Farrell asked all the officers at West LA, or 10 of them, you know anything about this residence? Only one steps forward. And what does he say? It's indelibly impressed in my mind. That call back in 85, 4 years later, sits down and writes a report. And now, he knew what he was going to do on this particular night. So, O.J. not a suspect, went to save lives. They wanted to get a search warrant. That's why they were lying. Denies the statement to Wax and Fiato. Then, to get that search warrant, he lies to a judge. He says in the search warrant that O.J. left unexpectedly from Chicago. And there's some writing on the search warrant. I think it's in evidence. And it's kind of interesting because everybody knew. Cato knew he was going to Chicago. Everybody knew he was going to Chicago. It wasn't any unexpected trip, but I suppose it would help out. In fact, if you think about it, Ms. Clark said this. Well, that's why those socks were out there and everything, because he left in a hurry, like he had one pair of socks. We know why those socks were out there. He left unexpectedly to try and justify what they were doing. It all comes back to Furman when he says in that letter, if I see an interracial couple, I'll stop them. If I don't have a reason, I'll make up a reason. This man thinks he's above the law. Even Darden, Mr. Christopher Darden, my friend, has to admit, he said it was textbook what's happened to their witness, not our witness. And so he lies to the judge. He lied to the judge. He's lied to you as jurors. Then he says that Arnell and Cato said O.J. left unexpectedly. That's written in the warrant. Never say anything of the kind. Cato knew this was a planned trip for Hertz. He talked to Kathy Randa. Then in the search warrant he puts that it was confirmed there was human blood on the door. That's never been tested, even to this day. Another lie in this search warrant. He denies telling Thompson the order to handcuff O.J. Simpson. Then he lies about O.J. Simpson's blood. Remember during his testimony, he got that blood about 2:30 and he was trying to push it back an hour, so we're like maybe 3:30, because he had to explain, it's hard to explain those hours in there. What's he walking around with this man's blood for? For 3 hours before he goes back out to Rockingham at 5:30? What's he doing with this blood? So he has an hour in there, and you look at his testimony, he lies about it, between 2:30 and 3:30. Then Furman testifies, between these two, I don't know who you can believe. When Furman testifies, something about that, when he talks to Cato, Cato tells him about these thumps, that he doesn't tell anybody about it. He's so central to this case. He's got to be the big man and go solve this entire case. He doesn't tell the rest of them. Remember, he goes off all by himself for 15 minutes. Just walking around, he goes off by himself somewhere, supposedly where he supposedly finds this glove. No opportunity? We'll be talking about that. But Van Adder comes in and says, well, yes, the Furman told me about the thumps on the wall, contrary to what Furman had said. So these are the lies of the co-lead detective in this case. If you cannot trust the messenger, you can't trust the message that they're trying to give you. You can't trust the message. So this man who starts to lie from the very, very beginning, I'll leave it up just a second. We've covered the lies and the things that he did. And then they rope in Commander Bushy. Try to back him up by saying, well, I'd ordered them to do this, a direct order to do this. But isn't that interesting now? Let's think about this. You look at those logs and see how many police officers came out to Bundy and Rockingham. Maybe more than 30. You think that of those number of officers, that maybe one of them, maybe one of the patrol officers could have went to give the notice? It took all 4 detectives, all 4 LAPD experienced detectives to leave the bodies. They had notified the coroners. They didn't have a criminalist to go over to notify O.J. Simpson. Who's fooling who here? This is preposterous. They're lying. Try to get over that wall, to get in that house. If you don't believe so, you're talking about saving lives? Remember what Arnell said. First of all, they all make this big mistake. They forget, and they say, well, when we leave from the back, we go right in that back door of the house there. We go right in the back door. But they forgot. Arnell Simpson comes in here and testifies, you can't go in the back door because, remember, Cato had put on the alarm. You had to go around the house to the front. Arnell had to open the keypad to let them in. Remember? You think who knows better? You think she knows better or they know better? She had to open the door to let them in. They're so worried about dead bodies and people being in that house and saving lives. Who goes in first? Arnell Simpson goes in first. These big, brave police officers. And the young lady just walks on in there first. They don't go upstairs looking. They just want to be inside that house and make her leave. Or give Furman a chance to start what he's doing, strolling around the premises and doing what he's doing there. Then we come to Detective Phillips, a nice man, but even he makes misstatements in this situation. Now, he knows Furman probably better than anybody because he's the one who calls Furman. He's the one who works with Furman. Furman, in the culture of LAPD, has been promoted. We have heard that in '85, when he goes out to this incident, he's a patrol officer. Now he's a detective, moving up in the ranks, working with Phillips. And Phillips calls him after 1 o'clock. Furman's been somewhere down at La Quinta in the desert, and he comes back supposedly. And he gets this call to respond to this location. And even Detective Phillips, in this case, and I examined it, when asked, well, Furman told you, didn't he, about his going out on that call in '85 about this so-called domestic discord and then the '89 situation. You knew about that, didn't you? Phillips, oh, no, I never knew anything. Nobody told me anything. I don't know anything about that. No, I didn't. And then Lang comes in here. And in Lang and Van Adder's report, right in the report, and it's in evidence, Exhibit 1021, Lang directly impeaches Phillips, that Phillips did tell him about the '85 incident. The Furman had told him he'd been out on it. And why would he do that? Now, these are facts, ladies and gentlemen. This is what happened in this case before your very eyes. Not anything I'm making up. And who would know Mark Furman better in this case? His lack of credibility, his lying, racist views than Ron Phillips, his supervisor, who apparently chose to look the other way, and I'm sure he's as embarrassed as anybody else by this disgrace, Furman. So it's important at the outset that we understand the role of Phillips, as we need to understand the role of Van Adder. He was the one allegedly given this order by Bushy to go over and give the death notification. He didn't comply with it until much later. And presumably the reason they were going to go over was to give the notice to Mr. Simpson, and Furman was going because he was needed. Now, can you imagine this? Furman, with his views, genocidal views, was going to go over to give notice to O.J. Simpson to help O.J. Simpson in his time of need. Can you imagine that? He's going over there to help him with his kids. That is ludicrous. So from risky to bushy, you've seen and are seeing a part of this code of silence, this cover-up. The cover-up that Laura McKinney talks about, where male officers get together, cover up for each other, don't tell the truth, hide, turn their head, cover. You can't trust this evidence. You can't trust the messenger. You can't trust the message. When Furman gets on the witness stand and says, I haven't used this N-word for 10 years, think Phillips knows he's lying? Some of you probably knew he was lying. It took those tapes to make those of you who didn't believe these kind of things exist to take place. Didn't he have an obligation to come forward under those circumstances? For if Furman would speak so candidly to this lady that he met in a restaurant in West LA, you think he talks like that to the guys on the force? She talked about, he said those words in police administration and police procedures. That's the way he talks. That's the way he is. Nobody came forward to reveal this. We revealed it for you. Let me just take a moment. This whole thing about the police and what they've done in this case is extremely painful to us, and I think to all right-thinking citizens. Because you see, we live in Los Angeles and we love this place. But all we want is a good and honest police force where people are treated fairly, no matter what part of the city they're in. That's all you want. So in talking to you about this, understand there is no personal pride. But I told you when we started, this is not for the weak or for the faint of heart. And so let's move on. Then, just wanted to show you this part from Detective Phillips. This is what was asked of Phillips at 15084. Mr. Simpson and Miss Nicole Brown Simpson had been embroiled in previous domestic discord situations, one of these resulting in Mr. Simpson having to go to court. You told them that too, didn't you? Answer, Phillips, I never told him that. He's talking about to Lang. So if, my question, if Detective Lang so indicates in his report, he's wrong. Answer, if he tells you that, I told him that, he may have learned that from Detective Furman, but he didn't get the information from me. I never knew that. Then when Lang came in, I asked him the question about this same area. I asked Lang this question. So let's look at it together. Does that report indicate that Phillips stated that victim Brown was the ex-wife of O.J. Simpson, the well-known athlete actor? Answer, yes, it does. And does it say, additionally, Phillips stated that Mr. Simpson and victim one had been embroiled in previous domestic violence situations, one of which resulted in the arrest of Mr. Simpson? Does the report say that? Yes, it does. And he goes on to talk about, Phillips told you that, didn't he? And he goes on and says, but he told you this before you went over to Rockingham. Isn't that correct? Answer, yes. And so even Phillips was then impeached. And then Phillips tried as best he could to be a team player. It seems as though they got together, and Mr. Clark tried to make a big thing out of this, but here's how he described Mr. O.J. Simpson when he told him that Miss Nicole Brown Simpson had been found dead. What do you mean she's been killed? Oh my God, Nicole is dead. Do you recall that testimony? Yes. What do you mean she's been killed? Oh my God, Nicole is dead. Now, is that a question or is that a question? What do you mean she's been killed? They want to make something, I mean, is that preposterous? And then he goes on to say, he became upset and made that statement. Then he continued to be upset, continued to talk on the phone to himself. It took me several seconds to get him to talk to me again, to have him listen to me. And he seemed very upset. And these prosecutors would tell you, oh boy, that's something unusual about that. Anything unusual about that? What do you think? He just kept repeating over and over again that Nicole had been killed. Eventually, when I got his attention again, is when I mentioned the children. You have to remember, this conversation took place very quickly. He was talking, and I was talking, and everybody was a little excited. That's what Philip said. And so, again, what I hope that I've done here is to let you share exactly what the testimony was. Then I asked Arnell about it. She said he was very upset. He was crying. He was saying, Arnell, I don't understand. He was very upset, emotional. Have you ever, at any time in your then 25 years, heard your father sound like that? Answer, no. She says he was upset, distraught, emotional. And then she describes him on that evening after he comes back from Chicago. He was seated with my grandmother, my Aunt Shirley, Bob Kardashian was there, the family and friends. Some of his friends were coming and going. This was in the family room. Now, with regard to his demeanor and how he appeared, describe again for the jury how he appeared before he left the room to go to some other place. How did he appear to you then? He was just very upset. He was crying off and on. We were watching the news, and he kept talking to the TV saying, you know, I can't believe this, I can't believe this. In shock, upset, and disbelief. And I've read the other part for you about the police officers going in the back door, but she describes how they walk around and she opens the alarm. She's the one that went in and let the police in, and she's the one who walked in first. And then even Tom Lang. It's a personal favorite of mine, but in his instance, I think there are probably more mistakes than anything else. Human foibles, and he seems to be quite different than some of the others. Remember, he told us how he took these tennis shoes that O.J. Simpson told him he was wearing. And I said, what'd you do with those tennis shoes? He said, well, I took the tennis shoes and I put them in the trunk of my car. I was going to take them home for the night because it was too late to book them. Then we looked at this video. And the tennis shoes he got, remember, he put the tennis shoes in the front seat with him. Maybe he stopped halfway up the road on the freeway and put them in the trunk. But that's not what he did then. And then he was part of the group who says O.J. was not a suspect. Turns his head, perhaps. Maybe that's his partner. You notice he wasn't involved in this whole debacle with these Fiato brothers and Agent Wax. He wasn't involved. He's smarter. He wouldn't let that happen. And you know what? It's interesting because it's his case. That's his case that they're working on. You see him come running in here, trying to cover for anybody. He didn't do that, to his credit. And then we come, before we end today, to Detective Mark Furman. This man is an unspeakable disgrace. He's been unmasked for the whole world for what he is, and that's hopefully positive. His misdeeds go far beyond this case because he bespeaks a culture that's not tolerable in America. But let's talk about this case. People worry about this is not the case of Mark Furman. Well, it's not the case of Mark Furman. Mark Furman is not in custody. He's not. That's the man who they're trying to put away with witnesses like this, a corrupt police officer who is a liar and a perjurer. You know, they were talking yesterday in their argument about, well, they said, well, gee, would you just think he would commit a felony? What do you think it was when he was asked the questions by F. Lee Bailey, so well put? And we'll talk about that at the very end, about whether he'd ever used the N-word in 10 years. And he swore to tell the truth. And he lied. And others knew he lied. But what I find particularly troubling is that they all knew about Mark Furman. And they weren't going to tell you. They tried to ease him by. Of all the witnesses who've testified in this case, how many were taken up to the grand jury room where they have this prep session? They ask him all these questions. Ms. Clark, and I went back and I read again her introduction of Mark Furman. How many witnesses did they do that with? Well, they took him up there and they prepared him for this because, you see, they knew about the Kathleen Bell letter, but she didn't fit. She didn't fit in what they wanted. They didn't want her. They'd rather malign her and believe this lying police officer. So they knew. Make no mistake about it. And so, when they try to prepare him, talk to him, and get him ready, and make him seem like a choir boy, make him come in here and raise his right hand as though he's going to tell you the truth and give you a true story here. He knew he was a liar and a racist. There's something about good versus evil. There's something about truth. Truth crushed to earth will rise again. You can always count on that. And so when Miss Clark so gently puts him on the stand and talks to him about, tell us how you feel about testifying today. Nervous? Okay. Reluctant? And all the things about this bad lady, Kathleen Bell. They brought it out at the beginning. This bad Kathleen Bell saying all these mean things about you. Oh, and you don't know her even, do you? We asked you to look at her on the Larry King show, and you didn't recognize her. You don't know her. Oh, well, it's just terrible, all these bad things are happening to you, Detective Furman. Go back and you look at your notes of how the testimony was as they tried to bring him in here and pass him off. These things were all happening. Kathleen Bell letter was in 85 and 86. Same time he went out to O.J. Simpson's house in 85 that they want to talk so much about. What they're talking about is not even relevant. What we're talking about now is what happened in this case. And so, after having made all these denials and been adopted and accepted by the prosecution and put him on the stand, and you saw it. It was sickening. And then, my colleague Lee Bailey, who can't be with us today, but God bless him wherever he is, did his cross-examination of this individual. And he asked some interesting questions. Some of you probably wonder, well, gee, I wonder if he's asking that. He asked this man whether or not he'd ever met Kathleen Bell. Of course, he lied about that. Never met this woman. I don't recognize her. I don't know her. Gee, I don't know anything about that. Boy, and he sounded really convincing, didn't he? He says, quote, I do not recognize this woman as anybody I have ever met. That's what he says. Then Bailey says, have you used that word, referring to the N-word, in the past 10 years? Not that I recall, no. You mean if you call someone a nigger, you have forgotten it? I'm not sure I can answer the question the way it's phrased, sir, and they go on. He says, Bailey then pins him down. I want you to assume that perhaps at some time since 1985 or 86, you addressed a member of the African-American race as a nigger. Is it possible that you have forgotten that act on your part? Answer, no, it is not possible. Are you therefore saying that you have not used that word in the past 10 years, Detective Furman? Answer, yes, that is what I'm saying. Question, and you say under oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Furman? That's what I'm saying, sir. So that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar. Would they not, Detective Furman? Yes, they would. All of them? Correct? All of them. That's what he told you under oath in this case. Did he lie? Did he lie? Did he lie under oath? Did this key prosecution witness lie under oath? And I'm going to end this part and resume with him tomorrow morning. Did he lie? And when they try to tell you he's not important, Let's remember this man. This is the man who was off this case shortly after 2 o'clock in the morning, right after he got on it. This is the man who didn't want to be off this case. This is the man, when they're ringing the doorbell at Ashford, who goes for a walk, and he describes how he's strolling. Let me quote him for you. Here's what he says. I was just strolling along, looking at the house. Maybe I could see some movement inside. I was just walking while the other 3 detectives were down there. And that's when he walks down, and he's the one who says the Bronco was parked askew, and he sees some spot on the door. He makes all of the discoveries. It's got to be the big man, because he's had it in for O.J. because of his views since '85. This is the man. He's the guy who climbs over the fence. He's the guy who goes in and talks to Cato Kalin while the other detectives are talking to the family. He's the guy who's shining a light in Cato Kalin's eyes. He's the guy looking at shoes and looking for suspects. He's the guy who's doing these things. He's the guy who says, I don't tell anybody about the thumps on the wall. He's the guy who's off this case, who's supposedly there to help this man, our client, O.J. Simpson, who then goes out all by himself. All by himself. Now, if he's worried about bodies or suspects or whatever, doesn't even take out his gun. He goes around the side of the house, and lo and behold, he claims he finds this glove. And he says the glove is still moist and sticky. Now, under their theory, at 10:45, that glove is dropped. How many hours is that? It's now after 6 o'clock. So what is that, 7.5 hours? It's a testimony about drying time around here. There's no dew point that night. Why would it be moist and sticky? Unless he brought it over there and planted it there to try to make this case. And there is a Caucasian hair on that glove. This man cannot be trusted. He is central to the prosecution. And for them to say he's not important is untrue, and you will not fall for it. Because as guardians of justice here, we can't let it happen. We'll see you tomorrow. Thank you.
All right. Mr. Cochran, can you have it taken down, please?
Oh, sorry.
Thank you. All right, ladies and gentlemen, we're going to conclude our evening session at this time. Please remember all my admonitions to you. Do not discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. We'll stand in recess until 9 a.m. tomorrow morning. All right, thank you, counsel. We're in recess.